Good morning, everyone. Welcome back to day 4. I declare open this hearing of the Senate Legal and Constitutional Affairs Legislation Committee for Budget Estimates 2026-27. I'd like to begin by acknowledging the traditional custodians of the lands on which we meet today, and I pay my respects to their ancestors and elders past and present. I extend this respect to all Aboriginal and Torres Strait Islander peoples and their cultural and spiritual connections to Australia's lands and waters. On behalf of the committee, I welcome any traditional owners that are here today. The Senate has referred to the committee the particulars of proposed expenditure for 2026-27 for the portfolios of Home Affairs and Attorney General and other related documents. These are budget estimates proceedings, and the outcomes to be heard during today's proceedings estimates for the Home Affairs portfolio. The committee has set Friday, 5 June 2026 as a date by which written questions on notice should be provided to the Secretariat. The committee has also decided that answers to questions on notice should be returned to the Secretariat by 5 p.m. on Friday, 17 July 2026. Under Standing Order 26, the committee must take all evidence in public session. This includes answers to questions on notice. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to a committee. Officers and senators are familiar with the rules of the Senate governing estimates hearings. If you need assistance, the Secretariat has copies of the rules. The Senate has endorsed the following test of relevance of questions at estimates hearings. Any questions going to the operations or financial positions of the departments and agencies which are seeking funds in the estimates are relevant questions for the purpose of estimates hearings. I remind officers that the Senate has resolved that there are no areas in connection with the expenditure of public funds where any person has a discretion to withhold details or explanations from the Parliament or its committees unless the Parliament has expressly provided otherwise. The Senate has also resolved that an officer of a department of the Commonwealth shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to a superior officer or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. I particularly draw attention of witnesses to an order of the Senate of 13 May 2009 specifying the process by which a claim of public interest immunity should be raised. Witnesses are specifically reminded that a statement that information or a document is confidential or consists of advice to government is not a statement that meets the requirements of the 2009 order. Instead, witnesses are required to provide some specific indication of the harm to public interest that could result from the disclosure of the information or the document. I remind senators of their obligations under the Behaviour Code for Australian parliamentarians to treat witnesses with dignity, courtesy, fairness and respect. As Chair, I'll be particularly vigilant in ensuring cultural safety for First Nations people and culturally and racially marginalised groups during these proceedings. Officers called upon for the first time to answer a question should state their full name and their position for the Hansard record, and witnesses should speak clearly into the microphones. The committee's proceedings today will begin with the Department of Home Affairs. Outcome 3. I now welcome Senator the Honourable Murray Watt, representing the Minister for Home Affairs. I also call officers from the Department of Home Affairs, including Australian Border Force and Illicit Tobacco and E-Cigarette Commissioner, for Outcome 3. Minister, would you like to make an opening statement?
No, thanks, Chair.
Ms Foster, would you like to make an opening statement?
No, thank you, Chair.
Excellent. Commissioner, would you like to make an opening statement?
Thank you, Chair. Yes, I would. And I do appreciate the opportunity. Good morning. It's wonderful to be with you this morning. I wanted to give you a sense of the trends of what's happening on our border. So around the world, we have seen an upward trend in the consumption of illegal drugs. Between July 2025 and March this year, we have detected 14 tonnes of major illicit drugs. Notably, we're seeing an increase in two particular drugs, cocaine and ketamine. Cocaine seized at the border has increased by 23% compared to the same time last year. This is in addition to the 20 tonnes of cocaine detected offshore while being trafficked via the Pacific Maritime Highway, likely destined for Australia and New Zealand. Ketamine a fast-acting dissociative anaesthetic used legally in human and veterinary medicine, is rapidly emerging as a serious drug of concern. 1,907 kilograms of ketamine has been detected at the border, compared to 537 kilograms in the same period in 2025. This is an increase of 255%. Our people have worked tirelessly to keep these drugs off the street, resulting in $33 billion worth of estimated drug harm reduction in the Australian community. We've seen an alarming increase in the number of individuals attempting to bring child abuse material into the country. This reporting period alone, we have detected 122 individuals with child abuse material across 226 devices. This is an increase from the 102 people we found in the last financial year. The detections from this reporting period have resulted in 54 arrests and 30 instances where a child at risk in Australia has been identified or removed from further harm because of the information located on devices examined at the border. Our efforts to dismantle the illicit tobacco business model have continued. Between December of last year to March this year, the Australian Border Force stood up a campaign print wall to target illicit tobacco pre the border, at the border and post the border. Over the duration of the campaign, 998.5 tonnes of illicit tobacco were detected and over 4 million vapes. Border Force officers have detected over this financial year to the end of March $3.5 billion that would have been evaded through the tobacco excise duty tax at a time when projected revenue from tobacco excise is being diminished. We're working tirelessly to ensure those that are trying to circumvent this regulation will be stopped. International foreign fishers are hearing the message: if you enter Australian waters to fish illegally, you will be detected and you will be intercepted, losing your equipment, your boat and your freedom. The number of incursions into Australian waters this financial year to the end of March has decreased by 35%. Our total interdictions for this reporting period sit at 100, with 45 vessels disposed and 160 individuals prosecuted. Operation Broadstaff, which was stood up in February, has increased our detections in the Taurus, leading to the destruction of 9 foreign fishing vessels to the end of March. Now, despite geopolitical conflict and the impact on travel cost, we are still welcoming a record high number of passenger arrivals. Across the year to date, 18 million passengers arrived via sea and air travel, an increase of 1.2 million passengers from the previous financial year. Now, behind all of these figures that I've mentioned this morning are real people delivering outcomes every day with dedication and professionalism, and these efforts are a credit to all who serve in the Australian Border Force to protect our nation. Thank you, Chair.
Thank you, Commissioner. We'll proceed to questions and go to Senator Duniam.
Thanks, Chair, and thanks, Commissioner, for coming along. Minister, I wanted to start with you. Who won last night?
Well, some might say the referee.
Where was the referee from is the real question.
I believe he's from New South Wales.
Well,
I can't even say rugby league won the game or won the night.
My commiserations to you. But moving to matters before...
Thank you for finishing early last night. It did give me an opportunity to watch the final 25 minutes in which Queensland lost. So I appreciate that very much.
Yeah, well, I wanted to give you an outlet this morning, and I think we've now done that. So we'll go to the matters before the committee. I wanted to go, Commissioner, if I could, to the outcome of the tender CN42016661, the aerial surveillance tender. So that has been finalised, and I just wanted to go to the outcome of that tender. What is the outcome of that tender?
Certainly, Senator.
Good morning, Senator. Jared Howard, Deputy Commissioner, the Australian Border Force. The outcome of that tender was a contract executed and awarded to Maitreya after a competitive procurement process.
Okay, and what's the value of that contract?
The value of the contract is $4.319 billion GST inclusive.
4.319 billion. And so that goes beyond... Well, can you tell me the scope of that contract, the work that is covered under what has been contracted for?
Yes, Senator. So the contract will deliver a range of services around targeted aerial surveillance by both day and night across the maritime domain. So surveillance assets under that service will identify, detect and classify civil maritime security threats within the Australian exclusive economic zone. It'll provide aerial surveillance around the whole of Australia, including the coastal watch areas from Broome to Cairns and the Indian Ocean territories. It'll conduct mission and flight planning activities, the transfer of mission critical information between users, including our operations centre, and contribution of domain awareness data across our common operating picture. It'll also provision post-mission reports on completion of aerial surveillance missions, the ongoing development of technology and surveillance systems, and the infrastructure and crew around the provisions of those services.
So just to be clear though, I'm looking here at the Oz tender contract notice view, CN 4201661, which refers to a $190 million contract, not the $4 billion contract. So are we talking about different ones here? This says Skytraders, you said Maitreya.
Sorry, Senator, that is a separate contract. So the Skytraders $190 million contract was awarded for surge surveillance activities in the Indian Ocean Territory. My apologies, Senator.
So that's to Skytraders, and that was awarded on what date?
The 31st of October of last year, I believe, Senator, but I'll just... 31st of October 2025.
Okay, and to Skytraders, how many aircraft capable of Indian Ocean Territory surveillance operations at the time of the awarding of the contract did Skytraders have?
Senator, I'm not. I'd have to take that question on notice. When we, as part of the tender process, Skytraders put forward a position with platforms. Those platforms were, from memory, were new platforms. So in the process of acquiring assets, particularly for our contract, and that was taken into account in the awarding and execution of that contract. But in relation to the broader capabilities of Skytraders and what their capabilities writ large are, I'd have to take that on notice.
So, and I ask that because obviously in order to be awarded the tender, and you sort of go to this when you talk about new platforms, do you mean types of technology or?
So in this instance, Senator, there are two aircraft that will be utilised under this contract that Skytraders are in the process of acquiring.
Even at today, they are?
So I think as of today, they will have the aircraft available to them now. So they're going through the processes to register and those sorts of things. So while we executed the contract in October, the first flights are not due to start until next month.
In the month of June?
That's correct, Senator. And the lead-in time has to do with them acquiring the new aircraft, and so all of that is taken into account as part of the transition in of that contract.
Okay, and so there is even though the successful tenderer, who was awarded the contract in October last year, and the contract only goes, as I can see here, to the 31st of December 2027, are there aircraft doing this surveillance now?
No, Senator.
So we've awarded a contract to a company that is acquiring the tools to do the job.
Yes, Senator.
And there is no one doing the job right now.
So there's no one under that contract doing the surveillance of the Indian Ocean territories at the moment. We have other capabilities across the Australian Border Force that are currently the operational commander can utilise. This is about surging in further capabilities to cover that particular geographical area.
Okay, well, we'll come back to the details of what's happening on the ground. So I did ask on the 11th of December last year, roughly 5 months ago, some questions on notice, and it was question on notice, portfolio question on notice number SED 25-129 in relation to this tender. It checked this morning before I came back, it remains unanswered. Is there a reason why, given the contract was awarded at the end of October last year, details around, or answers to a question asked on the 11th of December, so a month and a half later, remain unanswered?
Senator, I hesitate.
You're not
to
going to
say
take
this,
on
but I'd have to, without having the question in front of me, I'd have the documentation in front of me. I'd have to take it on notes.
Senator, could you give me that number again?
Yes, it's SED 25-129. And so we've had a set of estimates between then and now, and there was no answer at the last estimates, no answer to the question on notice. And we're here now at budget estimates, nearly half a year after the question was asked, and not only do we not have the answer, we don't have a reason why the answer wasn't given.
Senator, as I said, I'm very happy to look into it. I just don't have it in front of me. I will attempt to come back to you as quickly as possible, but I'm not 100% sure. I have to look into it.
You'll
Senator,
forgive me for being... Sorry, Secretary.
I'm chasing it down now, Senator.
Okay, yes, but you'll forgive me for being a little concerned about taking on notice the answer to a question which relates to an unanswered question on notice, which is not a small one. We're talking about a $190 million contract here for a company that didn't have planes for a contract that's already underway.
Yeah, Senator, I suppose the only thing that I would say with that is that obviously business areas answer questions on notice, but we're not the only part of the process, which is part of the reason why I would need to look at the whole arrangements that we put in place in relation to answering questions on notice. I'm not sure where that particular question is at, but very happy to take it on notice.
Good. Well, as the Secretary's indicated, she will lend her efforts to getting us an answer to that. And given we're here for a while, hopefully we'll have some clarity around that before you leave today. The tasking order for this contract states, and I quote, "Full service delivery is to commence within 90 days of the execution of an official order or by a date otherwise agreed between the contractor and the department." So I'm just wondering, was that part of the tasking order complied with? Have they commenced flights? I mean, they don't have the aircraft, as you say, to do so, and so what's happened there? Has there been a variation to what was agreed to or what was required in the tasking order?
So, Senator, the contractor complied with the last part of that element, as in there was a date agreed between both parties in relation to when those flights would start. That was originally, from memory, set for May. There has been a slight delay in relation to the registration of aircraft. I think that was about 3 or 4 weeks from memory. So it will mean that the services will begin in June.
So what date was originally set for compliance with whatever agreement?
It was May, Senator, but I'd have to take the exact date on notice.
Yes, please. And so the exact date now in the month of June for compliance?
Let me take that on notice as well, Senator. The exact dates. I don't have that with me.
Senator
Right.
Duniam, can I share the call?
Yes, of course.
While you're pondering questions on notice, I will use this opportunity to rotate the call to Senator Shoebridge.
Oh, thanks very much, Chair. Well, we may as well stay on air charter. So the SkyTrader contract, the $191 million contract, AusTender describes it as being mail and cargo transport.
So, Senator, that was the panel in which we utilised to access that particular procurement was a defence panel that is predominantly used for mail and cargo transport. It's not the only purpose of that panel. You can also access surveillance services from that panel. We, in selecting the right procurement process under the CPRs, we confirmed with the panel owner that we could access a surveillance type service through that panel, and it was confirmed that we could. So the contract that we are referring to is a surveillance contract. It's not a transport or a cargo contract.
No, but AusTender's not meant to be describing the nature of the panel that does it. AusTender's meant to be describing the nature of the contract.
AusTender will...
Category here, mail and cargo transport.
Yeah, so Senator, that's the category of the panel. It's not the... So that when you are uploading onto AusTender, there are certain mandatory things that you've got to fill out. That particular panel is categorised that way.
All right. So even though it's described as mail and cargo transport, it's actually for surveillance. Is that right?
That's correct, Senator. And there are a number of other types of services that you can access that panel for. In this instance, we accessed it for a surveillance
And
service.
that's a defence panel, is it?
It's a defence panel, Senator.
So is it populated by defence members of the ADF, members of the defence department? Who populates the panel?
Well, so the panel itself is, for want of a better term, Senator, is owned by Defence. But as you may be aware, when the Commonwealth set up open panel arrangements, then other agencies can access those panels. So while the panel's owned by Defence, and I'm not 100% sure the exact compilation of who and how in Defence they've pulled that together, but in order for us to quicken the procurement process, we're able to access that panel through an open tender arrangements.
Yeah, I'm not criticising you for using the panel. I'm just trying to work out who's on the panel.
So there, I'd have to take on notice the companies that are on the panel.
Sorry, no. Who's on? So that's who's on? So it's you choose from a bunch of pre-selected contractors that have been put together by Defence. Is that right?
Yeah. So when the panel is set up, it'll be an open tender process to set the panel up, and then there will be contractors or companies that are sitting on that panel, and then people can go and then select from those companies who they're going to.
All right. So I understand Defence got the list together, which is the panel, right? After a tender process. Then how did Home Affairs choose SkyTrader from the panel? Was that a decision of Defence, or was it a decision of Home Affairs?
No, that would have been our decision, Senator, to choose what companies we went out to.
So why was SkyTrader chosen, particularly given they didn't have any planes that could do the work?
So we went out... We submitted an EOI to the whole of the panel, so it was 13 organisations, 13 companies, of which 3 responded, and of those 3, through our process, we selected SkyTraders as the successful contractor.
Right. Was that because it provided the greatest value for money?
It would have... That company was chosen based on the expressions of interest and assessing not only value for money but capability and all of the other things that we're required to assess under the CPRs.
Well, SkyTrader gets a vast amount of Home Affairs contracts. In fact, this $191 million contract to SkyTrader is on top of more than $300 million that SkyTrader has received from Home Affairs in contracts over the last decade. They seem to get an extraordinarily large amount of the pie. given that there are like 13 or there's more than 13 alternates on the panel. Can you explain why SkyTrader just keeps getting so much of the pie?
Well, Senator, what I can say is that this procurement in which I was involved as the delegate, went through the appropriate procurement process that we're required to under legislation, and SkyTraders was the successful tenderer.
Well, could you provide on notice to this committee the assessment documents and the criteria, and if there was a report written, the report that was written?
I'll take it on notice, Senator.
Yeah. And if for some reason there's a difficulty in providing the documents, can you provide on notice the most detailed explanation, including who the entities were who gave an expression of interest?
Senator, I'll take that on notice, and we'll provide as much information as we can, noting the commercial arrangements and those sorts of things. But I take the intent and I'll take it on notice.
Was there any direct engagement between Home Affairs and the former Chief of Army, Lieutenant General Kenneth Gillespie, who is now a non-executive director of SkyTraders? Was there any contact between Home Affairs and the former Chief of Army in his role with SkyTraders?
Not that I'm aware of, Senator.
Was there any connections between Home Affairs and former Chief of Army Gillespie when he was in a role with Canstruct? He had a role with Canstruct as well?
Not that I'm aware of, Senator.
Could you take on notice? You may not be aware, but could you ask the department to see if there's any records of contacts, connections between Border Force or Home Affairs or whoever in the agencies undertook negotiations or consideration of the SkyTrader contract, if there was any contact with the former Chief of Army?
I can take that on notice, Senator, but I will say, for this particular contract, I was the delegate, I was the decision maker, and I had no contact with Mr. Gillespie.
And can you also review whether or not there was any contact between the former Chief of Army and Border Force? And I might ask the Secretary to do it on behalf of Home Affairs in the consideration of Canstruct's contracts?
We'll certainly do that, Senator. As Mr Howard said, I too am unaware of any contact with the former Chief of Army.
I'm still trying to work out how SkyTrader got a $191 million contract to deliver a service that they didn't own the planes for.
Senator,
that seems, I mean, just from a cold start, that seems a remarkable proposition. And they still don't have the planes, even as we're here today, they still don't have the planes.
They now do have the planes, Senator, and it is not uncommon in these types of contracts for a company to bid knowing they are going to procure the asset as part of the process, particularly because it gives in our case, it gives the Border Force a very contemporary and capable platform if it's acquired new versus an older platform. So that all gets taken into account as part of the tender process and the assessment of the procurement.
Well, we'll have a look at the documents. I'm now going to ask you about the $104 million contract signed with Adigold Aviation Proprietary Limited for passenger air transportation. Are you aware of that contract?
I am not, Senator, but there may very well be others that are. It's not...
Now, of course, I don't think Adigold has any planes. I could be wrong.
The other thing to consider, Senator, and Deputy Commissioner Nicholson will talk to the Anagold situation, but certainly with SkyTraders, the other thing that companies will do is subcontract. And so whilst Sky Traders in this instance might not have the platforms themselves. They may very well subcontract to a company that does have platforms. So, each individual procurement is assessed on its merits, but it's also not uncommon in these types of procurements for many subcontractors to be used with different platforms.
Well, are there subcontracts to the Sky Trader contract?
Yes, Senator.
Who are they with?
Maitreya in this instance.
How do you spell that?
Metrea.
And who is Maitreya?
Maitreya is a global company that specialises in intelligence, surveillance and reconnaissance.
All right. And so Sky Trader, the contract's with Sky Trader, but the work has been done by Maitreya, is that right?
Well, so the contract is with Sky Traders, who they use various different subcontracts for various things. So it might be for assets, it might be for logistics. It once again it depends on the individual.
Well, this is an air surveillance contract. Who's doing the actual air surveillance?
So my understanding, Senator, is Maitreya is being utilised by Sky Traders for the platform side of this particular contract.
And where is Maitreya based?
I might take that on notice, Senator. This particular contract is going to be based out of WA up in Learmonth. That's where the aircraft will be based.
Yeah.
But the actual company, I have to take on notice.
All right. And I assume you review the subcontracts when you're offering a tender.
Yes, Senator.
And you would have had due diligence about Maitreya.
Yes, Senator.
Can you provide on notice what due diligence you did on Maitreya?
Yes, Senator. Yep.
All right, thank you. Are there any further subcontracts from Maitreya down?
Not that I'm aware of, Senator, but I'm happy to take that on notice just to double check. Addergold
Aviation, the $104 million contract that was executed on the 31st of October 2025. Again, it's headed mail and cargo transport in the category, but again it is headed passenger air transportation, and the description is air transport services. What's that contract for?
Good morning, Senator. Sarah Nicholson here, Acting Deputy Commissioner for Regional Operations. The contract for Addergold, valued at $104,279,916, including GST, is for, there's two service lines within that contract. One is a dedicated aircraft that meets the ABF's operational requirements, they being the movement of our maritime crew to ports to aboard their vessels to undertake patrols. Another service line within that dedicated aircraft is the movement of cargo to support operations from a detention perspective, and also move detainees across our network to support the safety and security arrangements as required, and also removal operations.
All right. You said there are two aspects.
Yeah, and the second service line is a brokerage service, whereby that's where Addergold would use a subcontracting arrangement to utilise aircraft on an ad hoc basis.
All right. And the first element, is that a 737 aircraft?
I believe so, sir.
All right. And who operates that aircraft?
That particular aircraft, I'd have to take that on notice.
Is it Nauru Air Corporation?
I'd have to take that on notice, whether it's the dedicated service line or the brokerage service, but we do utilise
you described them as two separate. You first of all said you've got this dedicated service line, you've got this plane that's, I assume, sitting ready to go 24 hours a day, 7 days a week. Is that right?
Correct.
And that's the 737.
I believe so.
If we were to go onto the airport, if we were to walk on, is it based in Brisbane? Where's it based?
I'd have to confirm that, sir.
What would be painted on the tail? Would it be Nauru Airlines?
Yes, Senator.
Yeah, so it's a Nauru Air Corporation aircraft, isn't it?
To my understanding.
Yeah, well, that's what I asked you earlier.
I'm just
So I'm just needing to clarify which one of the service lines we use the dedicated Nauru aircraft.
Well,
I'm pretty sure.
You know the 737 has got a big Nauru Airlines thing painted on it. It's a Nauru Airlines aircraft, right?
Correct.
And does Addergold contract directly with Nauru Airlines, or does it go through some kind of corporate feeding chain to get to Nauru Air Corporation?
I don't have those details with me, Senator. I'll need to take that on notice.
All right. Well, it's my understanding that they subcontract to Aergo, A-E-R-G-O. Does that ring a bell, Aergo?
No, Senator.
Who's responsible for this contract?
That would be myself, sir.
Who sat on the... Did you also acquire this contract through the defence panel, or was this a separate tender?
We approached the market on the 6th of January in 2025. The tender closed on the 31st of January. We had 6 tenderers, of which we assessed 5 as 1 withdrew their tender.
All right. Were you in charge of that tender process?
I was the delegate on the tender.
Well, I'm asking you questions about a $104 million contract that you were the delegate on, and I'm asking if there was a First of all, I asked you whether or not Nauru Air Corporation ran the plane, and we eventually found out it did. Now I'm asking you about that same $104 million contract that you were the delegate on that was signed less than 12 months ago. Was there a subcontract through a corporation called Aergo?
I've just been advised, yes, Senator, there was.
Did you do due diligence? Mr Howard tells me he did due diligence on subcontracts when he was the delegate for a $191 million contract. Did you do due diligence on the subcontracts when you were the delegate for this $104 million contract?
Yes, Senator. The Commonwealth procurement guidelines were strictly followed. There was governance structure put in place, and both due diligence and value for money and risk assessments were undertaken across all of the 5 tenders that we received.
All right. Well, did you look at the related party connections between Aergo and Nauru Airlines? Did you look at the web of corporate connections between Aergo and Nauru Air Corporation? Did you see they weren't third parties, that they were connected? Was that part of your due diligence?
I'd have to take that on notice, sir.
Did you see in particular, did you look at another corporation called Pacific Wings, which is a subsidiary of Nauru Airlines, and did you see the common directors and shareholding between Aergo and Nauru Air Corporation when you did your due diligence?
I'd have to take that on notice.
Surely if you've got subcontractors who are each taking a cut along the way, one of the critical things you want to look at is that they were independent and that they weren't related party entities. Surely that's part of looking at a subcontracting chain, isn't it? So the Commonwealth isn't getting doubly grifted on the way through a contract. Did you look at that?
So, Senator, Ms Nicholson would have had advice from experts. Let us take that on notice, and we'll go back and see if we can get you the answers to those questions.
One final question.
Will you provide on notice your assessment of this contract, what assessment you did of the subcontractors, and if there was a report recommending it, will you provide on notice to this committee that report?
We can do so, subject to any commercial concerns.
And why a 737 aircraft? How often is the 737 aircraft, which is an incredibly expensive asset to keep on 24-hour notice, how often is it even close to full? How often does it have more than like 1 or 2 passengers on it, or a handful of cargo? Why an incredibly expensive asset like a 737? Why was that chosen?
The ability to be able to move our marine workforce and rebalance our detention network is of key operational requirements for us.
Well, will you provide on notice the number of passengers that have been on the 737 aircraft since the contract was signed for each of the flights? And we also provide on notice what the passenger capacity for the 737 aircraft is, please.
Thank you, Senator Shoebridge. I'm going to take this opportunity to rotate the call. Senator Duniam.
Thanks, Chair. I understand back to the tender CN 42016661 relating to, that was awarded to Sky Traders. The tasking order also said that the successful tenderer should have short-term turnkey capability. I mean, given the contract was awarded 6 months ago and we still don't have the tools or platforms to undertake the work that's been contracted for, do we still fit within that short-term turnkey capability definition?
I am very confident, Senator, that when we assessed the procurement, that Sky Traders was the best option available to us, and we will get the capability that we required under that contract.
Has money been paid to Sky Traders under this contract? Because it's for, what, 2 years and 2 months, October 25 to December 27. You know, that's a 2 and a bit year period. How are payments made through that period of time?
I'll take the question on notice, Senator. My understanding is that we have not yet made a payment to Sky Traders because of that slight delay that I spoke about earlier. But in order to answer your question wholesomely and just confirm, I'll take it on notice.
Okay, yeah, I've just been given, well, it's effectively $100 million a year, and we're 6 months in, half a year in. So
yeah, and so Senator, the way that these contracts are generally set up is there will be some like an amount paid at the beginning as sort of to cover sort of setup costs and transition in arrangements and those sorts of things. So from memory, the payment at the beginning of the contract is larger than sort of then it sort of gets staged through. But I can't remember the exact numbers, so I'll take it on notice and get back to you.
And just related to that, are there any penalties for not being able to complete or commence in a timely fashion?
Let me take that on notice as well, Senator. We absolutely generally have those types of penalties in contracts. I just, for this, because we're working through a few contracts at the moment, I just don't want to make sure that I've got the right, in my mind, the right information. So I'll take it on notice so that we provide the right information to you.
And again, given it is only effectively a 2-year contract at $200 million, is and we're 6 months into the period almost, is the overall amount to be expended going to be reduced in any way? With 18 months to go on a 2-year contract?
My understanding, Senator, is that is most likely the case because we're starting a bit later than what we were expecting to, but it will depend on how the contract gives us the ability to surge more hours and those sorts of things. I'll take that element on notice as well, Senator, just to confirm for you, but I think that is most likely the case.
Sure. What surge capability do we have right now for the Indian Ocean Territory?
From an aerial surveillance perspective, so we can utilise the current aerial surveillance contract to surveil the areas out to Indian Ocean territories. The reason why we can do that now, but there are some safety requirements that require particular aircraft types to have access to infrastructure, particularly runways and the like, in cases of emergency. We are not going to have access to the same infrastructure because of some upgrades that will be occurring around that area. And so part of the reason that we've gone for this particular contract with Sky Traders is because it will give us larger aircraft that create redundancy so that we don't need to access that particular infrastructure. That is of the reason why that's important is and the impact for Sky Traders and for us from a capability perspective is not being felt at the moment because the infrastructure upgrades have been delayed, and so therefore we can still use the current capabilities that we have, but we won't be able to use those capabilities in the near future. And so that's the reason why we had to go for a surge contract. That's why it's a short period of time, just to be able to give us larger aircraft to cover that particular area.
So we can use the existing provider. Are they still under contract?
They are, Senator.
Okay. When does that contract conclude?
31st of December 2027.
Okay. All right.
And then there's a transition out period, a 6-month transition out period after that, but the contract concludes on the 31st of December.
Right. And just to the other tools that Border Force can deploy in the Indian Ocean Territory, what else is done there to monitor that part of the world?
Senator, so we have some surveillance capabilities. We've got some, patrol boat, like those types of capabilities. I'm reluctant to go into details around exactly what our capabilities are from an operational security perspective.
Senator, I'll ask the Command of Maritime Border Command to provide you just with a sense of what we're doing in the Indian Ocean, and I welcome Rear Admiral Brett Sonta to the table.
Senator, Rear Admiral Brett Sonta, the Commander of Maritime Border Command and the Commander of Joint Agency Task Force Operations Sovereign Borders. Just to answer your question, as you know, as DC Howard said, current capability for the ABF can reach there. And as you would be aware, we also have ADF capability that can reach there in both terms of aerial surveillance and response.
Mm-hmm. So the ABF is confident that we're still covering the area well?
As the operational commander, I am confident, Senator.
And also, Senator, as the Commissioner of the Australian Border Force, I'm confident as well.
Excellent. So just to something I'm less confident in, have we got that update on the unanswered question on notice yet?
Yes, we have, Senator. There was some back and forth trying to establish whether or not the information had any commercial in confidence. It was only provided to the Minister's Office this month, and they have just prioritised its clearance, and it will be with you.
So it took us 5 months to figure out if there was commercial in confidence information that
Senator,
could be redacted or...
sometimes questions on notice get an answer, they go straight through the system. When there's a question about them and they get sent back and forth, that can create extra time. I will also note that it was from the December estimates. The organisation was somewhat distracted in the December, January, February period.
We all were.
So we make every effort, as you know, to get the questions on notice done in a timely fashion, and we have pulled this one out to make sure that it is getting to you.
Excellent. I appreciate that. So just following on from some questions that Senator Shoebridge asked around subcontracting, with regard to in particular the tender we've been talking about, 42016661, and the use of the, or subcontracting of the, to the US firm Matria. Does Matria hold an air operator certificate in Australia?
I'd have to take on notice the exact details, Senator. They if they don't, then they will be in the process of acquiring that. But because of how close we are to operating under the Sky Traders contract, I suspect they do, but I'll take on notice to confirm.
So is this, so I'm just trying to get a very basic understanding. The contract went to a company that didn't have aircraft with a subcontractor that didn't have an air operator certificate in this country, but the commitment was that they'd have it by a point in time, which they've missed and has been extended to June.
Senator, Sky Traders is an Australian company that has many aircraft. They just didn't have the aircraft they were going to use for this particular contract because they wanted to offer us the most contemporary platform that they could, and they were going through the process with their subcontractor to acquire that. But Sky Traders, they run the Victoria Police Rotary arm. They have had aerial contracts with CSIRO. CSIRO and the Australian Antarctic Division. They're not a new company in relation to being able to provide these types of services. Maitreya doesn't have a significant Australian presence, but has very significant experience working with Coast Guard-like and defence-like organisations around the globe doing these similar sorts of activities. So we base our assessment under the Commonwealth procurement rules based on them being able to do those services at a point in time, and that might mean they have to get particular platforms or they might have to get particular licences. As long as they can meet those requirements and we assess their ability, or our assessment of their ability to get those as part of the procurement process, then that all gets taken into account when we're awarding the contract.
So you've taken on notice whether they currently hold an air operator certificate, and you were, I can't recall, whether you were going to take on notice whether they have procured the aircraft to actually undertake the work required under the contract. And I suppose aligned to that, do you know whether they've registered any aircraft in Australia yet for this contract?
So I know, Senator, the reason why we granted the slight delay was because they were going through the registration process and it was just taking a little bit longer than expected. So if they haven't, they are in the process of doing so.
And are there any other subcontractors related to this contract that SkyTraders are working with?
I might take that on notice as well. So sometimes that there are logistics and other subcontractors. Maitreya is the only one that's in my mind, but just to confirm, I'll take that on notice.
Okay. Let's go back to the tender I think we were talking about earlier on, which the larger one, the 4.3 billion, CN 4239669. So to Maitreya as well, to undertake a range of services. Were any of those ones that would require the operation of aircraft?
Yes, Senator.
So just on that, so they don't have an air operator certificate, or didn't, at the time of the issuing of this contract of 4.3 billion?
I'd have to double check to see whether or not they did or not at that particular point in time. We executed this on the 31st of October 2026. Yeah, sorry.
You are well ahead of
No. Too many contracts in my head, Senator.
Yes.
So the larger contract for the future aerial surveillance we executed on the 30th of April of this year. So they had progressed in their sort of operating within Australia based on subcontracting with SkyTraders. But as part of as I mentioned before, as part of doing our checks under evaluating the procurement process, we will have made assessments based on their ability to get the relevant licences if they don't already have them. So it doesn't preclude them from being granted a contract just because they don't have something at the moment, if we're assessing that they can get the relevant regulatory steps.
Just back to SkyTraders for a moment. Have they ever operated maritime surveillance services before?
They have
for you?
I don't. For us, I'm not aware, Senator. I don't think so. I know that they have done, things for the Australian Antarctic Division and CSIRO, and so I'm not sure whether they were surveillance type. I'd have to take that on notice just to confirm.
If you could. At the time of the issuing of the IoT contract, to which Maitreya is a subcontractor, how many staff or people were there in Australia attached to that organisation?
Attached to Maitreya?
To Maitreya.
I'd have to take that on notice, Senator.
Was there a requirement around staffing presence, how much of a footprint in this country does a company have, noting that Maitreya is a global company?
There will have been a requirement to deliver the services under the contract, which will need to be done here in Australia, and they will have, as part of the contract, that they're required to train and aircrew and the like. They're required to be based in particular locations and have flexibility to be able to move about in accordance to operational requirements. So if they didn't have, well, I would suspect that the amount of staff that they had at the time of the procurement and then awarding of the contract will be different to when they are up and running on the 1st of January 2028.
Okay. And I'm not sure what level of detail you can give us here, but with the requirements for this aerial surveillance contract, are you able to talk us through how many aircraft, what type of aircraft we're looking at, how many pilots, and the number of necessary flight hours, and where, in broad terms, the aircraft would be deployed to?
So I can talk to some of that, Senator.
Sure.
I'm slightly reluctant just to talk about locations at the moment, but that's only because...
To what extent you can?
Yeah, only because we're still just working with affected staff on what that looks like.
Sure.
In relation to the contract, it will provision 11 aircraft, mission systems, sensors and displays, and the associated aircrew and operational and maintenance support. So I don't have the exact numbers of people, but it's 11 aircraft. 2 of those are larger aircraft. So there will be some transition in arrangements, Senator, across 2028. So the aircraft types will change slightly, I suspect, although we're still working through the details of those.
Yes.
But towards the end of 2028, when they're operating at their full complement, I suspect that it'll be 3 Bombardier Global 6500 aircraft and 8 King Air B300 or equivalents.
Okay. Given the slippage in the former tender we were talking about, the $190 million tender, and I think, did you say that the services required under the $4.3 billion contract were to be deployed by the end of this year, 31 December?
No, Senator, the $4.3 billion contract is the 1st of January 2028 as a transition in.
2028, okay.
So they won't have all of their capabilities available as of the 1st of January. The way that the if you think about the future contract, this $4.3 billion and our current contract, the current contract ends on the 31st of December 2027, and then the current contractor has a transition out period of 6 months, and then we basically have a transition in period for the new contractor that the contract begins on the 1st of January 2028.
Okay, and are there milestones between here and the beginning of 2028 that Border Force will look at and make sure we don't end up in a situation where we get to that date and they say, sorry, the aircraft aren't ready, or whatever?
There are certainly milestones have a particular connotation under a contract, but there are certainly
whatever term. Yes,
so I would say that there are absolutely stages where we will be monitoring to make sure that they are ready to transition the capability, and we will be working very closely both with Maitreya as the future contractor and with Leidos as the current contractor to sort of work through what that transition period looks like.
Okay. So the submissions for the tender closed when? Oh, sure.
You've got 1 minute. Maybe after this.
That's fine.
So the contract was awarded following a 2-stage procurement process, Senator. The first stage was a request for expressions of interest, which went out in October 2023, and then the RFT went to 7 shortlisted companies that expressed interest in August of 24. I don't think that I have the exact date that closed.
Well, I think
That is
maybe between now and the next slot we might get that detail. Thanks.
Thank you, Senator Dunniam. Senator Shoebridge.
Oh, thanks, Chair. I had some questions about the the treatment that Australians had when they returned from the global Samud flotilla in the last week? Who's best to answer that?
Senator, are you referring to their arrival at the border?
Yes, their arrival at the border, their treatment as they came through. Their detention when they arrived, what happened to them on their arrival.
So, Senator, if it's a question of literally processing at the border, then obviously the Border Force can take those questions. I'm not sure that we've had any involvement with anything subsequent to the border.
Well, it is about what happened at the border. Why don't I ask this question? And I assume that Border Force has a role about what happens at the border. So there have been multiple reports that Australians who have returned from the Samud flotilla, as they went through the airport, were pulled aside by the Australian Border Force and had their devices, their phones taken off them, and then had their passwords taken. Are you aware of this?
Senator, I am not aware of that, but please go ahead.
Well, first of all, does Border Force have the power to take people's devices?
Yes, Senator, under the Customs Act, we do have the authority to download digital devices at the border.
All right. And on what basis do you exercise that authority? What's the criteria?
If there is a risk to the security of the nation.
All right. Well, what risk to the security of the nation would the returning members of a Samud flotilla, who have just been brutalised by the Israeli government, what risk do they have to the nation coming back to the country?
Senator, a decision is made by the officer at the border in relation to potential risks from people coming back, particularly from the Middle East. And that is most likely the determination they made to assure the nation that there was no risk associated with these individuals.
These are individuals who were assaulted, imprisoned, humiliated, attacked by the Israeli government, and they were coming home hoping for the protection of their own government, and your officers treated them as a risk and took their devices off them.
Senator, can I
How does this happen? They were coming home. They wanted to be welcomed home. How does this happen?
Senator, the Commissioner has not confirmed that anything happened at the border. You asked him, did they have the power to take devices, and he answered that question. I think we need to wait until he's been able to confirm what, if any, role Border Force played in their return in this regard.
Well, I know it happened because they've told me and I believe them. So I'm putting to the Commissioner the proposition of facts as I know them. Now, the Commissioner may want to take it on notice, and Secretary, it may be awkward for you that an agency in your department did this to Australians who are coming home hoping for protection.
That is not conceded.
It's not conceded.
Senator Shoebridge, I have been in this committee when allegations you have made based on information you claim to have about various officials has proved to be untrue. Can I suggest that before you start accusing people of things, we confirm whether what you've been told is true? It may be true, in which case, of course, there are questions that could be asked about that. But at this point, it has not been conceded that that occurred.
Your government has repeatedly, Minister...
I think Senator Shoebridge should withdraw his previous comment directed at the witness.
What comment?
I think your reflection
Your accusation.
I withdraw any reflection.
Yeah, thank you.
Minister, your government continues to refuse to believe the version of events given by Australians who have been brutalised by the Israeli government, assaulted, violated,
in what way
and
have
have
we done
repeatedly backed in.
In what way have I done that? Now you're just making accusations against me and the government. In what way have I done that?
Well, because...
I know you're aiming to get a story up, but you can't misrepresent what people are saying.
Well, because when you look at the statements made And admittedly, they were made by DFAT officials, and so this is not directed at Home Affairs, but made by DFAT officials, after the evidence came out from Australians about them being sexually assaulted, about them being punched, about them being put in strain positions. DFAT officials came out and made a statement to the effect that none of them required medical attention, that there was nothing to see here.
Well,
now that statement by DFAT.
Well, I don't think that DFAT would ever use words like "nothing to see here." That's the kind of words that the Greens political party uses, not the officials of the Australian government.
Can we just return to one person speaking at a time? And I would ask that we wait until the senator's actually asked a question. I know he's making long statements before he gets into asking his question, and I'd ask that we get to the question a bit quicker. Right. That would be helpful, please.
Well, why don't we go back to what Border Force's powers are? Border Force has the power to take devices from Australians, but only if they think they might be a security risk. Is that right? Or a risk to Australia's national security? Is that the basis upon which that power is exercised?
That's the basis.
All right. And then I am advised that once devices were removed from Australians returning from the Samud flotilla, they were taken by Border Force to another room out of their sight and weren't returned for 20 minutes. Would that be consistent with Border Force's practice in taking a device and then downloading the material on a device?
Yes, Senator.
What does Border Force then do with the material that's been downloaded?
The material is assessed to determine if there are any risks to the nation as a result of working through the information on that device.
Is that determined before the person is allowed to pass through the border? Is that a real-time determination, or is that what happens?
It really does depend on what is found on the device, Senator. So, for example, when we have concerns about an individual carrying child abuse material, if the officer immediately finds abuse material, then action is immediately taken at the border. In this particular circumstance, there may be an assessment that has to occur at a later date.
So what does Border Force then do with the material? Assume they've downloaded someone's device, that person has then been allowed into the country. Does Border Force ever delete that material?
So it depends on what is found, as the material found on the device may be used as evidence depending on what's found.
I accept if you find evidence of a crime, you'd obviously want to maintain the evidence and keep a chain of custody and retain the evidence. But in circumstances where no evidence of a crime has been found, what does Border Force do with the material that it's downloaded? In this case, on my understanding, from people who have returned after having been brutalised by the Israeli government.
Senator, I think we need to keep the questions to what Border Force can do. There is no established connection between that and the flotilla at the moment.
What does Border Force do with the evidence they download from people's devices in circumstances where they haven't found evidence of a crime? What do you do with the data?
There is no requirement to maintain that data.
Well, there may be no requirement to maintain it. Is there a requirement to delete it?
It will be deleted, Senator. If there's no requirement to maintain that data as evidence in an investigation or a prosecution, then it will not be retained.
Is there a policy to delete it?
Can I take that on notice for you, Senator?
All right. What software does Border Force use to assess the downloaded material?
Please go ahead, Senator.
Can you advise which platforms and which software platforms are used to download it? Not to download it and then to assess it.
Yeah, so to download and assess, I can take that on notice as well.
All right. And if there is a policy in place that deals with how the data is treated once it's been downloaded, Can you provide that policy?
I'll certainly take that on notice, Senator.
Yeah. And can you provide on notice your understanding of what happened to each of the Australians returning from the Samud flotilla? And they've been returning now over a period of about a month.
Yes, Senator.
All right. So just before I got one final question. When a device is taken and then returned, is it Border Force's policy to tell people what happened to their device? Is there an obligation to do that?
There is a notification to the individual that they are conducting that analysis of their digital device.
Is it a verbal statement? Is there a written form to advise people what's been happening, what's going to happen?
There would certainly be verbal notification. Whether there's an accompanying written notification, I'll take that on notice for you.
All right, thank you. I've got a series of questions about Secure Journey / MTC. Who's best to deal with that?
We're at the table.
All right. I want to give credit to some of the work done by the UWU and the Guardian in drawing attention to this, but you would have seen, Secretary, a series of very disturbing reports about security failures on the part of, we could call them MTC or Secure Journeys. It's the same entity. I'll call them MTC because it's simpler here, including more than a dozen escapes, people not receiving medical treatment, incredibly dangerous situations involving fires. Are you aware of those very real concerns about MTC's performance?
Senator, I have read the Guardian report and I have been working closely with the ABF in the management of the contract for immigration detention.
Mr Reynolds, are you aware of those reports?
I'm aware of that Guardian article, Senator. I think that came out on Monday. Is that correct? That's the one you're referring to?
Yes.
Yes, I am aware of that Guardian article.
Is it accurate?
I'm not going to pass judgment on a media article, Senator.
Okay. Well, has there been more than a dozen escapes from MTC-run facilities?
So the total number of escapes whilst Secure Journeys have been the contracted service provider would be 12.
How many?
12.
Okay, so a dozen escapes. Is that consistent with the contract? You expect a dozen escapes?
No, Senator.
Well, so what have you done, given that I assume it's a contract breach, letting people escape, is it?
Yes, it is, Senator.
Okay, and was it 12 separate escapes?
Yes, Senator. 12 separate events.
Over what period of time?
So that would be since the commencement of Secure Journeys taking over the contract for the immigration detention network. Would be from May of last year.
So one a month, basically. That's their record. They have one a month, and they're meant to have none. Is that right?
Senator, they're meant to have none.
Yeah. What have you done?
So under the performance management framework, there is a charge event for an escape, and that's a failure to maintain immigration detention for all detainees. And Secure Journeys have been charged with those charge events for those 12 incidents.
Is that an abatement or a charge? Is that the same thing?
Same thing.
Okay, so what do they have to pay when they let someone escape?
So, Senator, I have received legal advice that because of the commercial in confidence nature of the contract, I cannot publicly discuss the quanta of that charge event.
Sorry, how on earth would that cause anything other than perhaps embarrassment to Home Affairs because it's so small, or embarrassment to Secure Journeys because it's so large? Where is the commercial interest you're protecting here? You can't tell us how much Secure Journeys have to pay as a penalty when they let the first person escape, the second, the third, the fourth, the fifth, the sixth, the seventh, the eighth, the ninth, the 10th, the 11th, 12th person escape. You can't tell us. Is that what you're telling me?
Senator, that's the legal advice.
Well, I'm going to
I've
press for an
received.
answer. How much has Secure Journeys paid for each of those 12 escapes as penalties, abatements or charges under the contract?
Senator, I'll take it on notice.
All right. Do you know how much?
I do.
Well, then you can't take it on notice.
No, Senator, I have received legal advice.
Well, if the minister...
Let him finish. Let him finish the answer.
If the minister wants to take a public interest immunity claim on
Okay,
your
just
behalf,
talk over the top of people. You should let the official
That's the process
finish
to go
his
through, and
answer.
it'll be much quicker, Mr Reynolds.
Senator, I'm happy to take it on notice for you. I will seek legal advice, and if required, I will seek a public interest immunity claim from the minister.
Well, you see, you know it now, and so I'm asking for it now.
And he's explained why he's not providing it to you now.
But that is...
For entirely legitimate
He
reasons.
has to take a public interest immunity claim. That's how it works.
It has been, officials at the table and here before have taken questions on notice to see what they are able to provide and to see whether a public interest immunity claim is something that they need to do. That is what the Commissioner has said that he is going to do. That is not out of the ordinary of what other people have done in this estimates.
Well, it may not be out of the ordinary with what other people have done, but if you remember your opening made it clear that officials have to provide the evidence that they know. If they do not, and Commissioner has said that he knows the figure, he actually sitting there knowing the figure. If he's obliged to provide the answers unless a public interest immunity claim is being taken.
It is...
Now,
Point of order, Chair.
Sorry, maybe just let Senator Shivers finish and then we can come to you, Senator.
Is a public interest immunity claim being taken? In which case, we'll go through the process.
Chair, as you have already pointed out, it is entirely within the standing orders and standard practice for witnesses to take a question on notice so that they can determine whether then a PII claim needs to be taken.
Yes, I agree. Minister?
We will address this at a different point. This repeated situation where we have witnesses sitting there who know information and because it's for one reason or another, and in this case it's said to be legal professional privilege, which is not a basis to overcome parliamentary privilege, are refusing to give the evidence in estimates. It is degrading the utility of estimates. But I'll move on.
I think you should, through you, Chair, you are again impugning the witness. You've had an explanation. It is standard practice for a very long period of time on this committee. So I ask that you withdraw that comment.
No, I'm not. It's degrading. This process is degrading the utility of estimates. Commissioner Reynolds has said the basis upon which he's seeking not to do it. It's not his job to enforce the rules of the parliament. It's our collective job, and we're failing to do it.
Well, you're entitled to change the standing orders if you wish.
It's in accordance with the standing orders.
I would suggest that officials at the table being asking to take questions on notice is entirely within the rules, and doing that to enable them to consider whether a public interest immunity claim is required is also within the rules. Senator Shoebridge, you've got about 2 minutes before I'm rotating the call.
Are you aware, Commissioner Reynolds, of the Comcare notices that have been issued to the department in relation to multiple breaches, work health safety breaches from Secure Journeys and Home Affairs?
Yes, Senator.
Are you aware of the one that was issued in relation to the fire at the Villawood Immigration Detention Centre?
Yes, Senator.
Yeah, which says in part about a fire on the 23rd of September 2025. It says, the response to the fire incident on 23rd September 2025 at the Latrobe compound revealed that workers attempted to gain access to a burning room without appropriate respiratory protection. The lack of preparedness significantly increased the risk to both staff and detainees, with 2 staff members requiring hospitalisation due to smoke inhalation. Although staff were advised to wait for firefighters to arrive on site, however, in this instance, a detainee was locked inside the room. The firefighters arrived on site approximately 20 minutes after the initial call. Commissioner, because of the failures, a detainee almost burnt to death or was killed in a fire, and staff rushed to try and provide assistance without adequate training and without respirators. How does this happen on your watch?
So, Senator, the detainee locked themselves in that room and started the fire. But more to your point, which is I have concerns for the staff when it comes to detainees lighting fires and the need for them to be able to respond. We have done a lot of work with Secure Journeys to ensure that staff are adequately trained to deal with that situation and have the adequate equipment to do so. If you like, Senator, I can get Acting Deputy Commissioner Nicholson to run you through exactly what we have done.
Well, I want to know how on earth this happened on the 23rd of September, and you would well know that many people in detention have very significant mental health disorders, significant trauma. Self-harm is part of what you deal with the cohort of people you have in detention. And for your initial response to try and suggest that we should take into account the fact that there was clearly a self-harm incident by the detainee and therefore we should see it in a different light. This is the cohort of people you're dealing with. You accept that?
Senator, absolutely.
And you're meant to have responses in place, knowing the vulnerability of the cohort of people you're dealing with. And surely you should have responses in place so that if they lock themselves in a burning room, you're in a position to A, do what you can to protect them and ensure that the staff who are trying to protect them are themselves safe. And you failed on both grounds here.
Senator, we review every incident that occurs and look at where there have been any issues associated with that incident and then remediate as required the equipment, the training inside the immigration detention network, including for our Secure Journey staff, to ensure that the best, safest network is in place.
Thank you, Commissioner. Thank you, Senator Shoebridge. I'm sure we'll be returning. Senator Dane.
I'm sure we will return. I just want to go back to the Sky Traders contract and thank you for the most prompt action on this question on notice answer, which I have now. And I do just want to go to the answer to question 8, which was if the relevant company was not able to commence full operations from 31 October 2025, were any penalties applied, and if so, what were they? And you have taken on notice any elements of the contract that relate to those provisions, so I don't expect you to relitigate that with me. But again, just on the contract notice view for that tender, it does specify the contract period was from 31 October 2025. The answer says the contract was signed on that date with initial services commencing from 31 May 2026, originally in 3 days' time, and full services by June 30 of this year. Do those dates there reflect the dates we were talking about a little earlier on? That is, it was supposed to start in June, but now it's been moved back to, supposed to start in May, but now moved back to June. Are they the dates we were?
So, Senator, yes, I think they were supposed to start in May to build up to full capability as of the 30th of June. And, they're now not starting until, I think it's in the first 2 weeks of June, but we're just, I think I took on notice to find the exact date. So that full capability might be slightly delayed as well into July.
Perhaps. Okay, and so my second question, and again we'll deal with all of this on notice, I'm sure, or at least what we've talked about so far, the value of the contract being $190,795,803.32, does that apply to the period 31 May or whatever the new date is in June, or is it a reduced amount? Just given the discrepancy between the contract notice view and
yeah, I'm pretty confident, Senator, that we have not paid any money to Sky Traders, and we won't until they actually start their services in June. And so therefore, because they are starting late, it's very possible that the total amount that we will need to spend on that contract will be less. But I think I took on notice just to find that exact detail. But I'm pretty confident I'm right. I just want to make sure that I'm 100% telling you the right thing, Senator.
Yeah, no worries. No, I appreciate that, and I'm pleased to finally have that answer. Just back to the larger contract, and you were going to attempt to see what date that process closed.
Yes, and I did get that, Senator. It was the 5th of December 2024.
Okay.
So it opened in August and it closed on the 5th of December 2024.
That final stage, yeah. So it was put to me that in December of that year, the registered director for Maitreya was actually a real estate agent in Melbourne. Now, was that information made available to the directorships of a company that was being awarded this contract?
I am not aware of that piece of information.
You were the delegate.
I was the delegate, Senator. Yeah. So certainly when I made my assessment in April in relation to awarding of the contract, I was not aware of that particular piece of information. And the due diligence that I undertook in relation to looking into Maitreya, I examined the information that was before me. Quite a hefty, as you can imagine, quite a hefty pack of information that the procurement team had pulled together for me because of the fact that it is a very large and complex procurement. And then that included a bunch of information around the company subcontractors and the like. There was nothing presented to me in relation to that.
Yeah, so as you say, a bunch of information presented to you about the company, and it's a large contract, it's a global company, it's a significant body of work that's going to be undertaken. It was also put to me that according to ASIC, the primary place of business at the time they lodged their tender and the process closed was a residential address in Toorak, and then only in April of this year was the address updated to a co-working office space in Perth. So, I mean, as you say, it's a big global business and there's information to be made available to you as the delegate around their capacity to do that. None of this information around the fact that it was a real estate agent in Melbourne who was the registered director in Australia and operating out of a Toorak residential address until they moved to a Watso or something like that came across your desk as part of your process.
No, Senator. I think Maitreya, and I think I took on notice and can sort of answer for Senator Shoebridge. Maitreya's global headquarters is based out of Washington, DC. They're a large company. When I reviewed the information that was presented to me that the procurement team had done a fantastic job in pulling together, I was very confident that Maitreya could deliver on the services that was required in the, having considered all of the things under the Commonwealth procurement rules that I'm required to consider, and that's the reason why I executed my delegation and awarded the contract to Maitreya.
Okay, but and is that information that I've just presented to the committee something that would at any point be considered in your brief or the evidence given to you or the information given to you by your procurement team?
Well, I think, Senator, there are checks that are done on companies to make, as part of the procurement process, to make sure that they can deliver the services that are required. I don't know if they go down to the level of detail of checking locations of their business setups and those sorts of things. They will But there is a number of the evaluation team will actually check to make sure that that companies can deliver the services, that they're financially viable, all of the things that are required in various points of the Commonwealth procurement rules. In relation to the level of detail that they go down to, I'm not 100% sure, but what I can say is that based on the information I had available to me at the time, I was confident that Maitreya could deliver the services that the Commonwealth required. I think the other piece to consider, and it does come back to the point that I was sort of making around when companies tender for these types of things, they might not have these types of contracts. They might not have the full allotment of staff, the full allotment of equipment, and those to deliver the contract at the time they're tendering. We're making an assessment based on whether or not we believe they can deliver the services when the services are due to be delivered, in this case as of the 1st of January 2028. And Maitreya has until that particular point in time to get its all of the capabilities and people and everything that it needs to be able to do that. Companies have to make decisions about whether or not how much they invest at the time of tendering versus getting through to the point of delivery. In this case, because it's a very large contract with many elements that a company has to deliver, it is possible that they were not investing significantly into until a point in time, in which case they've won the contract. Now they'll increase their investment. That's not unusual. It just comes, I suppose, Senator, it comes back to my point around at the time that I exercised my delegation, when was I confident that they could deliver? I was, and hence the reason why I made the decision.
And so, look, just taking a step back, with the information you've provided relating to the smaller contract, the IoT contract, and the larger one, and we're talking about a subcontractor in one case, the main contractor in the larger one,
yep,
that didn't have aircraft, didn't have an air operator certificate, operated out of a residential property in Melbourne according to the ASIC Director Register, and then relocated to a co-working space in Perth.
Senator, I never confirmed any of those things. So I know those were things that you put to me, but all I would say, I took on notice to find the exact details about their operating licence. I can't confirm.
Can you take on notice those points I've put to you? Were those facts that I've put to you part of what the procurement team provided to you in their work before it was... Well, there are people at the table who may want to answer, but I know we're about to go to a break.
We are about to go to a break.
So maybe we'll pick this up after.
Sorry, I know you've just come to the table as we're about to break for morning tea, so we'll do that now and we'll return at 10:45.
Chair, just with your indulgence, and when we get back I do have the answer to a couple of questions on notice that I took that I might be able to read in.
Excellent. I'm sure Senator Dunniam would really appreciate that. Thank you. We will now suspend until 10:45. We will resume from our morning tea break and proceed back to Senator Duniam.
Thanks, Chair. And we were sort of partway through an interchange, and I think were there answers perhaps to?
Yes.
I do have answers.
Yeah,
to a
great.
couple of questions.
That'll help me. That'll jog my memory about where we were
don't.
at, so.
These are not necessarily the questions that you were immediately asking me, Senator.
No.
But I did take on notice the subcontractors for the larger Maitreya contracts. So they have Jet Aviation Australia, Marops Limited, Sky Traders, Bombardier Defence, Textron Aviation, Fujitsu Australia, Rishworth Aviation and CAE Australia as subcontractors as part of that for a variety of operational support, pilot training, maintenance, aircraft manufacturer, ICT.
Perhaps on notice, just if you could provide to what extent you can what each of those subcontractors do and whatever value.
On notice?
Yeah. On notice is fine, rather than...
And then the second question I have for you, Senator, is you asked me whether Sky Traders had done any surveillance work. The answer is yes. They have done some surveillance work down in the Antarctic area.
Surveillance work in the Antarctic. Okay, in the Southern Ocean. Fair enough. Very good. And you just said that Sky Traders was a subcontractor in the larger contract under Maitreya?
Yes.
And the reverse.
And the reverse in the IoT search contract.
Noting I've asked you on notice to specify those details, what is Sky Traders doing for Maitreya in the larger contract?
In the larger, they are providing pilot training services and operations coordination and support services.
Okay.
Is what
All right. Well, any further detail on that broader question on notice would be good. Just in terms of the larger contract, I can't recall in amongst the dates we've talked about, when did the evaluation for the large contract conclude?
I don't think I have evaluate. So we executed the contract on the 1st of May.
Of this year?
Of this year.
Yep.
I don't think I've got the detail of when the evaluation element was.
Well, one would
assume.
assume. Sorry, and I'm not au fait with the stages of contract, procurement, etc. But I presume that sort of until the contract is executed, you're in some form of evaluation, due diligence, etc.
That's correct, Senator. So,
okay,
broadly, we have to evaluate the specifics of the tenderers against the tender documentation. Then there'll be a sort of a negotiation element. Inevitably, with these contracts, with these procurement activities, there are areas where the Commonwealth and the preferred party have to negotiate over a variety of different things, and then you arrive at execution in sort of three broad bits, if you like, elements to the procurement process.
Sure, okay. And just in...
I agree.
Important
That was very soothing.
It was. Thankfully it wasn't later tonight. We'd all fall asleep. So just on... Given there was overlap between the two processes, so the larger contract and the Sky Traders one we talked about earlier, and given there were parties involved in both, is there any sort of process you have to go through? Because you were the delegate on both, is that right?
I was the delegate on both.
Is there any process you have to go through to ensure there isn't some sort of crossover conflict or problem arising out of dealing with both?
Yeah, Senator, so we have some rigid and detailed probity processes that we put in place for these major contracts, and we also the department has a policy around sort of the high risk, high value procurements that adds an additional layer of governance to make sure that we're meeting our obligations, and that I, as the delegate, get some additional advice from people like the Chief Procurement Officer and the Chief Risk Officer, just to make sure that an additional check in relation to making sure that we've complied with the relevant legislation and common procurement rules. So I think that it is possible that some elements of the business will have worked on both procurements, particularly in the business area where the contracts are sort of let from our Civil Maritime Division. But I'm very confident that the probity requirements were met and that I saw that as part of my exercising of my delegations.
Okay, and I do recall at the end of the last session we had two of your colleagues come to the table, and I think they were going to speak about the detail around what was provided to you as the delegate relating to, well, it may have been, I'm assuming here, but...
So, Senator, it was more to give you reassurance about the level of technical support that Mr Howard as delegate gets to make his decisions, so to take you through the kind of due diligence checks, etc., that we will do, and what level of detail is required for us to meet those. So if that's helpful to you, Ms Tressler, and...
Yes, that would be excellent. Wherever... Ah, yes, here we are.
So Ms Cargill is our Chief Procurement Officer who provides support.
Good morning, Senator. So Charlotte Tressler, Chief Operating Officer. Just a couple of things I'd like to reference in relation to this line of questioning, because I think it was in relation to director and entity being offshore. So CPR 10.2 does state, just for your reference, subject to these CPRs, potential suppliers to government must not be discriminated against due to their size, degree of foreign affiliation or ownership, location or the origin of their goods and services. And then otherwise, we do have a very thorough due diligence process that is put in place and compliant, of course, with the CPRs. And our Chief Procurement Officer will take you through some of those details. But at a general level, just to give you a sense of all of that, so we will look at, is that a genuine supplier? What do their organisational structures look like, including foreign ownership, etc., the directors that are associated with the business. We have extensive checks that we do around supplier capability, so skills, qualifications, experience, availability of resources, experience in the relevant areas, as well as financial capability, commercial viability, and a range of others. And our Chief Procurement Officer can take you through that. The other thing I'd just say, from an organisational perspective, with procurements of this nature, just because they are what we call high risk and high value, we do put additional governance in place within the department to really ensure that we're oversighting the procurement and meeting all of our obligations.
Sure thing.
Senator Stephanie Cargill, Chief Procurement Officer. So just following on from Ms Tressler's evidence, we do wrap all these checks up. It's a risk-based assessment for all of our high-risk, high-value procurements, and you can imagine a procurement of this value require the highest level of due diligence and probity checking. So that's actually done through our tender evaluation process, predominantly as part of two steps. The technical evaluation, which is where we conduct the actual organisational capacity of the tender responses, and there's also a financial viability assessment undertaken, which are the two key processes in which we undertake these checks. But throughout the entire process, as you noted, we always have an ongoing risk assessment, and that's live throughout the process and continues throughout the contract management phase of the contract, and we're always revisiting that risk assessment. But just in terms of the types of questions that we ask, and we actually have a matrix in the organisation under our due diligence framework, which actually sets out for the type of complexity of procurement, the types of questions that are required to be asked. So just under the one being, is the supplier genuine, we would look at ABN status, contact details, business structure, ownership, Indigenous business, related entities, any risk known about any potential collusion, bank account details, foreign ownership, beneficial ownership. They're just some examples, and that's just under, is the supplier genuine, being one question as part of the due diligence.
Thank you for that. And so in that question that you ask when evaluating a contract, is a business genuine? You talked about those things, and I was asking, of course, those questions before around this notion, which has been put to me, and I'm seeking information in response to those claims, whether the director at the time the tender process closed was a real estate agent and the business was registered to a residential address in Melbourne.
So, Senator, we would be loath to go into the detail of tender evaluation responses, certainly for commercial in confidence reasons. But what I would say is that it was very well known throughout the tender, was well known throughout this organisational capacity assessment that Maitreya needed to actually establish a presence in Australia. So it was known at the time that there was one director located in Australia, and that was formed part of the assessment, but also going to and offset by other information about the global network and their other referee reports and all the other information we had. And noting Ms Tressler's point about not discriminating against foreign businesses, that was all taken into account in terms of the organisational capacity rating, and then that gets followed through in the evaluation process, and we need to then check whether we are confident that supplier can establish the required presence that we need to deliver the services, and that forms part of the ongoing process.
Okay. In terms of, was there any communication or advice provided to the tenderer about that element of their tender, that there was one director based out of, allegedly, Melbourne, and it was registered to a residential address? Was that, I mean, is that something, is there a to and fro, or once it's in, that's it, doors closed, black box, and you do your process?
Oh, no, that if required, we're able to issue clarification questions.
And were clarification?
I'd have to take on notice and not certain whether we'd be able to release
Indeed,
those
I
under commercial in
understand,
confidence, but there is a process whereby if we want to ask a clarifying question, and the process is always that we would make sure that all tenderers effectively are asked the same question in terms of clarification, then that would be done. But otherwise, there are then the next steps of the process where we would do follow-up checking and continue our risk assessing.
Sure. As part of this, do we understand what the actual ownership structure is of Maitreya?
Yes, we do. So Maitreya is part of a broader Maitreya enterprise, which is Maitreya Holdings Limited, a series of companies, Maitreya LLC, and they're actually part of a larger US asset management firm or company or group of companies by the name of Oaktree Capital Management.
Okay. Just... Oh, if you'd like,
Do you want to finish this question?
Yeah, look, I'll have, I think, two or so questions, and then I'll be done with this issue.
Fine.
Okay, so just in particular, the use of the Bombardier Global 6500 business jets, is that an operational sort of question? Okay. So can I understand what modelling was undertaken relating to the total whole of life cost, including fuel burn, maintenance, sustainment, and Commonwealth pass-through costs?
I'll have to take that on notice.
Okay. And how many pilots are required to operate these aircraft? And was there any evidence provided by Maitreya of their prior operational experience with this platform?
The specifics I have to take on notice.
Sure.
Yep.
Okay. Was there any criteria or weighting that was used in the assessment relating to previous experience across the bidders? So had they conducted work for your agency or others when making the decision?
There would have been, I'm not 100% sure of the exact criteria, so I'd have to take that on notice, but there will have been an assessment of their capability to deliver. Normally an element of previous experience would be assessed as part of that, but I could take that on notice to double check, Senator.
Okay, all right. And my final question relating to this, and again, I think it relates to something you've taken on notice already, Ms Cargill, but was the successful tender at Matria permitted to materially alter key parts of their proposal post being awarded the contract?
I think the short answer to that is no.
No,
Senator.
No.
Okay. All right. Thank you very much, Chair.
Thank you, Senator Dunningham. Senator Shoebridge.
Thanks, Chair. I was asking questions previously about secure journeys and the multiple contractual breaches. I took you to the incident whereby 2 workers suffered smoke inhalation and were hospitalised. A detainee almost burnt to death in their locked room. Was there a penalty for secure journeys for that incident?
Senator, under the contract, we have a performance management framework. The framework monitors performance against several key performance measures. Those particular performance measures are audited by the Australian Border Force officers at site across the network, and we coordinate and produce monthly performance audit reports. Each of those reports compile the performance against 17 key performance indicators and 3 charge events. In regard to the event that you're referring to, I'm just looking through the types of chargeable events or quality failings. They're things like an incident reporting requirements where they must report against our incident reporting requirements, the development and maintenance of detainee risk assessments, appropriate meals, detainee activities and programs, preventative and reactive maintenance, detainee case plans, detainee property management, management of records, logs, registers and data. There are a few others there, and particularly the one that we are working with them closely on is the mandatory clearances, training and qualifications. The charge events include an escape from detention, extraordinary incidents whereby a part or full control of a facility is handed over to an external agency or to the ABF, or professional and integrity code of conduct breaches. So with that framing, the incident that occurred, we would have looked at part of their reporting requirements. Did they report in a timely manner? Did they report in accordance with the requirements? Would potentially have, if that was the case, incurred a quality failing. But they're all the requirements around the performance against those performance measures and KPIs in the contract.
So sending workers to their potential death untrained without respirators into a fire, that's not a chargeable incident, but not notifying you about it would be the chargeable incident. Is that right?
Senator, I don't think that's an appropriate characterisation.
Well, that's what happened here. 2 workers ran to their potential death without training, without respirators, into a fire. They were hospitalised as a result of it. The issue isn't that for you and under the contract. The issue is whether or not they notified Border Force about it.
It's not just that, Senator. They are accountable under the contract to train and provide the appropriate qualifications to their workforce. And with regard to this particular incident and the Comcare notification we did receive, Secure Journeys were required to ensure all officers were briefed accordingly as part of how they respond to a fire, of which they have done so. But prior to then, they would have received a quality failing under the contract for not having provided their staff with the appropriate training to respond to a fire.
were they penalised or charged because of this incident? That was my question. My understanding is that your answer is no, and you're seeking to explain why not. But perhaps you can just say it in the clearest possible terms. Were they penalised or charged or abated under the contract because of the incident?
I would need to take that on notice because the way in which our performance framework in the contract, it relies upon the service provider to meet the performance measures, which include informing, educating and ensuring their workforce have the qualifications to perform their role.
Well, I wait for your answer on notice, and if the answer is yes, can you please advise the quantum of any such penalty they paid for almost sending 2 of their workers to their death, and in this case, also not having systems in place to protect a detainee in their care? Can you provide us what if any, penalty was paid?
I don't agree with the way that you've articulated that particular incident, Senator, but
Well, it's that incident.
incident.
What was wrong with how I articulated the incident, Commissioner?
Particularly, Senator, the inference that Secure Journeys sent 2 of their workers into that situation.
Is it because they did it voluntarily? Is that the issue? They did it voluntarily because they weren't trained?
It's the inference you've made that it was the company who sent them in.
The company employed them, they didn't train them, and the workers then, because they saw someone was locked in a room, a burning room, they went to try and save them.
They did.
The workers then suffered inhalation and asphyxiation and were hospitalised. Yes, I do think MTC, Secure Journeys, is responsible. Yes, I do blame them for it, and yes, I do think they should be charged under the contract for that. You disagree with that?
Senator, we'll take the question on notice for you.
All right. Secretary, The Guardian reports that the Minister required the President of Secure Journeys / MTC to come from the US last year to have a meeting to discuss the repeated contractual failures. Did that happen?
There was a meeting between the Minister and the senior official, yes, Senator.
Was it for the reasons that I put? The repeated contractual failures and breaches by MTC / Secure Journeys? Is that what caused the meeting to occur?
Senator, the meeting was to ensure that Secure Journeys understood how seriously we took their requirement to meet the terms of their arrangements with us.
Were you in the meeting, Secretary?
I was, Senator.
Commissioner, were you in the meeting?
No, Senator.
Who else was in the meeting?
So, Senator, my memory is that Deputy Commissioner Holborn attended the meeting.
Deputy Commissioner Holding?
Yes, Senator.
Is Deputy Commissioner Holding here?
No, Senator. Deputy Commissioner Holborn is on personal leave.
All right. As a result of the meeting?
No, Senator.
No, Senator. She's on personal leave today.
All right. Who else was in the meeting?
So, Senator, the Managing Director was there, and my memory also the Australian manager from Secure Journeys.
When you say Managing Director, what was the person's name?
Can you help me?
Dan Marquette. So the President of MTC, Dan Marquette, was in attendance.
Dan Marquette. And was he there as Managing Director or as President? Or I'm just trying to find out who was there. Managing Director, President?
Both.
So the local Managing Director, what was that person's name?
Troy.
Idelson.
Ivanhoe?
Idelson.
Sorry, Troy?
Idelson, yeah.
Yeah.
Commissioner, if you know, just let us.
Idelson.
Idelson. Troy Idelson, Dan Marquette, respectively from the Australian and the US operations of Secure Journeys, is that right?
That's correct, Senator.
And then there was the Minister,
That's correct.
Minister Burke. correct?
That's correct, Senator.
Was there any other staff, any other ministerial staff present?
There would normally be, Senator, but I don't recall.
There was yourself from Home Affairs
That's right.
and Deputy Commissioner Holding.
Holborn.
Sorry?
Holborn, Senator.
Holborn. Were there any other officials from within Home Affairs?
Not to my recollection, Senator.
All right. What was the outcome from the meeting?
A commitment that we would continue to work together and that Secure Journeys would do everything in their power to meet the requirements of their contract with us.
Was there a discussion about the fact that there'd been a savage reduction in the number of staff in the facilities since MTC took over? For example, the UWU, on their estimation, says that the number of staff in the facilities operated by MTC staff and contractors has fallen from 1,900 in 2023, before they took over, to barely 1,000 workers across the network now. Was that discussed?
So, Senator, I don't recall the detail of the discussion. What I do recall is the Minister making his expectations about the performance of the company very clear.
Did that include adequate staffing?
Senator, I've just told you I don't remember the details. I remember the
Did you take
headline.
Minutes? It's a very important meeting regarding a $1.2 billion contract with a large US multinational in a high-profile part of your portfolio for which you're responsible, Secretary. Did you take minutes of the meeting?
I did not, Senator. I was not there as a note taker.
Did Deputy Commissioner Holden, did you say?
Holborn.
Holborn. Did Deputy Commissioner Holborn?
I don't know, Senator.
Does Home Affairs have no records of this meeting?
Senator, I can check with Deputy Commissioner Holborn when she returns from leave, so I'll take that on notice.
And if there were minutes, will you please provide them to the committee?
We'll take it on notice, Senator.
All right. The in answers to a question on notice, I think it's AE 2675, we asked about staffing levels at immigration centres, and the answer we got from, I think it was sourced from Home Affairs, but eventually came through the Minister, was staffing arrangements are an operational matter for the service provider. Is that your position?
So, Senator, the contract with Secure Journeys is outcomes-based. So it doesn't specify staffing volumes?
Oh, yes, and as a result of which there have been repeated safety breaches, 12 escapes. The union says that staffing numbers have gone down from 1,900 to 1,000, and when that happens, you have outcomes like this. It's a problem in the contract, perhaps, Commissioner?
No, Senator. The service provider must maintain sufficient workforce to deliver its obligations under the contract. The Australian Border Force has personnel in each and every detention centre each and every day. Part of the work they do is to ensure that the appropriate workforce is in place at every detention centre.
Well, then, I asked if you knew how many staff were there. If you have personnel in each and every detention centre monitoring the staff, you should be able to tell me. So I'm going to ask again. Can you provide the staffing numbers at each and every detention centre, and can you compare them to what they were in 2023?
Senator, it's an outcomes-based contract. So you could, for example...
You just told me you have staff monitoring the staff numbers.
Each day.
Well, then
in each location.
Well, then you should have very granular detail.
So you can have 4,000 people in place, but if they're not delivering on the outcomes in accordance with the contract, that's what matters, and that's the contractual
no danger of
obligation.
That with Secure Journeys, because they've savaged the staff numbers. So you now tell me you have staff monitoring on a daily basis the number of staff in these facilities. So when I get an answer to questions on notice, such as staffing arrangements are an operational matter for the service provider, when you tell me you have granular daily detail about staffing numbers, I wonder if I'm getting full cooperation as is required. So I'm going to again pressed for an answer to that question. What are the staffing numbers at each and every facility operated by MTC subject to this contract?
And my response remains the same, Senator. It is an outcomes-based contract.
That is not an answer, Commissioner. The contract may be outcome-based. Fine. That's terrific. How many staff are at each facility?
That will change on a daily basis.
Well, then can you give me the average or the median, average and the median for this financial year for each of the facilities?
I can take that on notice for you, Senator.
Yes. Also, in answer to question A26, in this case 76, you made clear there are no contractual ramifications for prosecutions for sexual assaults that happen at detention facilities. Well, there's now actually, you'd be aware, been a prosecution for a sexual assault at one of these facilities. Can you confirm that there was no charge or abatement in relation to that sexual assault?
That is not in the criteria for an abatement, Senator.
So no penalty for secure journeys if they allow, if their systems permit or allow detainees to be sexually assaulted. How do you write such a contract?
No, Senator, it's not a matter of the contracted service provider allowing an atrocious incident like that to occur. As we have been discussing today, this financial year up to March, 3,824 people have moved through the immigration detention network. 85% of that 3,824 have a criminal history. 2/3 of that number are high or extreme risk detainees. On occasion, there will be incidents between detainees, and it will be dealt with to prevent those incidents occurring again. And it will be referred to the relevant law enforcement agency. Will absolutely deal with any sexual assault that occurs inside the immigration detention network.
So can you just confirm there was no charge or abatement or penalty paid by Secure Journeys, notwithstanding the prosecution for a sexual assault that happened on their premises?
True. I can confirm that, Senator.
One of the Comcare notices issued to Home Affairs in relation to these facilities required the department, in this case Home Affairs, undertake a comprehensive review of all workplaces where Secure Journey is engaged to deliver detainee-related services. Now that Comcare notice was provided in mid-2025. Have you done the review?
Senator, you're referring to the Comcare notice regarding the fire in Villawood?
I'm referring to the Comcare notice. There were two Comcare notices. The Comcare notice to Villawood had certain requirements on it. That was regarding fire safety protocols. Has that been complied with?
Yes, Senator, it has.
Can you provide evidence of when that was done?
Yes, we can. It was concluded and reported back to Comcare on the 31st of March.
But of course, the other Comcare notice that was issued, and it's MC 000392338NT01, that was issued in mid-2025, required that the Department of Home Affairs undertake a comprehensive review of all other workplaces where Secure Journeys is engaged to deliver detainee-related services, particularly those operating at APODs or similar environments. Has that review been done?
Yes, Senator, it has.
Sorry, just to be clear, there's no confusion. This was a Comcare notice issued on the 29th of July 2025. When was the review done?
I would need to provide that detail on notice.
What was the outcome of the review?
It was specifically to do with our alternative places of detention and ensuring that staff were briefed and aware of emergency evacuation procedures, and that those procedures were visible to the workforce and they were aware of them. And we undertook direction and a network-wide review of all those alternative places of detention to ensure that occurred. So,
can you provide on notice who undertook the review, if there were any changes as a result of the review, and provide a copy of the review?
Yes, Senator.
All right. Oh, just one final question. What is the total sum of charges/abatements that MTC has had to pay under the contract since it commenced, and in relation to how many incidents?
Senator, I'll take that on notice.
All right, thank you.
Thank you, Senator Shoebridge. Senator Duniam.
Thanks very much, Chair. So just on the same matter more broadly, just this number of frontline staff at immigration centres, do you have a figure on how many are deployed?
Good luck.
Yeah.
Senator,
Sorry, I did hear a bit of that. I thought
Senator,
Thank you, Senator Shoebridge.
we have taken that on notice for Senator Shoebridge. I will take that on notice for yourself as well, Senator.
So that is a number as at today that you took on notice for him? Or?
I think it was a median over the details we will apply to your query as well,
You may
Senator.
as well ask for today, John. That'd be useful.
Yes. Today would be excellent.
Yeah, we'll take that on notice, Senator.
Thank you very much. So just in terms of the NZYQ cohort who are in custody, if there are any, I'm not completely across who's in, who's out and where they are, has management of that cohort had an impact on the work of your frontline staff at centres?
So, Senator, the impact of the High Court decision on NZYQ was in fact for a requirement for us to release a number of people who had been in immigration detention.
And so there are none that remain of that cohort?
For people who met the circumstances of the court case of that group, we needed to release them from immigration detention.
And so do any remain, though, that fell outside of what the High Court's decision was?
So anyone who fell within that definition was released.
Gone.
There were clearly many people who remained in immigration detention who did not fall within. So in terms of your question to the Commissioner, in terms of the detention network, the immediate impact was that there were less people, but...
what was the actual number again that were impacted by the High Court decision?
Senator, it's important to understand it's not a static cohort. People can become NZYQ affected on a rolling basis. So we can give you the number that were initially released in November, or we could give you the number to date that have been affected.
Well, why don't we do the November number and then we'll do to date, yes.
Certainly.
Senator Michael Thomas, Deputy Secretary Immigration Compliance. There were 144 people that were NZYQ affected, so to speak, in November 2023 that were released from immigration detention during that month.
Okay, and then since then?
Sorry, Senator.
To date, I
have a monthly breakdown of people over each month for the last 2 years.
Perfect. Let's
I don't
go through
have
that.
the total though, so I would have to.
I've got a calculator here.
Or we could give you just the current number of individuals who are on a bridging visa are. What would you prefer?
So does that include? So does that what you've just offered replicate the broken down month by month?
No, Senator, because so somebody can become, like just stepping back, somebody becomes NZYQ affected when there is no reasonable prospect of removal available at a point in time such that we cannot lawfully hold them in immigration detention. At that point in time, we're required to release them, and we release them generally on a bridging visa R. It's possible that after that point in time, something will change in the facts, either relating to the individual circumstances or the country of origin, that means that removal becomes possible. At that point in time, it is possible to take that person back into immigration detention. Another thing that can happen is, and has happened sadly, some people have died. So the number does change. Like it's not like a pouring into a tank. There is some outflow from it as well. It's stock and flow,
including via debt.
Some people commit crimes and are taken into custody in the state custodial system.
And then the other kind of key outflow is the group who have a removal pathway available under the third country reception arrangement with Nauru.
Okay, and we'll come to those later. But just the difference between the number, Ms Sharp, you were offering and the month by month. So, Mr Thomas, the month by month is people that... Can you explain how we make that number up?
Those are people that have become NZYQ affected, so to speak, while in immigration detention.
Okay, let's do those first.
Reasonably practical.
Yes.
So we are required to release them from detention.
Why don't we do those, and then we'll go from there.
Apologies in advance, it's a long list of months.
That's all right.
In December 2023, there were 5. In January 2024, there were 14. In February, March, April and May, there were less than 5 each month.
Less than 5? How do we don't have a precise number, under 5?
No.
So, Senator, in order to protect individuals' privacy, when we are providing statistics, we provide precise numbers for 5 and over and a less than 5 figure, so that if, for example, it's only one person and that person can be identified, then we're not breaching their privacy. But when you get to the total figure that Ms Sharp will give you, that will give you a sense of how many people are currently affected.
Although Ms Sharp's figure is slightly different to the figure that this will amount to.
That is correct. So the difference will be, as Ms Sharp said, people that have exited that bridging visa cohort because...
There would be no problem if we don't have it to hand in us giving you a total figure on notice. There's nothing particularly... No. We're not being cagey here. We just don't have it presented that way.
I would never accuse the Department of Home Affairs of being cagey at all. So we got to, I think, was it March?
We got to May.
May.
In June 2024, there were 8. In July, less than 5. In August, 13. In September, 8. In October, 20. In November, 23. In December, 34. Then in January 2025, there were 13. 12 in February, 10 in March, 15 in April, 8 in May, June and July.
So 8 in May, June, July?
So 8 each month.
Mm-hmm.
Less than 5 in August, September, October, November, December. So less than 5 each month. And then for January, February and March this year, less than 5 each month as well.
Okay, excellent. I didn't tally all of that up, but so Ms Sharp, your number?
Yeah, so the current, well, as at 31 March 2026, there are 343 people holding a bridging visa R granted after the NZYQ High Court decision.
Okay, noting that is the numbers we've been through, plus those initially affected and others that you've...
That is the number of people who have been assessed as reaching the NZYQ threshold,
yes,
whose circumstances have not changed in such a way that they no longer need to hold a bridging visa.
Okay.
I should note too, Senator, that people may become NZYQ affected while in criminal custody, for example. So on release from custody, they will enter that NZYQ cohort and be granted a bridging visa R as well. And so there are other sources for that cohort too.
True, and so that category of individuals is not included in your
It is.
It is included in your number, is it?
Not in those monthly numbers, but they
just
are
the
included
aggregate.
Because we could not have lawfully detained them. So they're
Yes,
coming
'cause
up
they
to
were
prison release, but if we know we cannot remove them, we cannot detain them in the first place, so they go straight. We do that assessment to ensure we stay within the bounds of the law. We do that assessment as they're coming up to the end of their prison sentence.
Okay, and so just that is very helpful information, and we'll come back to that in a moment. In terms of, though, the workload for the officers, the number of whom we're not quite clear of, we'll get on notice, the United Workers Union and claims of being overworked and increasingly put in dangerous conditions. I mean, what is the agency's response to that set of claims?
So the United Workers Union has a relationship with Secure Journeys, the company.
Mm-hmm.
It's not a relationship with the Department of Home Affairs, including the Australian Border Force. With regards to the claim, Senator, that there is understaffing, there is continuing work between Secure Journeys and their workers around the rosters that they have and around the number of workers allocated to particular tasks.
Mm-hmm. Okay, and that satisfies the contracting agency being Border Force as part of Home Affairs, that things are under control?
So, Senator, we continue to work with the contracted service provider Secure Journeys to ensure they're meeting all of their obligations under the contract. We use a monthly performance management report to enact that assurance that they're meeting those contractual obligations.
And are they meeting all of those obligations?
On a monthly basis, they have not been on occasion, and there have been penalties as a result.
Can you describe what obligations have not been met and what penalties have been applied?
So I'll just ask Acting Deputy Commissioner Nicholson to come to the table to see what we can describe for you.
Sure.
Good morning, Senator. With regard to performance under the contract, we obviously have a number of levers that we can use to monitor and ensure that the service provider is meeting its obligations. A series of those contractual levers continue to be leveraged, including obviously formal correspondence around their obligations to meet the contract. We also have at our disposal the performance management framework, where they are abated for failing to meet one of the 20, or there's 17 key performance measures, and then the 3 charge events. We also have means to use default notices, whereby they are required to provide remediation strategies and plans to remediate their areas where they are not meeting their contractual obligations. And we also have the ability to suspend performance of any services until the circumstances of the issue actually is being, like, they're delivering in accordance to what we require them. We are in the process of finalising the first 3 months of the contract performance management framework. And we'll continue to work with Secure Journeys very closely on ensuring that their contractual obligations, where there are vulnerabilities that we have identified through our monthly auditing, that they are provided to them through those contractual mechanisms to ensure they're meeting their obligations.
And so you've run through the levers available to the government to pull to respond to issues. What levers have been pulled? Are you able to talk through that at all?
We meet with Secure Journeys at the senior executive level fortnightly to talk through where they're up to with regard to meeting their obligations. We also have issued a series of default notices where we feel that they've not yet meeting their requirements. And obviously we're continuing to provide written correspondence to them under the contract, reminding them and working with them on how they need to deliver.
And so are you able then to tell us what obligations or requirements are not being met of the, I think, did you say 17 there are on this contract?
So each month, every task, every service delivery is is attributed to one of those 17 performance measures across every facility is audited by the Australian Border Force. That is a very complex reporting structure, and in order for us to extrapolate that into a report that then is connected to a value of failings is what we are working through now, and I don't have those details with me, sir.
Okay. On notice then, could you provide what you're able to in relation to that? On the 8th of April this year, there was an escape from, as I understand it, someone in MTC's custody being transported to hospital. Can I confirm that that individual was a member of the NZYQ cohort?
No, they weren't.
They were not?
Senator, just to be abundantly clear, nobody who would be in immigration detention could also be a member of the NZYQ cohort.
So...
by definition.
Yes. So that individual would not, even at the... Let's say they... Oh, at April 8 they couldn't anyway, because what date was the High Court decision? That was on...
The High Court decision was in November 2023.
Yeah.
But the critical point is the moment somebody hits the threshold where we form the view we cannot remove them in a reasonably foreseeable future, like we don't have a practical removal pathway, we need to release them from immigration detention. So if someone is NZYQ affected, they wouldn't be on a medical transport run by Secure Journeys.
They'd be out.
The only way someone who was once affected by the NZYQ decision could be in immigration detention is if their status has changed, for example, if it is now feasible for us to remove them.
And so what if it's an individual who is awaiting transfer to Nauru?
So that person is no longer NZYQ affected.
Right.
So then they are, again, their bridging visa have ceased.
Place. Oh, right, okay.
Ceased on the issuance of a visa by another country pursuant to a third country reception arrangement, and they would be taken into immigration detention and no longer NZYQ affected.
Okay, and with regard to this incident that occurred on April 8, what sort of response was there from Border Force in relation to that?
So, Senator, that particular escape is currently the subject of a New South Wales Police criminal investigation. Therefore, I'm not able to discuss it publicly.
Sure.
And I don't want to prejudice the potential prosecution.
Do you know when that matter is likely to be resolved?
I don't have that to hand.
Could you take that on notice?
I can.
Thank you very much. Thanks, Chair.
Thank you very much. Senator Shoebridge.
Just before we move off MTC, I think, Deputy Commissioner, you said there were 17 key performance measures, is that right?
Correct, Senator.
And 3 charging events. Is that how the contract is structured? Are they the relevant criteria to look at to see whether or not a charge or an abatement or a penalty would be imposed?
Correct, Senator.
Can you provide on notice what those 17 were? Have you got them there now?
I do, Senator.
Might just be simpler if you just read all 17 and then the 3 onto the record. It'll keep the minister happy so we don't have anything else on notice.
It's okay. The monthly...
I know you aim to please, Senator Shoebridge.
I'm only here for your help, Murray.
I've worked that out a while ago.
So I'm just looking at the list that I have, Senator. And the list I have only has 11 charge events. I'm happy to read, not charge events, sorry, performance indicators. I'm happy to read those out, or I can provide you all of them on notice.
Why don't you read what you've got, and do you have the charge events there as well?
Yes.
Yes, I do.
Why don't we get what we've got here, and then if there's anything else, take that on notice. That would be helpful.
Can do. So the monthly performance report against the key performance measures includes incident reporting, development and maintenance of detainee risk assessments, provision of appropriate meals, availability of detainee programs and activities, preventative and reactive maintenance, providing detainee case plans, detainee property management, maintenance of records, logs, registers and data entry, complaints management system, external transport and escort tasks, and mandatory clearances, training and qualifications.
Yes. I mean, the previous contract had other measures such as incidents of self-harm, incidents of assault, circumstances where they lost control of all or part of facilities. Those aren't in this contract?
So I'll just go to the charge events, which are the three, which includes an escape from detention, an extraordinary incident, failure of part or full failure to control the facility, and then professional and integrity, code of conduct. With regard to your question around, and I'll have to take the detail on notice, but that incident reporting, I believe, captures what you were referring to around incidents that are of a critical nature.
Yeah, I'm not interested in whether or not there's a requirement to report. Obviously, that's useful. No, I'm questioning whether or not the occurrence of sexual assaults, incidents of self-harm, of themselves lead to abatement/charge/penalties, and it appears no. Is that the case?
I believe so.
And that is a change from the previous contract, is that right?
Correct.
Why was that change made?
I'd have to take that on notice. So this is about ensuring that the services that are provided to support detainees are in place, which is why we have that focus on the detainee risk assessment, the meals, the activities and programs that support the health and wellbeing of detainees whilst they're in our care.
Perhaps you could, on notice, identify what, if any, elements of those 17 KPMs relate to actually keeping the people in detention safe. And I'm more than happy for you to do that on notice.
I'll take that on notice.
Thank you. I'm going to move to some other questions about the tracking of individuals as they leave and return from Australia who have been involved in military conflicts. Are you best to deal with that, Commissioner?
Yes, Senator. I'll ask Acting Deputy Commissioner Smith to join me at the table.
Thank you. You may or may not recall that in the months following the outbreak of the conflict in Gaza, that Border Force was asking some questions of people of military age leaving Australia and heading off to Israel/Palestine, and or people who were travelling with Israeli travel documents who are also Australian citizens. There was some initial questioning, and I think you provided an FOI, provided some details of that. Do you remember that, Commissioner?
Yes, Senator.
Since then, has Border Force undertaken any tracking of Australian citizens who have gone to fight for the IDF?
Thank you, Senator. Tony Smith, Acting Deputy Commissioner for National Operations. Senator, we don't track Australians that are moving overseas unless we have a reason to be tracking them, and for this purpose it is not a criminal offence to be in a foreign country fighting for a foreign military.
So I assume you'd give the same answer about whether you have been tracking Australians going to Russia to fight for the Russian military. You don't track that?
We don't track that, Senator, no.
You don't track people going to the US to fight for the US military?
Senator, unless there was a reasonable cause to track those individuals, we would not be tracking them for the purposes of that travel.
You wouldn't track any Australians who have gone in the most recent conflict, returned to Iran to fight for the Iranian military? That wouldn't be tracked either?
Senator, as per my previous response, not unless there was a reason to be tracking those individuals.
Yep. So in the appalling conflict in Syria, you wouldn't have tracked people who went to Syria to fight for the Assad regime? They wouldn't have been tracked?
Senator, if there was a reason to track those individuals, we would track them, but unless there was a reason and there was an offence, we wouldn't.
Going to fight for the Assad regime, tick, that would have been fine?
If it was for a foreign military and it wasn't an offence under the criminal code,
yep.
And the ABF, for example, from an Australian Border Force perspective, would not be conducting investigations in relation to the criminal code.
But potentially if someone had fought for the Kurdish administration in the northeast of Syria, you might have tracked them, is that right? Because
technically, Senator, if there was a reason to track those individuals, we would track them as they travelled overseas.
Minister, don't you think that there's a national interest from Australia's perspective to see when our citizens are going and fighting for foreign governments? And, you know, pick the case of Russia's war on Ukraine. Don't you think there's a national interest to track whether or not Australians are going to join the Russian military to engage in the invasion of Ukraine, an invasion that Australia recognises is unlawful and wrong?
Well, I think the officials have essentially explained the position that there is a distinction from the Australian government's point of view between going overseas to fight as part of a particular government's armed forces and going to fight for a terrorist organisation that is not an official government armed forces. That's how I've always understood the distinction.
Yes, Minister.
Well, I don't think it has to be. It could just be a resistance organisation, for example.
Well, I'm not sure that we necessarily track those individuals either, and we could get into a lengthy discussion about what's a terrorist organisation versus
why don't we just avoid that entirely and put the very simple proposition that do you think it is in the Australian national interest for Australians to go to Russia? They may have Russian nationality, they may not, but an Australian citizen to go to Russia to fight in the Russian military to attack Ukraine. Do you think that's in Australia's national interest to permit that to happen?
Well, it's certainly not something that I, as a minister in this government, would encourage people to do, and I think everyone is very familiar with this government's strong position against Russia's illegal war. But as the officials have outlined, efforts are made to monitor or track, however you want to describe it, individuals if there is a particular reason for tracking them. But there is that distinction between official armed forces of a government and terrorist organisations.
And Senator, you spoke in outcome 1 about the framework that we use to monitor individuals of terrorism concern overseas. And so if we had information to indicate that any of these people was engaging in terrorist activities, then they would be monitored through that framework.
In addition, Senator, I've been reminded that both Russia and Syria are, if you like, do not travel countries from the Australian government's perspective.
Well, you ask, you would track it if you thought there was a reason. I'll give you an incident, circumstances where I believe there's a reason and see if it meets your test. There have now been multiple authoritative findings that the Israeli military is engaged in a genocide in Gaza. An FOI undertaken by an Israeli NGO identified that as at March of last year, 502 Australian citizens had had been fighting with the IDF in that conflict in Gaza, where there are multiple, incredibly credible allegations of war crimes and crimes against humanity. Have you been tracking any Australian citizens, and we know that there are at least 502 as at March of last year, who have been potentially engaging in war crimes or crimes against humanity in Gaza?
I think the officials, I wouldn't know that, but the officials may or may not know that.
So, Senator, if you have any information regarding any Australian who has committed a crime overseas, I'd ask that that either be referred directly to the Australian Federal Police, or you're very welcome to refer it to the Australian Border Force.
Well, but this has been referred to the Australian Federal Police. It has been referred to Border Force. Nothing has happened.
What has been referred?
Multiple human rights groups have provided evidence, detailed evidence and dossiers of Australian citizens with supporting documentation to both Border Force and the Australian Federal Police, and nothing has been done, and you're not even tracking.
Oh, Senator, may I just confirm? So that's of individuals with names and where they have served, so the details of...
Briefs about individuals, including social media material that's been provided, other evidentiary material provided by groups like the Australia Centre for International Justice and other groups. They've been providing this to the AFP and Border Force. I think you indicated you had a website or something, or an email address at some point.
So, Border Watch?
Yes,
is where
they've been providing this. Nothing has happened.
Senator, I'm very happy to look into this for you. I can take that on notice to determine if there have been referrals of Australians serving with the Israeli Defence Force or other defence forces where there is a belief that they have committed a crime. I'll take that on notice and look into it for you.
All right, but to be clear, in terms of Australians going to Russia to fight for the Russian military, it's a don't ask, don't tell policy, because Border Force looks at our laws and says it's not unlawful.
So, Senator, we don't track Australians overseas. So, unless it was brought to our attention that an individual was going overseas to commit a crime, we don't track them.
Well, I mean, young male of military age going to Russia, there's a reasonable risk they will be part of an illegal invasion of Ukraine. A young male of military age, or a young person even of military age, going to Israel, there's a reasonable likelihood that they'll be part of what we now know is a genocide in Gaza. This would seem a basis. This would seem a basis upon which to...
I'm not sure that you can necessarily reach that conclusion. I mean, and again, I repeat I repeat the point that the Australian government advises Australians to not travel to Russia at all.
You make no.
But I don't know that you can
Israel.
assume that a young man of military age travelling to Israel is necessarily going to serve in the IDF.
Well, we know that, not from any information you've gathered, your government has gathered, we know from information that the Israeli government has provided to an NGO that at least 502 Australians had done so as at March of last year. We would expect the number to be even greater now.
Well, we haven't verified those numbers, but the point I was making is that your assumption, I don't think, can be made. Now,
that there's a risk. My assumption was there's a risk. The data is a compelling risk.
Well, again, I haven't verified that data, but I acknowledge that it is possible that Australians have travelled to certain countries to serve in the armed forces of those countries, and the officials have outlined the circumstances in which those people's movements and behaviour is monitored.
When the Australian government has taken a position that a law is unlawful, in breach of international law, do you think Australian citizens should be permitted to fight in that conflict on the side of the aggressor who has broken international law? I personally don't think they should.
Well,
is it your government's position that there should be no legal impediment to that?
Getting into opinions, and I've also been reminded that Israel is a do not travel country from Australia's perspective as well.
Is it the government's position that our laws should be neutral about permitting Australians to fight on the side of aggressors in wars that Australia has identified as in breach of international law? Is the government's policy position that we are neutral on that?
I'm not going to play into your games, Senator
What's the
Shivridge.
game? I think most Australians would want a clear policy position that Australians can't go and fight for the Russian military against Ukraine. I wonder why you're resisting it.
Well, go back to what I said 5 minutes ago about that.
Which is what?
That we would not encourage Australians to do that.
Okay.
Because we have held a strong position that Russia's war on Ukraine is illegal, immoral, unjustified, every other negative adjective you can come up with.
You might as well just go and then I'll clear it off.
Okay, thank you, Senator Shubridge. Senator Polley.
Thank you very much, Chair. I wanted to ask some questions around the illegal tobacco and vapes. This government has, in fact, invested a lot of money into addressing this crime. So can you outline to the committee what action Border Force and the department are taking to combat this illegal tobacco and e-cigarettes?
Yes, certainly, Senator. So for the Australian Border Force, we operate pre the border, at the border and post-border in breaking the illicit tobacco business model. So it's across the entire supply chain. Just this year, we have conducted a campaign called Print Wall, and over a 3-month period, we intercepted 4 million vapes and almost a kilotonne of illicit tobacco. This speaks directly to the activities that we're undertaking. Pre the border, we work very closely with international partners throughout, particularly the Indo-Pacific. Just this year, the General Administration of Customs in China, their Anti-Smuggling Bureau, broke up a ring of illicit tobacco exporters and arrested dozens of people in breaking up that ring. Recently, we had the Korean Customs in Australia. They are also providing us with a tremendous number of referrals regarding illicit tobacco, and we have excellent working relationships with other nations throughout the region, including Singapore and including Japan. Indeed, pre-border, during that campaign, we had 290 referrals from international partners, which led to preventing over 35 million cigarettes and 257 kilograms of loose leaf tobacco entering the country. At the border, the Australian Border Force works to intercept through the profiling of particularly sea cargo and air cargo. And over that campaign Print Wall, we intercepted 786 million illicit cigarettes and 347 tonnes of loose leaf tobacco. So that's over 937 tonnes that we picked up at the border. And post-border, last year in October, Minister Burke announced the creation of the National Disruption Group. This is a group working post-border where every state and territory is a member of that National Disruption Group, and they are having tremendous success in bringing together all of the law enforcement, the health services and licensing for tobacco across Australia to break that supply chain for illicit tobacco.
Could you just outline the membership and the work that the illicit tobacco task force is made up of?
I certainly can, and there is a difference, Senator, between the illicit tobacco task force, which deals with serious and organised crime, and the National Disruption Group. I'll hand over to you, Tony.
Fantastic, Senator. The illicit tobacco task force is Australian Border Force led. It has members of the Australian Taxation Office, the Australian Criminal Intelligence, the ACIC, the CDPP in the Commonwealth prosecutions, and also AUSTRAC. AFP have also recently become members of the illicit tobacco task force as well. And as the Commissioner had outlined the role of the National Disruption Group, the Illicit Tobacco Task Force is primarily focused on serious organised crime elements associated with illicit tobacco. So tackling the high-level syndicates that are behind and the masterminds behind the illicit tobacco networks that are impacting upon Australia, both onshore and offshore as well. Over the course of the last 12 months, we've got 20 active investigation cases that are underway within the Illicit Tobacco Task Force, 2 briefs that are under assessment at the moment, and 9 cases that are before the court. And those cases involve charges against 15 individuals. The Illicit Tobacco Task Force works very closely with state, territory and Commonwealth law enforcement policing agencies to make sure that we're combining not just a focus on illicit tobacco, but where those criminal syndicates are also associated with other commodities. We make sure that there is a convergence between our information sharing and intelligence sharing so that we take a collaborative action.
So, the amount of tobacco and cigarettes and vapes that have been seized, and we know organised crime are involved in it, what would be the percentage of the tobacco trade that is jointly done with drugs and these the crime that's been committed there in terms of organised crime? How much of this trade is actually dominated by them?
So it's a really good point, Senator, that there is a connection with serious and organised crime branching between border control drugs and illicit tobacco importation. So they're looking for any illicit commodity from which they can make a profit. And we have found through our profiling and targeting that they're using similar methodologies on occasion, so there is a direct connection. Whether there's a percentage that I don't have one. Do you have one, Tony? Not a direct percentage, but there is absolutely a connection.
Is Border Force involved with the homegrown illegal tobacco that's been produced here?
Senator, the domestic production of tobacco in Australia is, from a lawful perspective, non-existent. There are no commercial enterprises that are associated with the domestic production. However, from a targeting and investigative perspective, the Australian Taxation Office is the key agency that focuses on domestic production.
What can you tell the committee about the Office of ITEC Commissioner and the work that they do?
And I'll pass to the ITEC Commissioner.
Thank you.
Thank you, Senator. Amber Shahita, Illicit Tobacco and E-Cigarette Commissioner. The work of my office is to take a helicopter view across the system. Border Force has provided an excellent summation of their work at the border to tackle this issue. There are a number of agencies, about 50 agencies across the country, that also have a part to play. So not just looking at this, tackling it from a border issue, but also from a state and territory issue, levelling the playing field across the legislative and licensing reform that needs to occur there. My office advises on those laws. It advises states and territories on the framework, on the priorities to undertake to improve our efforts across the country to fight illicit tobacco and e-cigarette trade. Also at a Commonwealth level, we have advised on the Combating Illicit Tobacco Bill that is currently before Parliament, and there are some other Commonwealth laws before Parliament, including the Anti-Money Laundering and Counter-Terrorism Financing Amendment Bill 2026. So looking from a legislative position in terms of strengthening consequences against this trade. My office also, as well as advising on laws, it administers intergovernmental governance and has a convening power in terms of looking across all of those agencies and brokering a system that is working together, that is sharing information, sharing intelligence, addressing gaps, and maximising the impact of multiple agencies rather than single agencies working by themselves. My office also reports on an annual basis to the Australian Parliament in terms of national data that shows the size and nature of the illicit market, that shows excise evaded, and that shows the enforcement activity across the country. So that is about trying to centralise advice for the Australian Parliament to get a clear view of what's happening across the country.
Can you, in terms of the data that you've collected, are there any indications of that you can use to identify perhaps where future shipments might come through, or is that giving you some sort of pattern about the amount of illegal tobacco coming into the country?
We have commissioned research with the UN Office of Drug Control to do a regional threat assessment, and so those findings will be available later in the year. But there is a number of outposted officers from ABF and Home Affairs that have visibility and are alive to the intelligence of what is happening in different country contexts, and they appraise me of that detail. And so that forms a part of my reporting.
So when do your report annually, when's that due to be tabled in Parliament?
That is due on an annual basis. There is a number of processes that I need to undertake at the end of the financial year to capture the data from multiple data custodians to prepare that report. So I will make it available as soon as practicable once that data comes in.
We know from all media reports and other evidence in other forums that there has been issues in Victoria in terms of pressure put on tobacconists are trying to compete with this illegal trade. Do you also gather that sort of data and work with the state police as well?
Yes, we work with all state police, all state regulation teams, whether that be in the health portfolio or in a gaming and trade business regulation portfolio in different states. There is some different portfolio administered arrangements there. We also make sure that we're engaging with the retail industry leaders as well, so that I have the information from all sources in terms of what's happening at different local levels. I'm meeting with local governments. This is about me engaging with as many entities as I can to get a clear picture and to therefore forge the priorities in which we need to deliver to combat this issue.
I also just want to go back to Border Force. Would you be able to give and you might have to take it on notice, but give us a sense of whether or not there's been an increase over the last decade in terms of the illegal tobacco that's coming in, and also with the drug trade as well, the sort of whether the stats are going up, which I suspect it is. Would you be able to take that on notice and provide to us?
So I can take it on notice for you, Senator, and we'll do our best to make an assessment.
Great. And there's a question from your opening statement that we were discussing between us up here, and that is in relation to ketamine. And obviously 255% more coming into the country. We know from evidence over and over again from different inquiries that Australians are willing to pay a lot more money for their drugs. The concern that we have is in terms of that huge percentage and what impact that is having on domestic crime here in this country, with so much drugs being consumed, what impact that's having with organised crime and crime in our communities, and the impact that it's having in our communities. Have you got a sense, having observed and been in this field for quite some time now?
So, Senator, I share your concern with regards to the lucrative illicit drugs market in Australia and the preparedness of Australians to consume illicit drugs. There are some very dangerous practices in Australia at the moment. One is called kitty flipping, which is the dual use of ketamine and ecstasy at the same time, which is incredibly dangerous for anyone indulging in that sort of practice. So we are deeply concerned by this. The Australian Criminal Intelligence Commission may also have some insights in answering your question, and the Australian Federal Police may also have a position on it as well, but I share your concern.
My final question, before I get wound up, and that is also, it was in your opening statement, and again, very concerning, the amount of child abuse material that's still coming through. And yes, I will be raising that with the AFP and others, because it's a good thing we're reading every week in my home state, someone's been arrested, which is good to know they've been caught, but it just is the tip of the iceberg as to how much material is out in our communities, and the children now that are still being, on a daily basis, being abused, whether it's in Australia or overseas. So has that also increased in terms of what... And isn't that one of the reasons that people have their phone confiscated when they come into the border, is if you suspect that they have that sort of material as well?
Senator, you are absolutely correct. And that's precisely why it is so important to maintain the ability to be able to download someone's digital device. We have an excellent targeting and intelligence division. We have really refined our profiles for individuals who may be involved in the criminality of child abuse, and we are able to identify these individuals when they come back into the country. And as you have seen and rightly articulated, there has been an increase in the number of people that we've seen with these devices. It's the assurance that we are picking them up and removing children from harm, and then moving through with the prosecution of these individuals means that it's an absolute priority for the Australian Border Force, and will continue to prosecute that at the border.
Thanks very much for the work you do. Thank you, Chair.
Thank you, Senator Polly. Senator Dunning.
Thanks, Chair. I'll stick with illicit tobacco. We may as well do this now while you're at the table. I was just going, the annualised reporting that you referred to for Senator Polly just earlier, obviously that's not until your work commences on that, or at least is coming together around the end of the financial year. Do you have a to-date figure on that data, the size of the trade and amount of excise evaded that you referred to? Do you have any data to hand?
No, Senator.
Okay, you expect to have that in June, though? I'll start compiling that in June or July?
Yeah, there's not a static way through the year for us to measure the size of the market with our modelling methodology. We look at annual legal imports. We look at annual wastewater data, and we make an analysis on combustible tobacco, which does not come out in the regular wastewater analysis reports. We have a range of data sharing arrangements with states and territories, different data custodian agencies within them that will provide us some data monthly on enforcement statistics, some enforcement statistics, but we need to do an annual kind of consolidation of all of that. So there's a few different data inputs, and we are unable to do that. We're unable to provide something earlier than what our culmination is in the annual estimate.
And just remind me, when was your office established?
1 July 2024.
And so did you have data 1 July 2025?
So 1 July 2025 was the starting point for having the annual data come in. My report was released in December. There was a number of different data collection processes, data integrity processes, validating our methodology. Some data didn't come in till October. So there's a number of things that come in the months after the end of the financial year.
Okay, and so you expect to have the equivalent report for 25-26 available by December in a similar time frame to the first one?
I won't be able to give you an exact date, but we are undertaking the same process as we did last year.
And is there I'm not sure how your office was established, whether it was by legislation or it's just a policy of government, but did that specify reporting timeframes that you would cause to be tabled in both Houses of Parliament or provided to the Minister by a certain point, or is it just a body of work, get it done, and as soon as practicable, it's delivered?
Yes, under the Public Health, Tobacco and Other Products Act, that's what established my office. It stipulates reporting on data, making data available as soon as practicable, and that report should be tabled within 15 sitting days of providing it to the Minister.
Okay. Now, we did speak at the Illicit Tobacco Committee inquiry, and I asked you some questions around your plans and goals to be set to then guide the work, perhaps, of government more broadly around the reduction of consumption of illicit tobacco, etc. All of those different goals we talked about. Have you furthered that work to develop those goals? Has there been any advancement on that?
What I've said previously is three things. Firstly, that my annual reporting in place has a number of statistics, and that provides the basis for monitoring and analysis and understanding anything in relation to progress on the issue. Secondly, I've said that in terms of what I am driving, I'm definitely working with a number of agencies across the system to reduce the size of the market, to minimise harms to the community, and to reduce criminal entrenchment in the issue. And thirdly, I've said previously that I am working on an outcomes framework. It is not a simple linear metric to be able to easily identify that's why I haven't been able to provide that to you. I can say that we are in the process of engaging states and territories on what those progress metrics might be in terms of being able to finalise an outcomes framework.
So when do you expect to finalise an outcomes framework?
I think I've said previously I don't have a date for when I expect that to be finalised. We are in the engagement process. I will have a better determination on whether what we've put to states and territories needs, or there are other ways of looking at things, or whether there needs some more analysis before we can finalise that. So we definitely are in a developmental phase.
Yes. So, okay. Rather than when do you expect, when do you hope to provide for the country this outcomes framework by which we can measure the success of what's happening and have a proper understanding of whether we are achieving a goal? So what is your goal for developing these goals in a time frame?
I just want to clarify that my goal in reducing the market is not hampered by whether there is an outcomes framework in place or not. This is, we are mobilising effort to make a difference. An outcomes framework will be complementary to the analysis and the reporting that I make publicly to the Australian public in my annual report, which reports on quite a lot of data to make a determination about the issue. So, knowing that those two things are already in place, we are working on an outcomes framework to enrich that process. I hope that that would be in place at a time where we can actually have agreed and accurate, meaningful data, data metric that will describe the progress that is being made. It is not linear, it is complex. This is multiple agencies, multiple points. We can impact the organised crime business model, and that might move and evolve in an unlinear fashion. So it would be preemptive of me to give you a date and a time for when that is ready.
Yeah, look, I mean, you're leading this on behalf of the government, and I'm not asking when you expect it will be done. We tried that. You've told me you're not going to lay a date down, but surely as the leader of bringing this together on behalf of our country to deal with what is a scourge, and no one disagrees with that, you would like to, I don't know, have it done by the end of the year, have those agreements you talked about, so that we can then move forward using the information in these outcome reports. Do you not have something of that nature in mind early next year, this financial year? No.
I think what I've said is that I don't have a date in mind.
So whenever it gets done, it gets done.
I also want to reiterate that it does not hold up any work towards progress.
I hope not, because that would be a very bad outcome. Look, if we can go to the budget papers then, and with regard to the information around tobacco excise receipts falling, have you done any analysis about whether that is because people are quitting smoking or people no longer consuming legal tobacco and instead consuming illicit tobacco?
I think my annual report makes it clear that price differential is one of the drivers of the illicit market. There are a number of drivers of the illicit market. Price differential is influenced by excise settings, pushing prices of regulated tobacco high, but also cheap abundance of supply, enabling illicit brands to sell cheaper. So it is, as I look at all of the drivers for the market and I look at all of the solutions, it is definitely something that I continue to consider. With my analysis, the priorities have been strengthening consequences, maximising interagency capability, continued demand reduction and centralising intelligence and data. Excise has not come out as a priority that appears to me as something that will resolve the issue neatly.
So had you had a look at the most recent budget papers and taken in the data around the reduction? So that hasn't, I mean, you mentioned your last annual report, which was December last year. Are there any advanced views on that, or as at December 2025?
My views haven't changed. I have looked at the budget papers. I have been speaking with Treasury, ATO, all of the agencies involved in this matter. We continue to gather and convene expert views on what's going to tackle this issue. My considerations have not remained stagnant since my report, but they haven't changed.
And just with regard to information, and I'm not sure if it's Border Force or you, Commissioner, that might be in possession of this information, but if we go to the state of Victoria, do we have any data on how many tobacco or convenience stores have been inspected, found in breach, rated by authorities with Commonwealth involvement, had stock seized, has had licences suspended or cancelled or been permanently closed? Is that something either entity at the table would have information on?
So, Senator, I don't have a summary of the Victorian government actions in relation to tobacconists. We do work with the Victorian Police Force, Victorian licensing and health authorities post the border. We could absolutely take on notice through the work of the National Disruption Group what we have done with Victoria.
Yes, on notice, in response to those specific, if it is information available in line with those, that would be helpful. Just for my own comfort, while you don't have it at the table here, it is the kind of information that ABF and the Commonwealth would have available to it fairly readily, yes?
So we can work to get that for you, but the state
on notice
material,
is fine, but I'm just, in terms of operationally, it is a nationwide Commonwealth-led approach, and I don't know whether that did, yes.
Yes, certainly.
We do have data sharing arrangements with Victorian Government and all state territory governments for monthly data to come through to my office in terms of enforcement activity in that state.
Okay, so the Commissioner of the Border Forces is going to take that on notice. Is it something better?
We can work together and provide that detail.
We work very collaboratively together.
I should hope so. It's an important part of this week's interrogation. Okay, I wanted to go back to NZYQ, if I can, please. And my question is going to go to the High Court decision in March of this year relating to the existing ankle monitoring and curfew arrangements. And I suppose if I could start by asking how many of that cohort were directly affected by that decision?
Senator, on the 18th of March, when the judgment was handed down, there were 82 individuals affected in total. 40 of those had electronic monitoring and 42 had both electronic monitoring and curfew, which meant that those conditions were removed. And they were no longer subject to those conditions. Okay, so just in summary, and I know each case is different and we certainly wouldn't talk about individual cases, but why were those conditions put in place in the first place? So as part of the, they were both discretionary conditions on the bridging visa Rs. And when a delegate considers the discretionary conditions for a BVR at the time, they considered whether those conditions were necessarily appropriate and proportionate to community protection. So they would have looked at the individual case, circumstances for each individual, and determined if electronic monitoring and/or curfew were reasonably necessary to ensure that community protection element, taking into account the range of other visa conditions they were subject to and their personal circumstances. Okay.
The regulation itself is very prescriptive, or the regulation that was in place that the court considered and took into account a real notion of reasonably adapted and appropriate to the risk of community offending or to community safety.
Yes, okay. And so elements like criminal history, etc., are the things that would be taken into account by a delegate in making, or a decision maker in applying a condition.
A whole raft of, yes.
Amongst other, yes.
Yes, that's right.
Okay. So in total it was 82, yes? Was that right?
That's correct.
Across the, yes. So they are now without monitoring conditions imposed. But what has happened by way of, what's been put in place to monitor in any way that cohort that were deemed appropriate to have such a condition, or either of those conditions applied to their bridging visa are? Like, is there anything in place now, given the concern that was noted at the time necessitating the conditions, and now they're being knocked out by the High Court?
Yeah, so to confirm, electronic monitoring curfew were only two measures that we had in place to manage this cohort. There were a range of other measures in place and have been since the High Court ruling. That includes regular engagement with the individuals, a range of other mandatory visa conditions around reporting requirements, ensuring they tell us information. A lot of those are subject to criminal penalties as well if they are in breach of those conditions, as well as support services for the cohort to connect them to rehabilitation services, health services, etc. So quite a vast array of measures in place to both support the cohort and manage the community safety risks. With the cessation of electronic monitoring and curfew, what we have done is increased our engagement with the cohort. So in particular, there's a visa condition 8401 around reporting requirements. Where someone does not have electronic monitoring, that visa condition becomes mandatory and they are required to report to us at a specified date, time, place, etc. And that has ensured that we have regular managed engagement with the cohort to understand their circumstances and any risks.
Why was it deemed appropriate to have these conditions in place if now just the High Court have made their decision and knocked it out? It is no longer applicable or a pathway that we can follow. But we are satisfied with the arrangements that I gather would have been in place, these other elements you talk about relating to engagement, reporting, etc. Why did we determine we needed the monitoring and curfews if we're satisfied not having them now?
They provided additional measures for us to use to assist with our engagement with the cohort and our understanding of what they were doing and potential harm to the community or risk.
Yes.
It gave us another lever, another mechanism to assist with our management. In the absence of them, again, we have other measures in place and we've increased those measures where necessary to just maximise our, as I said, engagement in that assessment of risk and understanding of risk. Noting that EM and curfew are no longer available to us.
Yes, indeed. And so, obviously, electronic monitoring is a 24-hour-a-day thing. You can't escape an ankle bracelet. And curfew monitored in all cases by the bracelet, is that right? So a curfew, you had to be at a certain address by a point in time. Did everyone who had the curfew condition have an EM?
No, Senator, there were cases where individuals just had a curfew condition imposed and not electronic monitoring.
Okay.
And that number varied over time.
Sure, yes, I know it's not a static thing.
Daniel, can I share the call if that's okay?
Sure. Why not?
Thank you. Senator Shoebridge can take us to the lunch break at 12:45.
Thanks very much. I was going to ask some questions about the payments that have been made to Nauru and particularly what's shown up in the most recent Nauru documents about where Australia's money has gone. Nauru published a supplementary appropriation bill number 5 in March of this year, and they referenced the spending 2 in their Nauru bulletin of the 20th of April, where they noted that the supplementary appropriation bill, which puts a further $31.5 million onto the Nauru budget, was funded by revenue provided by Australia under the third country resettlement arrangement. Is that right? Did Australia give Nauru $31.5 million?
Yes, Senator. Earlier in March, Australia settled the payment into the Nauru Trust Fund number 2. That was a payment we have spoken with this committee before about. It was a payment that went into the trust fund from Australia of $388 million. Within that payment of $388 million, there were 2 streams of funding. There was the core payment that goes into the trust, that was the establishing contribution, and there was a payment that was the equivalent of the year 1 amount. That second component was valued at $63 million, and it was open to Nauru to choose to draw down some or all of that first payment, that payment of $63 million, to recognise its costs and also it's the way the payments are set up. It is available for Nauru to use it both to manage the costs of the cohort as well as to support Nauru's general operations. And the $31 million you reference is a component of that year 1 payment of $63 million.
So when was the trust officially established? Under which law was the trust established?
Senator Ben Biddington, Assistant Secretary, Offshore Programs and International Cooperation. So the trust was established under the International Organisations, Privileges and Immunities, Nauru Trust Fund number 2 regulations, which commenced in November 2025. So that regulation has the effect of giving the trust separate legal personality.
All right. And under that trust, are there trustees appointed to the trust?
The trust is managed by a committee, and so as much as we're using the words trust, it's to be understood in the sense that the trust itself or the committee is set up via an MOU, so it's a trust MOU, and it's the Act, or the regulations rather, that give separate legal personality to this international organisation.
Well, it's described as an international organisation. Is it regulated under Australian law or regulated under Nauruan law?
It comes into existence by virtue of the Australian regulation.
So that regulation you referenced, the November 2025 regulation, that was under which legislation was that passed?
It's the International Organisations Privileges and Immunities Act, I believe.
All right. And does the regulation identify the members, I refer to them as trustees, but you say they're committee members, is that right?
That's correct.
Does the regulation identify the membership of the committee?
No, it doesn't.
Where would we find details about the committee that's oversighting the $388 million of Australian taxpayers' funds?
The committee is appointed pursuant to the trust MOU.
All right. Now, I'm going to ask again for a copy of the trust MOU.
Thanks, Senator. We took that one on notice when we were at a recent committee hearing. We're currently consulting with the Government of Nauru to check whether they're comfortable with the provision of the MOU to the committee.
All right, but the department has a copy of the MOU, obviously.
Of course.
Okay, are you going to take on notice whether or not, so I'm asking you to provide a copy, you're taking on notice whether or not you're going to make a privilege claim on it?
That's
or
correct.
Provide it?
But I guess I'm trying to give you assurance that we're actively progressing your request from a couple of weeks ago when we took it on notice. But yes, we will take it on notice again.
Can you identify, you said that the trust identifies does the trust identify the actual committee members, or does it identify the size of the committee and who appoints the committee?
It identifies all of those things.
So there are named trust members, are there? Are they named by office, or are they named by their individual names?
So the document, Senator, provides that an appointee is to be made by the Australian government and by the Nauru government respectively, and then those appointments occur under the authority of that document.
So it's a two-member committee, is that right?
That's correct.
One appointed by the Australian government and one appointed by the Nauru government.
Yes, Senator.
And who in the Australian government is tasked with making the appointment?
Senator, we have given evidence on this, I think, at the February estimates, and at the February estimates, the Secretary, I think, confirmed that she had appointed Mr Biddington in his capacity as First Assistant Secretary to be the Australian government representative.
Right. And who is your counterpart, Mr Biddington, from Nauru?
Senator, it's the Secretary of Finance.
Which is?
Mr Damon Adiang.
All right. Sorry?
Mr Damon Adiang.
All right. And how is Mr Damon Adiang related to the current president?
My understanding is he is the President's son.
The President's son.
But relevantly for the purposes of the arrangement, he's the Secretary of their Department of Finance.
Yeah, and who's the Minister for Finance in Nauru?
I understand it's the President.
Yeah, so the President's son is the Secretary of his own department, and the President's son is also the trustee under this trust.
That's
correct. Right? Correct?
That's the evidence we've just given.
And interestingly, when you read what happened to the $31.5 million that came out of the trust, I assume you approved that payment, Mr Biddington, is that right?
A disbursement from the trust. Yes, Senator.
Yeah, is there a difference between a disbursement and a payment?
Practically no, Senator.
Yeah. You approved that?
The committee jointly approved that disbursement.
You and the President's son approved it?
Yes, myself and the other committee member.
And then when you look where the $31.5 million went, well, $22 million went to the Finance Department, which is, he was the President's son, your fellow committee member is the secretary of that, correct?
Senator, the decision about how the Nauruan government decided to use the funds dispersed from the trust is a matter for the Nauruan Parliament.
Well, 1.8 million of it went to the presidency and the State House. That's your fellow trustee's dad. 1.8 million went there. Another 2 million went to the Chief Secretary office. Is there any requirement for checks of conflicts of interest on this trust body? Is there a requirement that the trustee act not in conflict of interest?
The Trust Fund Committee are required to ensure that the payments are made consistent with the terms of the trust and under the arrangement and consistent with the third country reception arrangement. Under that, Nauru has committed to us that it will consider visa application requests, and if it grants visas, it will ensure that individuals who are removed to Nauru are granted a 30-year long-term stay visa. They will have access to housing, healthcare, work rights, and in exchange for that arrangement, the Australian government has settled the trust.
Yeah, but my question was, are there any conflict of interest provisions in the trust so that neither trustee, neither member of the committee can make decisions that are in their own interests? And in this case, the President's son in Nauru agreeing to a disbursement, $22 million of which goes to the department that he is the secretary of and his dad is the minister of, and another $2 million going directly to his dad's presidency and State House. Are there any provisions that prevent those kinds of conflicts of interest happening?
So Senator, there's probably two aspects to that. One is that the trust MOU requires the committee member owing a fiduciary duty to the trust, so to the entity that they manage. And really that goes to the investments that the trust will make, protecting that investment for the benefit of Nauru. The other component relates to the clauses by which money would be distributed from the trust, and then that goes effectively to the purpose of the trust to maintain the TCRA arrangement.
Well, my final question before we go to lunch is, are there conflict of interest provisions covering your role, Ms Biddington, on the trust?
I'm not sure I understand the question, Senator.
There a provision in the trust, however it's done, that says you may not have or act where there's a conflict of interest. You must avoid conflicts of interests. What I would have thought would be a boilerplate provision in any trust.
Senator, I don't believe it's in the trust, but it's caught within the provisions that the committee has implemented. And so as a matter of practice, for any committee meeting, both committee members would make a conflict of interest declaration as part of that meeting.
Well, did the President's son indicate to you that when you agreed to a $31 million disbursement out of the trust, did he indicate to you that $22 million of that was going to the department that he's the secretary of and that his dad's the minister of? Did he indicate that?
Senator, there's sort of a different process that the Trust Committee was following, in the sense of following the Trust Committee document and the fiscal procedures for the purpose of dispersing funds to support Nauru for the TCRA.
Well, I'll take that as a no. Am I to understand that as a no? Because that's how I'm hearing it. Is that a no, Mr Biddington? You're the person who was in that meeting?
Yes, that's correct, Senator.
All right. We might come back to this after lunch. Yep.
Thank you, Senator Shoebridge. We will now suspend for lunch and we'll return at 1:20. Thank you. We will return from the lunch break. Senator Roberts.
Thank you, Chair. Thank you for appearing again today. Good to see you. Minister, these questions are built on an extensive session with constituents in Queensland. One in particular, well, several, but one in particular has followed all the rules for importing parts for gel blasters, but still being refused access to necessary gel blaster equipment for his business and personal use. He's done everything, and Border Force confiscated one shipment and destroyed the goods, and they sent the other shipment returned to sender. He's had no problem with the Queensland weapons licensing who approved the purchase. He and many others within the hobby industry and the industry, small business, believe the industry may be at risk due to the amendments to the Prohibited Imports Act 1956 and Combating Anti-Semitism and Hate Speech, Firearms and Customs Act 2026. They're confused. So I'm hoping to get some clarification.
Sure. I'm afraid, Senator Roberts, that's probably a level of detail I'll need to get the officials to respond to about the exact prohibitions.
Yeah. Yep. I was just making you aware of the context, then asking the officials questions. Well, first one is to you, Minister. Can the Minister confirm how skirmish sporting equipment, including gel blasters and paintball markers and their parts, are intended to be treated under the revised import framework? Or if you have to go to officials, that's...
Yeah, I might get the officials to speak to that.
Senator, we'll do that for you.
Senator, thank you. Tony Smith, Acting Deputy Commissioner National Operations. Senator, I can speak specifically in terms of the Australian Border Force's actions at the border in terms of administering the prohibition. At the level of detail that you're talking about in terms of the actual legislation itself, in terms of the background behind the legislation or what the legislation has brought forward, I might have to take that on notice. Can I just check, Senator, is it the actions of the ABF that you're looking for?
It's broader than that. It's the interpretation, because people are confused.
In terms of the administration for gel blasters at the border?
You see the questions that I ask. I've got quite a few.
Okay. I may have to take the specific details on notice, Senator, but as broadly speaking from the Australian Border Force perspective in terms of changes to the legislation, we would work within the parameters that have been defined as to what a prohibited good is. And I can only assume that the case that you're talking about, the goods themselves would fall within the parameters of being a prohibited item, which is why they're being seized at the border.
That's correct.
So the detail in relation to the legislation itself as to what it is and what it isn't, I might have to come back to you on notice in terms of the details, in terms of any complexity with that question.
If you could, please, and maybe add to that the subsequent answers to questions. Because Absolutely. I think we're heading down the same line of questioning. Given these items are defined within the legislation, can the Minister or officer clarify how those definitions are being applied in practice across the Combating Anti-Semitism, Hate and Extremism Firearms and Customs Laws 2026 and the Customs Prohibited Imports Regulations 1956?
So, Senator, in terms of the firearms laws combating anti-Semitism, hate and extremism that achieved its royal assent on the 21st of January, the Act strengthens the firearms import controls. It strengthened the permissions, the limitations and the ministerial discretion in relation to the way those laws are managed at the border. They do provide specific detail in terms of the parameters of what falls within and constitutes that legislation. And again, I'll have to take that on notice in terms of what specifically the questions that you have around what the concerns are by the constituent.
Okay, thank you. And it might help if we can put the constituents concerned in contact with you.
That would be good. Thank you, Senator.
What clear practical guidance, I think I know the answer to this now, what clear practical guidance is being provided to ensure lawful individuals, these people are not far-right extremists or far-left-wing terrorists, and to ensure lawful individuals and businesses can consistently interpret those definitions and remain compliant under the new framework? Is there a guidance?
Frameworks from the Australian Border Force perspective are provided through the internet sites in terms of where our pages, our web pages, will provide details.
Border Force website?
That's correct. Also, our engagement with industry across a number of different levels, working across different industry partners to ensure that any further details are published in Australian notices that go out through our industry partners.
Thank you. What's the intended lawful pathway or steps that businesses and individuals need to take to remain compliant under the new import requirements? Is that laid out anywhere?
It would be, I think it's fair to say, Senator, that we maintain a strong line of communication with any individuals that may have questions in relation to trade matters. So we have specific areas within the Australian Border Force who engage with importers that may be seeking clarification in relation to whether goods have fallen within the parameters of being prohibited. And those mechanisms are available, again, through our intranet sites.
Will guidance be issued to clarify how this framework is to operate in practice?
Guidance continues, Senator, in terms of how the Australian Border Force administers that legislation at the border. In terms of the specific legislative framework, that may sit outside of the Australian Border Force, potentially with other agencies such as Attorney General's Department or others that administer the framework.
Does the government accept that, this is a question for the Minister, does the government accept that lawful operators are currently unable to determine how to comply?
Sorry, Senator, could you repeat that?
Sure. Does the government accept that lawful operators are currently unable to determine how to comply? There's a real problem there.
Well, I mean, as you've heard from the Acting Deputy Commissioner, there has been guidance material provided, but I'm sure that the officials will take on board what's been said today, and if there's ways that that can be further clarified, I'm sure they'll do that.
And Senator, it would be very helpful to put the constituents in touch with Border Force so that they can hear directly and try and work with them.
That's what I asked Mr. Smith about.
And Senator, we're very happy to put more material online to assist people looking to lawfully bring these items into Australia.
Okay, thank you. I'm just checking. I think we can skip several questions now. Is there an approval pathway? Do you stamp approval on goods, on applications, or do you just confiscate them or send them back?
Senator, there'll be two streams that are administered at the border. We look at our first response at the border for goods that we identify as part of our examination. Equally, we have streams that look at our pre-clearance intervention. So that's when we have teams that look at the specific documentation, what's been declared, the appropriate permits to ensure that what is coming through the supply chain has been validated before it arrives in the country. So we have teams focused on trying to make sure that if there is legitimate entry permits in place and that the goods sit within the parameters of being a legal item, then they are facilitated as quickly through the border as possible. Where there is any confusion in that, whether that's from a pre-clearance perspective, such as the documentation isn't clear and it requires clarification, those goods are held pending further information from the importer. And equally, when goods are identified at the border subject to our examination, if they do not have clear documentation to support permit entries, then they are held pending further details from the importer.
So this one of the constituents said that he had all the permits necessary, but one shipment was shipped back and the other shipment was confiscated and destroyed. Does he have to get any clearance from you beforehand?
Senator, it probably goes to the earlier conversation and line of questioning that you had. There are very specific details that maybe if we discuss with the constituent themselves, we can get clarification around that answer.
Minister, has the government considered the needs of stakeholders involved in structured skirmish sports and related activities when developing the current framework? I know the legislation was rushed for the reasons the government made clear, but
I believe that we did consider that, yes.
Did you consider the skirmish industry specifically?
I'm sure, I wasn't directly involved in that, but I'm sure that that was given consideration.
Could we get on notice the names of groups, not personal names, but the names of groups that were consulted?
Happy to take that on notice, and I might just ensure that that answer also reflects what other consideration was given aside from meetings with stakeholders.
I noticed, and this is not being critical, it's being complimentary, I noticed that you said you didn't know for sure, but you'd get back to me.
Yeah, I'll take that on notice.
That's good. If stakeholder needs were not fully considered, will the government commit to engaging with affected groups to ensure the framework is clear, practical and workable? In other words, will you do a review?
So, Senator, I think we probably need to understand what the scope of the problem is.
Right.
And we will then establish whether or not there is a problem of a nature that needs a review, whether there are things we can streamline, or whether in fact the government's intent is being implemented. And this may not be helpful, Senator, but my understanding is that essentially there were different approaches to gel blasters in different states. And what the legislation did was essentially mean that people who wanted to import a gel blaster needed both a licence, like a firearm licence, but a licence for the gel blaster and an import permit. So it may be that if we work through with your constituents at what is missing in the framework, we might be able to remedy it.
Has any assessment been undertaken on the economic impact of these changes on small businesses and associated employment?
So, Senator, when we were developing the legislation, we certainly had discussions, most particularly in Queensland, because that's where most of the gel blaster industry was centred.
Mm-hmm.
And so there was a consideration of the impacts as we were preparing the legislation.
The economic impacts?
That's right, Senator, and the impacts on the businesses.
That's good. What impacts were identified?
So, Senator, we were aware, as I said, that there were I want to say a sort of a grouping, particularly in Queensland, of industry that would be affected, and so that was one of the things that we took into account as we were developing that.
Did you develop any specific or quantify the size of the impact economically?
Not to my memory, Senator, but I'm trying to answer these questions for you because it was one of the earlier outcomes. So I'm doing this very much from memory, not having been sort of personally involved in the work. So the level and extent of the work that was done is not something that I can recall, but we can get you that on notice.
Thank you. Secretary or Minister, if there's a need for it, will any transitional provisions be considered for existing businesses and lawful participants affected by these changes?
I'm sure there'd be someone who could speak to whether there are transitional provisions in the legislation.
Even better.
So, Minister, I don't believe we did include transitional provisions in the legislation.
I don't think so.
And I'm also advised that we did provide some analysis on the impact, but not a formal impact assessment. You'll recall it was a pretty pressured period when we were doing this work. What we were trying to do was actually understand and highlight the impacts so that government could make an informed decision.
I appreciate your openness and honesty there, Secretary. If current operators need, could they get clarification on or transitional provisions on how to manage stock, employment and ongoing operations? Because they're confused.
We'll certainly, Senator, perhaps include that in the earlier undertakings that my colleagues have made in terms of the import and permit issues. I think it would be helpful if we wrapped this up as a package of advice.
Should these constituents go direct to someone or just follow the website?
They're welcome to come direct to the Australian Border Force and we'll assist them as we can.
So
is there any name within the Border Force?
I think Acting Deputy Commissioner Smith would be happy to receive representation, Senator.
Just one last question.
Sure.
Thank you. Minister, I'm not asking for a mea culpa, but does the government acknowledge the risk of unintended economic and community impact in the absence of transitional guidelines?
Well, I mean, I guess the government made a decision that, especially after the dreadful anti-Semitic terror attack in Bondi,
agreed,
that action needed to be taken urgently on what we described as the motive and the method for that attack. And that's why we brought in legislation that addressed the motive being anti-Semitism and hate speech and hate crimes, and also brought in legislation to address the method, which was those firearms that I think most people would agree should never have been in the hands of those individuals. And so that is why we took the action that we did. And I understand that not everyone is pleased about that, but we don't back away from the need to take that action.
So with any legislation, there's a risk of unintended consequences. With almost all legislation, there's a risk of unintended consequences. So you have consultation and then review afterwards. Consultation before and review afterwards. With the rush legislation, and I'm not being critical, because you've just explained there's a need to balance urgency with the risk of consequences. I acknowledge that's a fine consideration. So there is a risk of absence of transitional arrangements.
Senator, let me take on notice. Often, as you know, we build into legislation a review.
Mm-hmm.
Let me see if there is such a thing or what our intent is. I would just note also, Senator, that we haven't in the legislation banned gel blasters. They have been regulated in a way that they weren't previously in some states. And so I am hopeful that we can find a way to work with affected parties in that regulatory framework. It would be a different matter, of course, if they had been banned and there were no options for people going forward.
Yes, and I thank you. You hit the nail on the head. I think you've hit the bullseye, because people are concerned that either the legislation was an attempt to ban gel blasters or it's a precursor to banning them. So I don't think that was the case. But
that's not the case. You're right, Senator, and that's one thing that you could immediately take back to the constituents. The other thing that might be helpful is we are setting up a firearms council, which with the express purpose of consulting, and I'm not sure if you were here yesterday when we were working through with Senator Mackenzie the very broad range of groups that we have been consulting with. She was obviously concerned to make sure that we were including, industry, legitimate firearms holders, people with other legitimate uses. I think this could be very helpful in the context of the regulation of gel blasters as well.
Okay, thank you. Thank you, Chair.
Thank you, Senator Roberts. Senator Duniam.
If we can just finish off on those questions around the NZYQ cohorts that we were dealing with before lunch. So I just wanted to get an understanding of, in terms of the increased engagement, and you've talked through what versions of engagement exist. For example, though, how often would one of these individuals need to report to authorities to comply with the requirements?
Senator, will depend on the individual, so it ranges anywhere from daily to a less frequent time period. Some of that might be in person, it might be attending an office or a location, it might be through a phone call, but it varies depending on the person, and each case is assessed individually.
Okay, so I'm just interested though, because as discussed, anyone who would have an electronic monitoring bracelet on their person, clearly it was deemed that it was best to have 24-hour knowledge of where this individual is, and then stepping down to a curfew, I suppose. But anyone who had a bracelet, is there a standard reporting requirement across those members of the cohort who had the bracelet?
Senator, many of them would have had daily reporting imposed by the delegate, but it's really important when you're thinking about how this visa operates that we can't use it in a way that's punitive. So we have to assess each case and consider whether how the conditions are working to make sure the combination of conditions imposed on that person are adapted to the risk. So we can't say, yes, every single person who would have had electronic monitoring definitely has daily reporting. We work through, in a pretty detailed way, their risk profile and work out what combination of the conditions that are lawfully available to us will be the most effective. So in this case, many of them probably did have daily reporting imposed, and that can change over time too. If there is, for example, if somebody was assessed as higher risk and then they successfully transition, they get a job, they're living in the community, they've got no other offending, that could change over time, their risk profile, and their reporting requirement would follow.
And then to be clear too, Senator, non-compliance with that condition carries a criminal penalty as well. So they are required to attend or to speak to us when directed. Otherwise, they face criminal penalties.
Perhaps on notice you could just provide me some detail of the individuals that had the electronic monitoring condition. Just a number, how many have daily or had, I know that things may have changed, as best we can get this detail, daily reporting requirements and every other level of frequency. Would there be any that have weekly reporting requirements?
There could be, Senator, but we'll take that on notice and confirm the frequency of that cohort.
Yes, I'd appreciate that. Thank you. Just then quickly to the Nauru deal, are there any updates on numbers?
There are, Senator. There are currently 12 individuals who've been removed to Nauru pursuant to that arrangement. There are a further 36 individuals who have been granted a visa by the Government of Nauru and are in immigration detention in Australia awaiting their removal.
And do we have any updates on expenditure related to the deal?
Yes, Senator. So as we were talking with Senator Shoebridge, in March this year, we made the payment into the trust. That was a payment of, I'll just get my figures, $388 million paid into the Intergenerational Trust Fund. Mm-hmm. And that funding, as we've talked about previously, then the majority of it sits in the trust starting to accrue interest, and there is a proportion of it that can be drawn or can be dispersed out this year to cover first year costs and the amount owed if Nauru choose to take it out, and then thereafter payments will be made into the trust from year 2 onwards.
Yeah, okay. And those payments into the trust from here on in are structured around further arrivals, is that correct, or is there a timeline?
A payment from year 2 onwards of between $63 and $73 million per annum will be paid by Australia pursuant to the arrangement.
Okay, and so just the 36 people that have been granted a visa, that is different to the group of people identified by Australia as the proposed persons group, is that correct? So people...
That is different.
Okay, so how many are on that list?
Senator, that's very much a point in time. So figure I don't have with me, and we have to date sought to claim public interest immunity. Sorry, the Minister has sought to claim public interest immunity over the rate at which we're applying for visas. Because each time if somebody has a visa granted, we need to conduct a fairly sensitive operation to locate and detain them.
I'll ask the question, could you take it on notice?
Certainly.
We'll go through that process. And do we have a number of anyone under that proposed persons list that has not been accepted by Nauru?
Senator, there are a number of visa applications with the Government of Nauru that they haven't accepted or declined yet. But to my knowledge, Nauru have not declined any. There have been, and I think one of my colleagues gave some evidence in the committee hearing into offshore arrangements a few weeks ago, where we described it as Nauru hadn't agreed yet. What Nauru is doing in some instances, or in fact in all instances, is upgrading its service offering, particularly its healthcare.
Yeah.
And its ability to manage this cohort. So for some of the more challenging members of the cohort, Nauru aren't saying no, but they're saying not yet.
Sure. So no one's been declined that we know of, and there are people in the system, and any information on those gratefully received. Are there people that have been sidelined from consideration, that were in a stream of consideration and somehow have come out of that?
Senator, much like there is a substantial cohort. We are working our way through the cohort. We're very interested in ensuring this arrangement is sustainable in a long-term way, and you can see that by the sort of steady rate at which people are being removed there. And so, in the same way, we are working our way through the cohort, pretty methodically. I don't think I would say people are sidelined so much as just there is a prioritisation.
Okay, and how do you determine the prioritisation of the cohort? Is it based on seriousness of offence? No.
Yes, Senator, it's not based on seriousness of offending. Every person who's within scope of this arrangement has failed the character test and has no right to remain in Australia.
Mm-hmm.
So there's no further consideration. That test has already been failed when their visa was cancelled.
So how do we prioritise then, as you said?
As I was just talking about, the level of services on Nauru is one consideration.
Right, okay. If they require them then, and are there other considerations?
I think broadly speaking, Senator, it's captured in Ms Sharp's characterisation of our desire and Government of Nauru's desire to make this arrangement work in a sustainable long-term way.
Mm-hmm.
And so we will consider everyone on a case-by-case basis to say, do we think that meets that overall objective? And that could be any number of factors.
Yes, so, and that is rather nebulous. The point was made that there is a prioritisation, and in my mind that strikes me that there are some who, and I accept the point around if there is a health service that's available for people with certain conditions, then they might end up at the top of that list, for want of a better description. But are there key criterion that we work through to establish who we will apply for first, or beyond the service provision element? Do you want to take it on notice?
I think it is better that I take it on notice.
Perfect. Can I ask about
Is now a good time to rotate the call if you're going to move on to a different topic?
I am, yes.
Excellent. I will use this opportunity to return the call to Senator Roberts.
Thanks, Chair. Now that this is about wind turbines that have been imported into Australia containing asbestos. Now that the asbestos in imported wind turbines has been identified, what's been done to remedy the problem and prevent recurrence?
Yes, certainly, Senator. So the issue was asbestos in the brake pads, on the lifts inside the wind turbines. What we put in place was we call it a profile on the border to look for these products. Between the 1st of December and the 1st of April, the Australian Border Force recorded 42 consignments matching against profiles introduced to target asbestos risk because of that wind turbine issue. Of the 42 consignments, 35 were cleared by risk assessment of the documents by ABF officers. The Australian Border Force referred 4 shipments for laboratory testing. All 4 returned negative results and were subsequently released. The remaining 3 consignments are, as of the 1st of April, held pending provision of further assurance documentation. So we're actively managing that risk on the border.
Are you actually inspecting the wind turbine brakes when they come in? Or is it just done by risk assessment?
It's both. So we'll make a determination based on that initial risk assessment, and then where required, where we have concerns, then we'll refer those for the testing.
And who does the testing?
So I don't have the name of the laboratory, but it is a nationally recognised laboratory.
So your officers go to the site where the turbine brakes are stored pending clearance, and then, if necessary, notify the testers.
So what we'll do, Senator, is that we will provide a direction that that consignment is to be tested, and then the consignment will go to the laboratory to conduct the testing, and then depending on the results, we may seize that particular consignment or it will be released.
How did this problem slip past the Australian Border Force?
So once we became aware of it, Senator, we were absolutely onto it. We've been testing for asbestos over a number of years. Now, how these particular brake pads made it into the country, I could not tell you. What I can tell you, however, is that for any individual, there is a $330,000 fine, or 3 times the value of the goods. And for any companies who are deliberately importing asbestos products without a permit, it's a fine of $1.65 million, or 15 times the value of the goods. So there are significant penalties under the customs regulations for bringing asbestos into the country without a permit.
Okay, so an importer of wind turbine brakes could just look at that and say, what's the risk assessment involved here? What's the risk of getting caught? If it's tiny, then it's worth flouting, trying to flout the fines, because they won't get fined. So they'll do a risk assessment the other way.
What I'd offer to you, Senator, is the fact that we have intervened with 42 consignments which came into the country in that 5-month period between the 1st of December and the 1st of April would indicate that we're absolutely applying all that we can at the border to look for asbestos coming into the country, including for the wind turbine lift brakes and any other asbestos product.
Subsequent to them coming in without detection and being put into operation, and you can't tell me how that slipped past you. So if you can't tell me how do you know that what you're doing now will get it all? Because I can understand you can't possibly inspect every piece of equipment, every good, every item that gets imported on individuals, on major shipments, commercial loads. So you have to use some kind of intelligence assessment and a risk assessment. I understand that. So how can have you changed practices?
Yes, Senator, that's precisely what we have done.
With the 42.
That's exactly it, Senator. So because we recognised that there clearly were some asbestos products that made it into the country, we doubled down on our efforts to reduce the risk of any asbestos brake pads for wind turbine lifts getting into the country. And I think the figures I've provided for you demonstrate that we are being effective in getting after it.
I'm wondering how many other lapses there are, not just wind turbine brakes, but in this, coming back to this case, was there an offence committed by the importers or the purchasers by misdescription or omission?
Senator, you'd need the details of the importers for those particular lift brake pads. so I don't have that for you here. I could take it on notice if that would be of assistance.
If you could, please. I'd like to know if it was deliberate or sloppiness on the part of the importer.
Certainly.
Thank you. Have all contaminated wind turbines had the problem alleviated, Minister?
Well, I don't know that I could sort of give you a across-the-board answer. I'm not sure if the Commissioner has any further information on that.
So, Senator,
would that be your responsibility? I would have thought.
No, that's a state responsibility to deal with that issue.
How can I go about finding that out?
Well, you've got some MPs in the South Australian Parliament. That might be a good place to start.
And WA.
Oh, yeah, I forgot about that.
And soon New South Wales.
Not sure they agree with you on fracking and a few other things, but anyway, that's another issue.
Always listening to constituents, Senator Watt. We don't just go blanket.
Drill, baby, drill, except in South Australia.
Thanks.
Except in one
electorate.
electorate.
Questions that'll be really helpful. No, I'm not here for the entertainment.
I'm just going through my questions. The Commissioner has answered most of them. What penalties or fines have been assessed for identified breaches? Oh, you've already told me that the heftiness of the fines. Have any been levied on the importers who've been caught?
So, to date, Senator, all of the consignments that we have reviewed and where we've referred them for testing, they've been found not to have contained asbestos.
Okay. What about the ones that have been found and were in operation?
And I'll do my best for you, Senator. I'll take that on notice and I'll do my best to answer that question for you.
Thank you. In general, Commissioner, you're there to apprehend illegal goods coming in illegally?
That's right.
If they get through the border and put into operation, who is responsible for enforcement then? Is it someone else or is it you?
So we can still apply the Customs Act for goods that have made it through the border.
Thank you. Do you have any prosecutions outstanding?
For asbestos-related
Yes.
issues? Not to my awareness, Senator.
Is anyone prosecuted for the ones that were discovered in operation?
So I think that is something that we can take on notice for you.
Okay, thank you. So self-assessment of components by the importers is appropriate given your limited workforce and the extent of imports coming into Australia, not only the extent in terms of dollar value or weight or volume, but the complexity of things today.
So all importers have responsibilities as far as ensuring that they meet the legal requirements for the importation of goods into Australia, but we will conduct compliance checks on any goods over which we have a suspicion that it may be an illicit or a prohibited product.
So your ways of protecting the borders, keeping the borders secure, is to do inspections, but that can't cover everything, so you use risk assessments, put responsibility onto the importers, and then try to protect that with hefty fines if someone's caught, to make the cost of doing business prohibitive. To make the cost of criminals or illegal importers being prohibitive.
That's a good summary, Senator.
Thank you, Senator.
When I retire, I'll come and get a job with you.
Thank you, Senator Roberts. Senator
There's a
Shoebridge.
merit process, Senator.
I'll pay that one. You were rejected, were you?
I thought you were going to ask me to be a referee.
Thank you. Full of comedians today. Senator Shoebridge.
Oh yeah, thanks, Chair. I was going back to the trust. Ms. Benedin, are there minutes kept of the trust meetings? And by trust meetings, I mean the meetings formed. You describe it as a committee. However, But those committee meetings, that's what I mean when I say trust meetings. Are there minutes of those trust meetings kept?
Yes, there are, Senator.
How many such trust meetings have there been?
To date, there have been 9.
9. Can you provide to the committee the minutes of the trust meetings?
Senator, I need to take that on notice for the purpose of considering a PII claim.
All right. What have been the... why 9 meetings for the trust? Were they meetings to consider the arrival of, the 400 odd million from Australia and then the disbursement of the 31.5 million to Nauru? What were the 9 meetings for?
Senator, in starting up the trust arrangement, the committee needed to come together and work out a whole range of processes as to how it was going to work. So the committee had, if you like, a higher schedule of meetings than it will probably have into the future as the trust is established. So those meetings went to a whole range of matters, including the committee coming together, fiscal procedures, processes by which the committee would work, broader arrangement about the administration of the trust itself.
Now, where's the money held? Is it held in Nauru? Is it held in Australia? Is it held in some third country?
So, Senator, the trust fund itself is invested through a provider. That provider is in the process of converting effectively cash into investments, and then the trust committee will oversight the management of those investments.
And is the provider based in Australia? Is the provider based in Nauru? Is the provider based in a third country?
It's through Mercer, Australia.
Mercer, Australia. Are there ethical investment guidelines for the trust?
Yes, there are, Senator.
Does it prohibit investment in weapons, asbestos, tobacco? What are the...
I don't have the specifics of all of those requirements in front of me, but it has been of interest to the trust committee members, and it would also include things such as environmental considerations for ethical investing.
Can you provide details of the investment directions?
Again, Senator, I'm just cautious that I'll need to engage with Nauru on the matter, so I might take that on notice for the purpose of considering PII.
The material produced by Home Affairs about the trust states, right on the front page, the purpose of the fund is to provide the government of the Republic of Nauru with an ongoing source of revenue during the fund period to fund its participation in the third country reception arrangement with Australia. Is that the purpose of the fund?
Yes, Senator.
Well, you see, but Ms Sharp said that the payments, the annual payments that go into the fund can be used for basically whatever purposes the Nauru government chooses. Now, I'm trying to work out which of those answers I should accept: your position, which accords with what the Home Affairs said, or Ms Sharp's position.
So, Senator, I don't think those positions are inconsistent, and it might relate to how the payments are made. So the trust comprises of a fund, which is currently established. That was the 388 million. 63 of that is available to Nauru in the first year. And after that, there will be payments of either 63 or 73 million for the ongoing arrangement. And we've previously provided evidence of effectively a system of banding. So depending how many individuals are on Nauru at a particular point in time...
I understand the quantum, the quantum issues. But
a payment could be made either directly to Nauru, or where it's below a certain banding, the residual amount would be put into the trust. And that's for the broad benefit and uplift of Nauru.
Well, it's just that the Home Affairs documentation says that the purpose of the fund is to fund Nauru's participation in third country reception arrangements with Australia. Now, you say that, or Ms Sharp said, that the $31.5 million that was distributed could be used by Nauru for, I'm paraphrasing slightly, but for whatever purposes the Nauruan government thought fit. I'm just wondering what's true. Is what's on the box in Home Affairs website true? or is it true that Nauru can use it for whatever they choose?
Senator, I think, as Mr Biddington said, there's not a huge difference between the two statements. I think the purpose of investing a large amount in the trust fund is to give Nauru the confidence in its economic future. And I gave a lot of evidence about that as we went through the Parliament. The intention was very much to create a stream of funding, and Nauru can then use that as to build its economic base and its future economic sustainability as a country. It's a very small country, as you know, in the middle of the Pacific. It is looking to diversify its economic base, and so that we expect that the funds will be deployed to both uplift services now on Nauru, and you can see that in that appropriation bill. Some line items are going to things like improving health services here and now, community policing and the like now, and some are going to other economic investments that Nauru is seeking to make to grow its economic base. Both things are consistent with the overarching purpose and one of the reasons why the Nauruan government was willing to enter into the third country reception arrangement with the Australian government.
Well, also what we're hearing now is inconsistent with the explanatory statement that is attached to the regulations that were made. They gave a much more narrow compass for the purpose of the fund, being to provide Nauru with an ongoing source of revenue for investments in education, health, environment and infrastructure. Now, there are multiple different statements about the purposes of the fund which are contrary to each other on the Home Affairs website. We get a different version again from you, Ms Sharp, about the purpose of the fund. Where would we find an authoritative statement about the purpose of the fund? If what's on the website is wrong, where do we go?
Senator, I think Ms Sharp was articulating before that the purpose of the fund to support the long-term arrangement that we've entered into with Nauru and the use of that fund for Nauru's economic sustainment are not inconsistent.
Right.
Nor with the statement in the explanatory statement. Health, education and infrastructure, they're all getting at Nauru's longer-term economic sustainability as a nation.
Well, I'm not going to have a debate with you about whether I don't believe they're consistent, but we don't have to agree. Mr Biddington, have you been given instructions or advice about the nature of your role as a member of this trust committee? Were you given a legal briefing and advice about what your duties are as a trustee?
Senator, yes, I've been appointed formally to the role. As part of the broader supports for the role, there are internal committee structures that support me to do that. Mm-hmm. That's comprised of people who understand the third country reception arrangement in detail from an operational point of view. It also comprises people who are skilled in financial analysis. It also includes members of our legal team. So it effectively brings together a multidisciplinary team to support the Australian committee member in that role.
Well, yes, but then were you advised about what the basic duties you would have, the fiduciary duties you have as a trustee are?
And I read the document, Senator, that explicitly says I owe a fiduciary duty to the trust.
But do you know what that involves, a fiduciary duty to the trust?
Yes, I do understand what that duty is.
What are the elements of it, that as you understand them?
So it's the analogy I would draw, Senator, is that of a trustee. So you owe a duty to the fund as a fiduciary.
Well, I mean, ordinarily, and these are the principles you can find on the Treasury's website, the duty to not act in his or her own benefit or for the benefit of a third party. Do you understand that as one of the duties?
Yes, Senator.
Yep. A duty to act personally, honestly and to avoid conflict of interest.
Yes, Senator.
And do you know what to act personally means?
That would be to act in my personal interests, Senator.
Well no, it doesn't mean my understanding is it's absolutely not to act in your personal interest, but for you yourself to exercise the functions, to not simply, delegate them or hand them off, but for you to actually exercise your functions yourself. So not simply to rely upon advice from a team. But were you advised about those basic elements, to not act for your own benefit or for the benefit of a third person, to act for the benefit of the beneficiaries, to avoid a conflict of interest? Were you advised of those things and given training for those matters?
Senator, I'm completely confident that Mr Biddington has the training and skills to perform this role. He is a lawyer himself. He has practiced as a lawyer in the past. He's done the Australian Institute of Company Directors course. He understands what fiduciary duties are.
It's a different role, of course, a company director to a trustee. And I'm asking you, Mr Biddington, if you got that advice and training for this role, and if so, in what form it was given to you?
So, Senator, I believe I've got the qualifications and the understanding of the nature of the role. Specifically for this role, and Ms Sharp just referenced the company director's course, it was training that I requested to do specifically for this role, and noting the point that the role of a director might be different to that of a trustee. There are still strong analogies in terms of how governance works broadly, particularly in the scheme of administering a trust that has quite a substantial amount of money invested, and then to be able to understand effectively not just the director duties, but also more broadly things that go to the administration of money like balance sheets.
Yeah. Now, did you undertake any such training or information in the company of your fellow trustee, Mr Adiang?
No, Senator.
Do you know if he had any similar training about his obligations, which, given this trust is established under Australian law, would apply to him as well? Have you had any training as a committee? Have you seen any of that training given to Mr Adiang?
I don't have personal knowledge of Mr Adiang's training.
When Mr Adiang was I assume he was part of the decision to release the $31.5 million to the Nauruan government?
Yes.
Did he tell you at the time that he was a director of the Nauru Air Corporation?
Not at the time, Senator, no.
Did he tell you that one of the principal purposes of the release of funds was to benefit the Nauru Air Corporation, on which he was also a director at the time?
Senator, I've said previously that in terms of the minutes of meetings, I would need to consult with Nauru, so I would seek to take that question on notice for the purpose of considering a PIO.
Well, to help you to undertake that process, I'll refer you to the Nauru Bulletin, issue number 7 of April of 2026, where the Nauru government, when speaking about the $31.5 million and speaking about the $22.7 million which was being allocated to Mr Adiang's, your fellow trustees, department, said a significant portion of this appropriation, $22.7 million, is allocated to finance other, primarily to strengthen the national carrier's financial position, the fiscal cash buffer and overseas medical referrals. Did he tell you that it was the intention that a significant part of the money you were dispersing was to go to a corporation which he was a director in? And did he disclose that conflict of interest?
I've taken the question on notice, Senator.
Right. Was there any discussion in the trust as the committee about where the $31.5 million would be directed?
Again, Senator, I've taken matters pertaining to the conversations internal to the Trust Committee on notice for the purpose of considering a PII claim.
All right. Well, I'd invite you to review the Supplementary Appropriations Bill number 5 from this financial year from the Republic of Nauru, which shows that the overwhelming majority of the funds went to either the department administered by Mr Adiang or, and absolutely, to entities where his father was the relevant minister and or directly as president. and to consider whether or not those actions should have required, at a minimum, a declaration of a conflict of interest. Will you review the appropriations bill, which shows the destination of the funds which you agreed to the dispersal of?
Yes, Senator, we'll review that document.
But noting that we have reviewed it, it's not as though this bill, you bring it to our attention, was the first time we became aware of this, Senator Shoebridge.
Oh, well, the department could have... Did the department understand that the fellow trustee in the trust, from the Nauru side, that he was the son of the president, that he was the secretary of the department receiving the bulk of the funding, and that he was a director on Nauru Air Corporations, which was to receive a significant portion of the funds?
Senator,
did you understand all that?
I understand that the government of Nauru elected to have their member of the committee be the secretary of their Department of Finance. It's not surprising that a reasonable proportion of funds that are appropriated to the government of Nauru get directed to their Department of Finance for further dispersing. That in of itself is when the funds are intended to go to support the delivery of services and activities on Nauru, that funds would go to the Department of Finance in and of itself is not surprising to us.
Well, it's not surprising to me to see the way in which Australian funds are dispersed in Nauru. None of this surprises me. I find it deeply problematic, but hardly surprising. Is there a regular audit of the fund as against Australia's legal obligations, most notably the obligations that you would expect of a trust established under Australian law? Is there a regular audit being undertaken?
Yeah, there is, Senator. The requirements are for an annual audit, and there's also a requirement for a 5-year review.
Who is the auditor that's been appointed?
An auditor is yet to be appointed.
Thanks, Chair.
Thank you, Senator Shoebridge. That concludes the questions we have for the Department of Home Affairs in this outcome. So you are released with our thanks. We will take a short suspension while we welcome our next witnesses. Thank you. We will resume, and I now call officers from the Australian Transaction Reports and Analysis Centre. Sorry, if we can not have the Minister interrupted while we're in proceedings by broadcasting. Thank you. Mr Thomas, would you like to make an opening statement?
No opening statement from me, thank you, Chair.
Excellent. We'll proceed directly to questions and begin with Senator Shoebridge.
Thanks, Chair, and thanks for your attendance today, Mr Thomas. Do you know the value of contracts which AUSTRAC has awarded to Palantir over the course of, I think the first contract commenced in 2017?
I don't have the full value with me here, but I can take it on notice and get the full value to you, Senator.
My review of AusTender has the contracts totalling $28 million since 2017. Does that seem about right?
It does seem about right, but I will get you the exact figure.
How many different contracts are there with Palantir?
There are two.
Yeah. There was the original one awarded in 2017.
Yeah, that's right.
And that's been amended multiple times?
That's right.
Yeah. What's the other one?
There's a subsequent one that was entered into in the current financial year about the provision of transaction monitoring services.
What you said in this financial year. When in this financial year?
I'll get you the exact date, Senator. It was earlier in this calendar year from memory.
Yeah, so this calendar year?
From memory. Let me come back to you with the exact date.
Is that the $5.06 million contract
that
with
sounds
Palantir?
About right,
yeah. And what's the term of that contract?
Senator, I'll come back to you with the exact dates and the value of that contract on notice.
What is the AusTender has a contract with between your agency AUSTRAC and Palantir Technologies that was amended on the 4th of April 2025 and runs from 1 January 2023 to 30 June 2027 and has that contract value at $8.348 million. Is the $5 million contract, does it represent an amendment of an existing contract or is it a standalone contract?
Can I come back to you with the details of those contracts? Senator, I just don't want to misspeak. I don't have the details of those contracts before me.
All right. Well, this contract is described as being a data analytics capability.
That's right.
Is that the most recent contract you've entered into, or is that the existing contract?
That's the original contract that we entered into. The original service we purchased from Palantir is tools to analyse our data. That is the major contract we have with them and the major service that we purchased from Palantir.
That was the original contract. And what's the fresh contract for?
The fresh contract is around the provision to move data within our data systems.
Sorry? It assists you to move data within your system?
It assists us to manage the transaction reports that we get from reporting entities.
All right. When data is provided to Palantir, is this running on Palantir's servers?
No, it's not. Could I give you an indication of the security arrangements for this data, if you like?
Yeah, by all means.
So the purchase of the Palantir tool sits on top of AUSTRAC's data holdings. As you're aware, we get significant volumes of data from the businesses that we regulate. And we use the Palantir tools primarily to interpret and analyse that data. It sits within a data centre that's not controlled by Palantir, but is an Australian-based data centre. AUSTRAC owns the tenancy of that centre, which means we control the data, we control the environment, and we control the access to that data. There's an offence there are provisions under the contract to control Palantir's access to that data. They can't access our data without explicit approval from AUSTRAC. And when they do access it, it can only be accessed by staff of Palantir that have appropriate security screening, Australian government's screening classifications. We have monitoring and analysis over the top of that data so that we can see who accesses it and when. But as I say, we control Palantir's access to that data. They can't extract data from that system. There's no ability for them to move data out of Australia into other locations. And the contracts that we do have with them have quite specific provisions, penalty provisions for misuse of that data. And we manage those contract provisions quite closely with Palantir.
You're aware that Palantir's parent company resides in the US?
I am.
You're aware that the US has this thing called the Cloud Act, under which US technology companies can be compelled to hand over data which they have access to anywhere in the world? You're aware of the Cloud Act?
I am.
Are there contractual arrangements with Palantir that make it clear that even if they were ordered to by the US government, they wouldn't engage in such actions in Australia?
Well, my understanding of the provisions and the advice I've got from our contract is we could terminate the contract with them if they sought to do that or tried to do that. As I say, we control access to data under the provisions of the contract that we have with Palantir. The Palantir engagement we have are tools that sit on top of our data that we use to analyse that data. They don't access our data or have access to our data unless we provide that access for the purposes of amending or changing the tools that we contract to them. The data is held on an Australian server that's not owned by Palantir.
Yeah, you say if you were aware of such an action, you would terminate the contract. Is that right?
That would certainly be a strong consideration.
You'd be also aware, wouldn't you, that under the Cloud Act, if an order is made to a US corporation, they are obliged to keep it secret and to not advise the target of whom the order is made.
So we control...
You are aware of that?
We control access to our data, Senator, under that contract and under the arrangements of the database that we maintain. I don't believe it's possible for Palantir to access and extract that data without us knowing that. And certainly if they did do that, that would be a significant grounds to consider terminating.
But if they had done it pursuant to an order of the US government, they would be obliged not to tell you and to do everything they could to prevent you knowing. You're aware of that?
But I don't believe under the arrangements we have, they could do that without us knowing about it.
What did you... I'm assuming both of the software products that Palantir are providing are incredibly complex products. Yep. Have you had somebody go through line by line to ensure that there isn't a key or a backdoor or a vulnerability that could be used or a deliberate intentional design to allow Palantir to comply with a legal obligation under the Cloud Act? Have you had someone go through the software to determine vulnerabilities?
We do security and penetration testing across all of our IT holdings and our software systems that we use in AUSTRAC, and that would include the Palantir systems. That penetration testing is done independently of AUSTRAC by external experts, and we do that on a regular basis.
Well, you see, Palantir has this year published a political manifesto where they say they will use their corporate assets, they will use their organisation to further the US military and to further the political and cultural interests of the United States. Have you read that manifesto that Palantir has delivered?
I'm aware of it, but I haven't read the detail of the manifesto.
Yeah. They are openly saying that they will be an agent for a foreign company, for a foreign country. They have openly said it. They're not hiding their light under a bushel here. Did you take into account those organisational and national security risks when you entered into a $5 million further contract with this company? Did you take into effect that they've openly said they want to be a tool of the US government?
We always consider national security risks and broader data security risks in any contract that we enter into. And we constantly consider data security risks with the management of our data holdings and of our data systems within AUSTRAC. We're constantly testing The veracity of our security controls, the quality of our management responses, not just in the context of Palantir, but more broadly on all of the data systems that we hold.
But if you're trying to look after a sheep farm, you don't invite a wolf in. But that's exactly what you've done here. You're trying to protect Australia's data, and you've invited in a foreign multinational who has said explicitly it's on the side of a foreign government and it'll do what is required to make sure that foreign government wins military and cultural conflicts around the planet. You've literally invited the wolf in, haven't you?
Senator, we've got a pre-existing contract with Palantir for a service that we rely on currently. We've got very strong security controls around how we manage our data. I believe we've got very strong provisions in our contractual arrangements with Palantir to enable us to manage that data safely and securely. As we go forward and we examine what our future data holdings and data platform needs are, we will consider all of these things afresh again, including any experiences we've had with the current arrangements.
Well, you see, you may not know what they're doing with your data because, as I said, if they're subject to an order from the US government, they are obliged to keep it secret from you.
As I said, Senator Shoebridge, we have very tight controls over the access to our data. And I believe through the advice I get from our cybersecurity experts, the expert advice we get independently, that we can control their access to our data.
Now, this most recent $5.06 million contract has been described as an open tender in some communications, but it really wasn't open to anyone other than Palantir, was it?
It was based, as I understand it, from a head agreement from the Department of the Digital Transformation Agency, pardon me.
Well, that's hardly an answer to my question, that it's based on a head agreement with the Digital Transformation Agencies. It was really only open to Palantir, wasn't it?
Well, it's a lawful agreement, Senator, according to the Australian procurement rules.
Rather than talk about it in the abstract as lawful or unlawful, tell me how it happened. How was it that Palantir got this $5.06 million contract?
Senator, we did an exercise looking at what our data needs were, what our technology needs were, and how we could best deliver those in the most effective way for the best price within a very confined timeframe. And you concluded what? We concluded that this was the best option for us.
And you concluded to only engage with Palantir?
We did.
Well then, how could it possibly be called an open tender?
It's a lawful tender under the provisions of the Digital Transformation Agency.
It might be lawful, but if you only engage with one entity, it's not open.
It's a lawful tender, Senator. I'm not sure how else to answer your question. It's a lawful tender, lawfully engaged by the Commonwealth of Australia through its existing arrangements.
Yes, an open tender which was open only to Palantir, under which they got a $5 million contract. That's the truth of it, isn't it?
That's right.
Mm-hmm.
And Mr Thomas has outlined the reasons that decision was made.
You see, AUSTRAC exists to protect Australia's financial system from criminal abuse. And is your agency really satisfied that in trusting the sort of the AI, the software background, the platform backbone to that system, to a single non-competitively selected US tech company that on any view of it has fascist tendencies, are you sure that that's consistent with the mission?
I am. And Senator Shoebridge, I mean, with respect, the AUSTRAC has made a decision that this particular company was best equipped to meet its needs. It doesn't, and I'm sure you don't think that Australian government agencies should be basing their decisions on the ideological allegiances of particular companies.
I absolutely do believe you should be judging your procurement decisions on the ideological positions.
Would you like us to run past which companies meet your ideological?
On the ideological positions
alignment?
of foreign multinationals whose principal shareholders are far-right billionaires who have contempt for democracy, and in circumstances where the company itself has published an open fascist manifesto talking about global culture wars.
Senator Shoebridge, I'm just wondering...
Yes, I do,
Okay,
and I'm surprised that you don't.
May I respond?
Senator Shoebridge, I'm going to allow the Minister to respond. I didn't hear a question. It sounds like the Minister wants to respond.
So are you suggesting that we should make a new term of government procurement that each organisation we procure aligns with your ideological views?
I just think you should have a provision that you don't contract with far-right multinational fascists.
There are...
And I don't think that I know that you obviously push back against that, but I think that millions of Australians are appalled that your government
I know you like
keeps
to speak
handing
for millions
contracts,
of Australians. I'm yet to see
handing
you demonstrate
contracts,
you do speak for millions of Australians.
handing contracts to companies like Palantir.
We are
I know
going to get back to the orderly question and answer nature of estimates. I've heard a bunch of statements and I would like some questions and some responses from our witnesses before we're ready to move on.
Mr. Thomas, did Austrac enter into the most recent $5 million contract before or after the manifesto was published online by Palantir?
My recollection was it was before, but as I said, I'd need to check the dates.
Well, if it was before, did you review it following the publication of Palantir's manifesto to see if it's consistent with Austrac's stated agency purpose and values?
Senator, as I said, we take data security incredibly seriously in Austrac, whether it's related to systems we contract from Palantir or the many other software and hardware systems that we have. We have incredibly tight controls around data security. Any suggestion that we have a lax approach to data security is completely incorrect and has no evidence to it. Can I say we test our data holdings, we test our data security. We've invested further as an organisation, both in terms of testing controls and expertise internally to make sure that our data is incredibly secure. It's one of the top priorities of the organisation and certainly something that I focus an incredible amount of attention to. We posed significant attention to the contracts that we have with Palantir purely from the point of view of data security and maintaining control of data and data integrity and making sure that Austrac has the control of its data and maintains the integrity of its data. There is no evidence, I would suggest, to imply anything other than that.
Have you conducted a privacy impact assessment covering the Palantir arrangements?
I don't believe we have conducted a privacy impact assessment on that.
Well,
let me check and come back to you, but I don't believe
with the financial transactions of pretty much every Australian, vast amount of personal information, and you haven't done a privacy impact assessment?
I'll come back to you on what privacy impact assessments we have done. Can I say the Palantir arrangements are the tools that sit on top of the data, not the holding of the data.
Well, you'll come back as to whether or not you've done a privacy impact assessment on either the current platform
or more broadly on
or the previous platform, the existing platform that.
Or more broadly on our data holdings. So.
All right. I just have a handful of questions on another matter. Australia has autonomous sanctions listing individuals and entities connected to illegal settlement activity and settler violence in the West Bank in Palestine. Is Austrac responsible for monitoring compliance with those sanctions in the financial system?
The Australian Sanctions Office monitors compliance with sanctions. What we do is work with the businesses that we regulate to assist them in identifying where people might be in breach of sanctions arrangements. And we do that in a range of ways by providing information to those businesses about red flags and other materials to look for. We're often in receipt of intelligence from our partner agencies about third parties and corporate structures that people might be moving funds through to try and avoid sanctions, and we provide that information to the businesses that we regulate so that they can properly monitor their transactions and pick up when any of those breaches may be occurring. They do provide us with intelligence reports and data reports when they do pick up those breaches, and we provide intelligence then to the Australian Sanctions Office on any of those breaches we pick up.
All right. Well, has Austrac received suspicious matter reports involving transfers to entities on Australia's West Bank sanctions list?
Senator, you know it's an offence for us to disclose any suspicious matter reports that we've received.
Well, have you issued any specific guidance to banks, remittance dealers, digital currency exchanges about transfers that may involve those West Bank sanctions listings?
Again, I won't provide details on any specific advice we've provided to financial businesses, because some of that might be quite specific around particular red flag indicators or particular businesses and transactions for them to be aware of. But we do constantly talk to the businesses we regulate about the kinds of things that they should focus their efforts on, both in terms of money laundering and illicit finance and also in terms of sanctions evasion.
Well, are you looking at financial transfers from Australia to Israel? Are you looking at them to see whether or not they may be in breach of the autonomous sanctions listings? Is that part of your task?
We monitor transactions between Australia and a whole range of countries.
Yeah, but I wasn't asking you about that. I was simply asking you about to Israel, given the autonomous sanctions of individuals and entities.
As I was about to say, Senator, we monitor transactions to a range of countries, including Israel, to attempt to detect any sanctions breaches. Mm-hmm. Some of those sanctions breaches that we do detect aren't as obvious as that. For example, companies and individuals trying to avoid sanctions often aren't making direct transactions between one place and another. They might be routing them through third countries and third parties. So the answer I was trying to give you is we're monitoring those sanctions breaches, but it might not just be with transactions to Israel. It might be transactions to other places, depending on the intelligence we get about what companies and other individuals might be involved in sanctions evasion.
If you identify evidence of sanctions breaches, what do you do with it?
We provide any evidence we have on sanctions breaches to the Australian Sanctions Office.
That's within DFAT?
Yes.
And do you have any further role after that, or if action is taken, are you just there to provide evidence?
We provide intelligence and evidence on sanctions breaches.
All right. Are you able to identify on how many occasions you've provided the Sanctions Office with evidence of potential breaches of the sanctions in relation to Israel?
I have to check what data I can release on that.
Could you provide the same information on any potential sanctions breaches in respect of the autonomous sanctions on Russia?
Again, I have to take some advice on what information I can provide to you.
All right. I appreciate that. Thank you for your assistance today, Ms Thomas.
Thank you, Senator Shoebridge. Senator McLaughlin.
Thank you, Chair. I'd like to take you to the recent tranche 2 of the anti-money laundering and counter-terrorism financing reforms and retirement villages, because I've had some representations from the industry, particularly those that have a type of bond system and a licence to occupy. And they're struggling whether some parts of their sector are under this new regulatory regime or not. Is your office going to issue any guidance in relation to that product offering?
I do understand we've had some correspondence with some representative groups from that particular industry, and we'll be responding to that correspondence that we do have. The Tranche 2 arrangements cover some specific designated services that the legislation designates under money laundering regulation. Those services quite specifically around the purchase of real estate and people involved in real estate transactions. I understand that might be the nature of the services that they're concerned about. And we'll endeavour as soon as we can to provide any advice to them. If you've got further constituents or others that have questions for us, if you can provide me with their details, we'll endeavour to get in touch with them.
Yes, they're not coming from the position of trying to avoid compliance. Yeah. It's a question, as I understand it, of whether they need to comply or not, and some parts of the sector. And it's around real estate, as I understand it. I'm not an expert in retirement villages. Yeah. Once upon a time I was, but I am no longer. And whether they fit into a real estate transaction or not. Is it your practice to issue practice directions? I'm not as familiar with your jurisdiction.
Yeah.
To give guidance, compliance guidance?
Yeah, it is. So the legislation broadly talks about the services that fall under money laundering regulation. We then design a set of rules that put some more specificity around what those services are. And then what we've been doing since the legislation passed has been issuing sector-specific guidance for particular industry types that fall under money laundering regulation about how that looks for their own areas of business. As we're continuing with the implementation of Tranche 2, there's lots of questions about edge cases where it might look like a particular transaction type or a particular type may fall one side or another of money laundering regulation. And as best we can, we're clarifying that with industries and businesses to be as specific as we possibly can be about who's in and who's out of this regime.
Right, so if they engage with you, they may have, but if they engage with you, at some point they'll get a ruling if it's sufficiently unclear from their perspective.
They'll get the best advice we can give them, and I'd really strongly encourage them to engage with us.
When is the implementation, as I understand it, with a quick look, is 1 July 2026. We're running out of time. How is your office coping with issuing practice notes, given each day is passing towards the deadline?
Yes, so the legislation passed in November 2024.
Yes.
We've taken an approach in developing the rules and the guidance material to be as involved as we possibly can with the industries that were coming under the new money laundering regulations. So the first task for us was to design those rules, which we did between December 24 and August of last year. And we did that with 2 rounds of consultation and an incredible volume of industry roundtables and discussions. And we changed those rules quite considerably by virtue of the feedback that we got from industry. Subsequent to that, we've been developing guidance materials for specific industries, and we publish those for each industry that's coming under our regulation earlier in January. And since then, we've been clarifying with particular business areas as best as we possibly can the rules and the law as we understand it for how they fit under money laundering regulation. The responsibilities for newly regulated businesses commence on the 1st of July. They commence on the 1st of July, but we won't be taking any enforcement action against anybody who's still unsure about whether they fall under that regulatory ambit, and we'll be working as closely as we can with those industry to give them as much certainty as we possibly can.
Yes, I understand this instance there is a diversity of legal opinion of whether they come under the Act, which is causing some angst amongst the providers.
They're not the only industry that has a diversity.
Yes, no, I appreciate that, but they have made representations to me, so I pass them on to you. So I'd appreciate if you could take on notice for me what you've done in relation to the industry and any guidance about when you can resolve their problems or you're anticipating.
Certainly will, Senator, and if you have anybody else who wants further advice or assistance, please encourage them to reach out to us.
Thank you.
Excellent. That concludes the questions that we have for you this afternoon. Thank you very much, Mr Thomas. You were released with our thanks, and we'll take a very short suspension while we welcome our next witness.
Thanks, Chair. Thanks, Brendan.
Okay, I now resume and I call Australia's Special Envoy to Combat Anti-Semitism. Ms Segal, would you like to make an opening statement before we begin?
I'll take
I swear. The Bible.
Sorry, I'm just asking for the mics to be turned up a little bit.
No, sorry, I don't want to say. I have no statement.
Oh, you don't have an opening statement?
No.
No worries. We'll proceed directly to questions.
Thank you.
And we'll begin with Senator Blythe.
Thank you very much, and thank you for appearing at these estimates hearings today. I just have some questions that we'll just run through, in particular relation to the recent budget announcements by the government. Did you have consultation with the government prior to May 12th about budget announcements in relation to anti-Semitism?
No.
No? In terms of, and we've heard from various agencies earlier in
Sorry,
the...
just a minute. When I say specifically in relation to this budget, no.
Yes, no, specifically in relation to announcements in this budget that have been made for anti-Semitism. No consultation. We've heard from agencies during the course of this week about anti-Semitism training within the public service and the progress that they are making. What is your expectation in terms of percentage of public servants that should receive the anti-Semitism training?
Well, I think that my expectation is one where I think the senior members of the public service should receive training, and then I would be seeking their advice as to who else in their department. I don't think it's a 100% issue. Because I think that's not to say it shouldn't be a significant percentage, but I think 100% just makes it sort of something that is almost rote, that's taken just like ordinary, something that someone has to go to. And I'd much rather it was meaningful to their role. So if they're having to make decisions that need that to be taken into account, have a base level of understanding, some will need a greater level of understanding. So I don't think it's a one-size-fits-all approach. So and so the anti-Semitism knowledge needs to be either more in-depth or less in-depth. So I don't think there's a fixed percentage, but significant.
Significant. And I think we heard from one agency, and I don't recall off the top of my head, but I think it was something like 50 out of 2,500 employees had done
50 people?
Yes.
Yeah, well, obviously that's part of a trial that has taken place. And I think that's the way to proceed with anything like this. You undertake a trial and you get feedback and you make changes. And clearly the feedback that has been received, and I understand it's been received by the relevant department, but my understanding of it is that it was clear that the more senior people wanted more discussion and took longer and needed to have more engagement, and more junior people needed a shorter program. So I think one has to be adaptive to the relevant people who are being educated.
Excellent, thank you. Can I just ask you, what's your understanding and explanation for why Australia, following the October 7 attacks by Hamas, was the last Western democracy to appoint an envoy to combat anti-Semitism?
I really couldn't comment on that. I sort of wasn't involved. I do know that it had been something that had been taken up by the community not that long beforehand. So it was a realisation that it was something important for the country, and the government then responded. I really, one could speculate more generally as to why these things have taken hold in different countries at different times. And Australia has been a long way away from Europe, and where there had been a lot of anti-Semitism still remaining after the war. So I think that it was something that took this country a little bit by surprise. I've said that before in many places, that we were caught up in our enjoyment of the freedoms and the Australian values and multiculturalism, and perhaps we're not as aware of the issue until it really became an issue for us.
And I guess just going on from there, do you think that had your role existed sooner, that it's possible that as a country we would have had a better, more coordinated approach to this surge in anti-Semitism that we've seen?
Oh, Senator, I would like to think that, that I would be having that impact, or someone in my position would have been having that impact. It is very hard, isn't it, to look backwards and decide what might have been. I honestly don't know.
And Senator, I'm slightly worried we're getting into asking for opinions.
Okay. Yes. No. That's yeah. Noted. Thank you, Chair.
No worries.
In your evidence to the Royal Commission, you've described horrific anti-Jewish hate march in Sydney on the 9th of October 2023 as a critical turning point in the development of anti-Semitism in Australia and a unique moment that was missed. You also said if that had been dealt with differently, we might have had a different trajectory. Can you please be more specific what you meant by those statements?
Certainly. Well, again, we are talking of opinion here, but it was my opinion that there was this surge, as I said in the statement, of hatred, much hateful things being said about Jews. Where are the Jews? Possibly gas the Jews. There is some dispute as to what was said at the time. But it was clearly a moment where there was hatred expressed for the Jewish community, albeit that it was in response to what had happened on the 7th of October in Israel. And I think that was a moment of demonstration to the rest of Australia and indeed to the rest of the world, because it was at the Opera House and it was very iconic in its photography, as to how this should be dealt with by the leaders of our country. And if it had been stopped and people had said this is absolutely unacceptable, and the police, instead of protecting those protesters, had indeed taken them, even if not arrested them, but asked them to move on, there had been a completely different policing approach, I do think it would have sent a very different message and possibly a different trajectory. As I say, you don't know, you can't look backwards, but yeah. I do see, and I think the Jewish community generally, when I've spoken to them about it, they see that as a critical moment. When that was not the case, the protesters were surrounded and protected, and indeed the one person who walked across waving an Israeli flag was shooed away.
Yeah. No, thank you for that. And I guess just to go and pick up on that, in terms of your understanding, has the federal government undertaken any formal reviews of the events that occurred on the 9th of October in Sydney? And have they worked with you in your position as Special Envoy to look at what a better national approach could be? So you've recommended some things, could policing have taken a different sort of approach to what happened? Has there been any kind of formal review into that you're aware of?
Well, I think what we're seeing now with the Royal Commission is obviously a very clear review of policing and those issues. Yeah. And remember, they were state police. We're not talking about federal police. It was in New South Wales.
But I guess it was an event of national significance. It was something that was, widely seen, not just across Australia, but around the world. And I guess, and that occurred sort of well before Bondi, which is what triggered the Royal Commission. But in terms of a specific, I guess, a direct action from that, was there a review that went into?
Now, I'm not aware.
No?
I'm not aware of anything. But if anything, it would be a New South Wales review.
Yeah. Okay. But nothing that you, in your role as Special Envoy, have been asked to?
No.
Not to either state or federal. Okay. Thank you. You've also said in your evidence to the Royal Commission that we have, I think, not seen enough leaders speak out. Can you be more specific about the leaders that you're referring to with this and how you think they should have spoken out?
Well, I think my approach stems from what I also put in the plan, that this is a whole-of-society approach.
Yep.
I don't think the rise of anti-Semitism in Australia or in any other country can just be dealt with by government. I do think it is a society issue. And government can speak out, other faith leaders need to speak out, other community leaders, business leaders, union leaders, a whole range of leaders need to speak out, because we are talking about Australia and Australian values. We're not just talking about a particular community that's being vilified or intimidated. We are talking about the country that we want Australia to be. And I think it's very appropriate and it's necessary, because it's the leadership generally of the country that sets the culture, sets the tone, sets what's expected and accepted. So that's what I mean. I think that leaders more generally around the country should have, but absolutely now. It's not as if it is all lost. I'm very hopeful that if we see leaders today speaking up for Australian values, for mateship, for looking after each other, for not intimidating or vilifying any group, that we can move anti-Semitism to the margins, which is what my ambition is.
And I think that's a very lofty ambition to have, and something that I hope can be achieved. I guess ahead of your Royal Commission appearance, you and your office apparently interviewed 65 Jewish university students, academics and staff. What were the dominant themes that emerged from those interviews?
Well, the dominant themes that emerged from those interviews were that they had felt in that period, through different experiences on campus, either from fellow students or from academics and tutors, extremely isolated and intimidated, and some of them had been vilified. And they had been forced to defend Israel who, in the face of criticism, whether they wished to or whether they believed it was correct or whatever. They were, because they were Jewish, they were being held responsible for whatever criticisms of Israel were being made. And when they complained, their complaints were not dealt with. And when they continued to complain or took their complaint further, the solution of the university, so remember this was just 65, I'm not speaking about every university, they're not a representative sample, they were just the people who approached, who responded to my invitation. But they almost consistently felt that they'd not been properly dealt with through the complaint system. Okay. And they generally had the response of, if you don't feel happy, you don't feel protected, you don't feel safe, then please study from home. So they were asked to stay home. Okay. So that was I'm being general here, giving you a general view. It's summarised in, I think, one of the attachments. The more detailed summary is one of the attachments to my statement. Okay. But that was the very unsatisfactory result of their... And they all felt they'd not been dealt with appropriately, and many of them felt extremely distressed by their experience, and some of them had had to seek medical attention.
Okay. And I guess going on to that, should the universities be playing a much more prominent role in the training and, I guess, raising awareness in terms of anti-Semitism?
Well, I mean, that is a very significant question as to what universities should be doing. If I could say that it is a topic that the Royal Commission is going to be looking at, I believe. So perhaps I could leave it at that, other than to say that, of course, I set up a report card process about appointing Professor Craven to look at universities, but to look at the particular elements that the Parliamentary Joint Committee had recommended. So they had recommended adopting a definition, adopting appropriate complaint schemes, changed policies, and training of university personnel about anti-Semitism. Yep. And Professor Craven's report has just come back and been released, and he did not manage to look at all of those issues, because the first issue he looked at was the adoption of a definition, and he found that there was a systemic failure from the university sector that generally they had not properly adopted in terms of operationalising a definition of anti-Semitism. And without a definition, he felt there was no point looking at complaint schemes and at other areas. And so he just has given that report. And I have sent it to all the Vice-Chancellors to say, look, here is systemic issue. You say you've adopted it, or you might have actually formally adopted it through your council procedures, but you haven't operationalised it. You haven't taken it into your codes of conduct, and you haven't taken it through the university mechanisms. Please reconsider the issue and come back with further action by the end of August.
Excellent. And that is probably a good segue when we're talking about adopting working definitions. Both the ABC and the SBS have declined to adopt the IHRA working definition of anti-Semitism, despite that definition having been endorsed by the federal government and adopted by the Royal Commission for its hearings. Do you regard that refusal as consistent with the national approach you've recommended?
Well, it's obviously not consistent with what I have recommended. I have recommended that definition be adopted. But I might say that one of the things my office has done, and I will show it to you, we have published a booklet on the definition.
Okay.
Because I think there's a lot of misunderstanding about the definition, or lack of understanding about the definition. There's a lot of, views that the ABC might have considered that it would constrain speech or anything like that. And this booklet is an educational booklet to explain to people how the definition works. And it's very clear that it's not mandating that it is anti-Semitic to say various things. It all depends on context. And there are the 11 case study examples that are attached to the definition that are illustrative and that do depend on context, but are very worthwhile guides. And I think it would be very helpful to organisations like the ABC or SBS to have a definition and consistent with the country as a whole, and to use the booklet as a guide. It's not, crystal clear in situations without knowing what a definition means. I think it would be helpful.
And I guess to go on from that, for a publicly funded national broadcaster to not be coming in line and actually rejecting the IHRA definition, what does that mean in terms of your efforts to create a consistent national approach? If even a publicly funded broadcaster, a publicly funded higher education institutions are not adopting a definition?
Well, I think, my wish is, of course, that we do have this definition consistently adopted and used in the country, because I think it is a very useful definition, as this booklet indicates. I think that it is misunderstood by many people as mandating various things that they fear, chilling free speech or whatever it's been accused of. And I don't think it does that. I think it is very focused, and I think the Royal Commissioner has made this point, it's focused on context, and it allows some things to be said in one context that might not be permitted, it might breach the definition in another context. So it is quite sophisticated, really. I'm hopeful that through education and through a better understanding of where anti-Semitism is coming from, that universities, for example, will adopt a definition, even if it's not IHRA. If it's close to IHRA, it will, they will move, I believe. I'm hopeful that with further discussion we can talk to the ABC and SBS. I mean, I have had various meetings with them, but so far I haven't managed to convince them about these issues. But, I do think that it's important that the ABC and SBS understand their important role in this country of setting the culture and setting the tone. And it's a responsibility. And I think that we need to talk to them further about it.
And before I share the call, because I'm conscious, just to pick up on that. So you've had conversations with them. So you've tried to educate them. I'm assuming they've got a copy of your booklet.
I mean, we've started the process. I think there's further ways to go. I have had beginnings of conversations with them. But I think that I'm very interested in seeing the recommendations of the Royal Commission also in this space. Yeah. So I do think that perhaps some of these discussions can wait until we see the recommendations from the Royal Commission.
So they've made that decision without necessarily consulting with you. So they've made the decision not to adapt. What is the government's position?
That's right. They have. They did not consult.
They didn't consult you at all. Okay, thank you, and I'll share the call.
Thank you, Senator Black. Senator Shoebridge.
Thanks, Chair, and thanks, Ms Siegel, for your appearance today. Your conflicts of interest forms have been the subject of at least one Freedom of Information request that's been treated as a deemed refusal. It's now an appeal with the Office of the Australian Information Commissioner. Were you consulted by the department about the decision not to release your conflict of interest forms?
Yes.
Yeah. Did you support the refusal to release your conflict of interest forms?
Well, Senator, if I can say, my understanding of the forms you're talking about are the forms that I might have signed when I first started. Are they the forms you're talking about?
Well, I don't know how many conflict of interest forms you've signed, but the request is for the conflict of interest declarations you've given. If you've done it more than once, well, then I assume it's about if you've done it multiple times.
No, I'm just asking if that's what you're talking about.
I haven't seen the documents because they've been refused.
Well, I don't believe that they're called conflict of interest forms. I think they're called interest forms. Are they called conflict of interest forms?
Well, howsoever described, the ones that declare any conflicts of interests or potential conflicts of interests that you have, this is a requirement ordinarily of every public office.
Absolutely.
And I'm assuming you made such a declaration. Did you?
I did. I declared all my interests.
Documents. They are the documents. And you obviously know what the documents are because you said you were consulted about the refusal to provide them. So I'm talking about those documents.
Yes. Okay. Yes.
So did you support the refusal?
Yes.
Why?
Well, I think it's in terms of the guidelines, they're private information.
Well, they're information that allows the public to see what a public official's interests are so that they can be judged whether or not in their public capacity they're acting in the public's interests or potentially also in another organisation's or entity's interests that the official has an interest in. Like, there's a clear public interest in having this disclosed. The minister's interests are publicly disclosed because that's how we operate.
Yeah,
there is public scrutiny of public officials.
Sure. Well, let me take on notice what has been refused so that we're talking about the same things, because I'm not quite sure where they are up to. So let me take that on notice. But my interests, if I could use it, those, when I started this role, are well known. They were very well known that I had been on various boards because I think you've asked me and others have asked me questions about those other boards that I was on at the time. I don't think that it's not secret information, it was public information.
Well, if it's not secret, if it's public, why do you object to them being published?
That's why I said I'll take it on notice what has been objected to, Senator.
Well, what's been objected to is the disclosure of your interest forms. You know that because we discussed it. You told me what they were yourself. That's what you've been consulted on, which sets out if you have board positions or former board positions, if you have positions with other organisations, if you have investments in entities that may have a potentially come across your work. That's what we're talking about. And why won't you allow the public to see?
Senator, if I could just make the point that Ms Siegel is not the decision maker on this FOI. She was consulted, but the decision was a departmental officer, and there is, of course, a review process against that decision. Ms Siegel doesn't have the documents in front of her, and I don't think it's reasonable to ask her.
I never suggested Ms Siegel was. I was asking about her consultation and what position she gave in the consultation. She was consulted, wasn't she, Secretary?
So
as anybody would be about their information.
Indeed, but my point, Senator, is that Ms Siegel's input is an input to the decision maker. It's the decision maker's decision, and if you wish that decision to be reviewed, then there is a process.
I'm not talking about the review of the decision. I'm talking about Ms Siegel's input into that process, which is a perfectly valid manifest Senate estimates. So, Ms Siegel, I'm still at a loss as to why, when you were asked, you objected.
I didn't object, Senator. The question was, did I support the decision of the view of the decision maker at the Home Affairs, and I did support it.
Well, you see, the way it normally works is you're not consulted on the final decision. Your opinion is sought along the way. So were you given a draft copy of the decision from Home Affairs?
Senator, as I said, I have to take that on notice. It was some time ago and I don't recall, but I can certainly review it and have a look.
Were you asked about whether or not you supported the opinion of Home Affairs
Senator,
to not
I said I would
release it?
take it on notice.
Well, I mean, I asked whether or not you objected to the release. You said that you supported the position of Home Affairs.
Yep.
Now, it would be very unusual in the process for the delegate to have formed a position and then consulted you afterwards. That isn't my understanding of how the process works. So when were you consulted, Ms Siegel? When were you consulted?
Senator, I think there's a temporal issue here. Ms Siegel is saying that she supports what she now knows to be the decision of the FOI decision maker. You are quite right. The process is to seek input from the person whose information is being considered. And I think that I'm confident that my staff will have followed the proper process in their consultation.
So I come back to the very question that I asked, which got, I'll repeat it again. When you were asked about whether or not you agreed to the release of the information, what did you say?
Senator, I said I would take that on notice because I don't recall the order of things. I will investigate it.
I'm not asking about the order.
I will take it on notice,
Okay.
Senator.
Senator Shoebridge, I think Ms Siegel has indicated that she's not in a position to respond to the details of the question you're asking. She's taken the question on notice.
In answers to questions from estimates last occasion, you said that you have specifically withdrawn from any authority or decision-making power within the Executive Council of Australian Jury, or ECAJ. What is your role then? You say you have specifically withdrawn from any authority or decision-making power. Do you have any other role?
No, so the position in relation to the ECAJ is I was the president of it. My presidency finished in about November 23.
Yes.
Which was more than 6 months before I was appointed the envoy. But by the constitution of the ECAJ, the previous president is known as the previous president. And they have a previous presidential role of advice and consultation of what happened in the past, as you would appreciate. And so I am technically the previous president because that is the fact, but I have withdrawn from their normal procedure of consulting me and speaking to me, etc., etc. So I don't have any role within the decision-making of the ECAJ.
So you remain the previous president, and that's a formal role under the Constitution?
Yeah, by fact, okay? By fact. I can't be removed because there is such a technical term, but I have no role at all in their decision-making.
Well,
and they don't consult me, and they've resolved that out of proper process and procedure for exactly the purposes that you are asking, because this role is an independent role, and I'm not part of the decision making of the ECAJ.
Well, you say it's an independent role, but we also find out from your answers that you have, and I quote, an academic specialist from within the education sector is on loan from the ECAJ. This staff member reports directly to the envoy and receives no direction or has any reporting lines to the ECAJ. Do they have a fully funded staff member? Do you have a staff member fully funded by the ECAJ in your office?
Yes.
How did that arrangement come about if you don't have any ongoing involvement with ECAJ? How did they turn up in your office?
Well, how did they turn up, Senator? They had an education function, I suppose, that wasn't being fully utilised. and I was assuming the role, and it was a proposal that was of mutual benefit, that I could take their person who would otherwise not be working effectively for them, and I would be able to utilise that person.
It was of mutual benefit. It benefited both you and ECAG. Was that the view?
Well, for the person in particular, yes, Senator. The person would not be employed and be doing the job at ECAJ, and I needed a person with that expertise.
Did Home Affairs have any role in approving that?
Yes, Senator. It was all done through the proper processes.
Ms Foster, were you aware that this arrangement was in place in Ms Segal's office?
Yes, I believe I was, Senator. I believe Ms Segal discussed it with me before putting the arrangement in place.
Did Ms Segal go through a formal process? Is there a formal process for the approval of this?
Senator, I'd need to check with my staff. What I can recall is the discussion that we had about it.
Yeah. Sorry, I'm just alerting the room that we have media in the room with us and seeking everybody's agreement for the media to down. Thank you very much. And all the usual rules apply, and we reserve the right to withdraw consent at any time. Thank you. Senator Shoebridge.
You see, Ms Segal, if you had no ongoing role with the ECAG, I still can't work out how it happens that one day you have a fully paid ECAG officer in your office now, in your anti-Semitism role. If there was no formal role, how did this happen?
So Senator, the agreement was established through an MOU, which my staff supported Ms Segal's office to establish. There have been a number of organisations and individuals who have wished to support the role of the Special Envoy. That's, I think, a natural thing, given the nature of the role and the nature of the challenge that Ms Segal has been appointed to resolve or to work on. And I have no concerns about her having assistance from members of her community in her role on a pro bono basis.
I'm interested in the ongoing, whatever ongoing connection between you, Ms Segal, and this organisation that led to this happening.
Well,
was it part of a discussion you had with the leadership? I mean, how did it happen?
Senator, I kind of think you are trying to draw more out of this.
I'm just trying to find out how it happened.
Well, how it happened was the plan that I established. You might recall the anti-Semitism plan that my office put out has as one of its key features education, because I do believe that that is where we can make the greatest progress, is to educate community, educate at universities, educate within the system itself, so that the types of anti-Semitism that we are experiencing today can be pushed back to the margins through a greater understanding of where it is coming from. So a person with academic qualifications and experience in education, and particularly knowledge of the international expertise out there, was a very valuable person in my organisation.
Is there any?
They did not have a role for this person, and it was a very valuable role for me. Having no ongoing role with the ECAJ does not stop me speaking to all the parts of the Jewish community. Part of my role and part of my mandate from government is to consult with the Jewish community. So I do speak to the ECAJ. I speak to the other bodies in the community, like the ZFA, etc. Speaking to community organisations does not show any improper connection, history or bias.
Did the government ask your advice in determining that the ECAJ would be the body that received the most recent funding under the budget? I think...
No, they did not.
Well, did the Minister for Home Affairs speak with you at all about the budget?
No, he did not.
Was this funding important in your mind?
Absolutely. It was a continuation or addition to previous funding that had taken place.
So how is it that there was no communication with your office on it?
It's not a matter for me. It was a matter that for the government to decide how to fund security side of matters. The community. My role does not stop the community speaking to government or the government speaking to community.
Were you aware that the ECAG would be the body to actually distribute the grant funds?
Well, only from the basis of, I had no knowledge of this particular grant, as I have previously said, but previously there had been grants of a similar nature to the ECAG, and they had set up a process, a highly organised, articulated, documented process for distributing the funds throughout the community. So it's not an unexpected thing that the government would use the same process that they had used before.
Do you have any ongoing involvement with the ECAG Harm Prevention Fund?
No, I don't.
The
in my role as envoy, you're speaking, in my role as envoy, I have absolutely no role with it.
I was asking more generally.
No.
The documents, there's a trustee established for the ECAG Harm Prevention Fund. Are you aware of that?
I suppose so.
Yeah. And the documents on the Australian Charities and Not-for-Profits Commission identifies that for the trustee for the ECAG Harm Prevention Fund, it has, under the heading Responsible People, it has Gillian Segal, Director.
Well, then they have just neglected to remove me from that, that registration. What would have been when I was president, that obviously I was in that role, but I'm no longer I have no active role, they don't bring anything to me, so I think that is an oversight on their part.
Well, this is a current document.
Yeah,
on the
but
current
I'm saying it's an
register for the
oversight that they should have
ACNC.
removed me.
When you say they should have removed you, who's they?
ECAG should have removed me.
Did you resign from this position?
Yeah, I resigned from any active role in the ECAG.
When did you resign as trustee for ECAG Harm Prevention Fund? And if you resigned by way of some instrument,
When I resigned as having no further role in the ECAG. So as I say, Senator, they may have overlooked that, but I think it's more of a technical overlooking. I don't sit in relation to the Harm Prevention Fund in any way, and they would have, in the period that I've been gone, which is a few years, I have not signed any documentation or returns to the ACNC.
Will you provide on notice when you resigned from as director of the trustee for the ECAG Harm Prevention Fund, and
Senator,
also,
what I said was they may have neglected to remove me as a director, but when I resigned, let me finish please, when I resigned from their active role as anything to do with the past presidency, they should have removed me. Okay.
Well, this document says it's current as at January of 2026. You see, if you're a director, it's your obligation, you have a director's obligation to take action yourself. And I'm asking you what you did to affect what you say happened, the resignation, and if so, when did you resign, and in what circumstances?
Senator, I will take it on
resign?
notice, but I will inquire from the ECAG why that is still on the register and why they have not recorded me as no longer involved.
No, Mr. Go. You as the director have the responsibility yourself as an office holder. What action did you take? Not what action did another body take.
I resigned from the ECAG itself, and I expected them to have formalised that through the Harm Prevention Fund as well. If they have not done that, it's an oversight on their part, Senator.
You would be aware that the Harm Prevention Fund is a separate legal body, correct?
Yes, Senator.
Yes. So what, if any, action did you take?
I think I've already answered that, Senator.
No, you said you expected another organisation.
The action I took is that I resigned from any further involvement with the ECAG. which in my mind included everything, including the Harm Prevention Fund. But if they have not taken that formal step, I will make sure it is done immediately, but I will also check why it has not been done.
You see, it's for these very reasons that I think there would be a significant benefit if your conflict of interest forms and your interest forms were publicly available, to allow for these kind of matters to be seen in the course of public debate as a public officer. Do you agree that transparency is useful in public office?
Of course.
Right. Thank you for your assistance today.
Thank you.
Thank you, Senator Shoebridge. Senator Blyth.
Thank you very much. And I just have a few last questions for you, and I'll just pick up a little bit on what Senator Shoebridge said, what your response to Senator Shoebridge was, and that in education you can make the greatest amount of progress in the task that you have been set. And we've spoken a little bit about the ABC and the SBS and higher education institutions as not adopting a definition of anti-Semitism and the work that you've got to do there. But even, I guess, through to other organisations like the AFL, where there have been some challenges even within those organisations, are you actively going out and working with those organisations and educating them?
Yes, well, we are working with different sporting organisations, different arts organisations, and different health organisations, actually, where there are problems to engage with their leadership to ensure we get there. Firstly, much as I described earlier, that I think it's the leadership that we first need to engage with. But it's also business. I mean, it is all of business that needs to be focused on this to ensure we have safe workplaces for people who are Jewish people and all minorities. So I think it is a more general thing to have boards of directors and those running these organisations ensuring that there is a strong understanding of anti-Semitism.
Can I ask how many of these organisations, and we might pick up on the AFL, because there have been certainly some issues within that organisation and out into the, I guess, player realm. Has an organisation like the AFL, have they ever proactively contacted you to ask for your assistance?
I would have to take that on notice if they've proactively contacted me. I mean, I do have, albeit a small team, I do have a team, so they might have contacted another person in my team who's working more in the sporting arena. So if I take that on notice.
Yeah, certainly. And in terms of, I guess it is a lofty goal that has been set to have anti-Semitism training done, through the public service. You've got a lot of education to do, not just through publicly funded organisations, but also then, as you've mentioned, into business, into sports, into arts. Do you have the resources that you need to be able to do that?
Well, that is a very big question, a very good question. I am hoping that there will be an independent organisation set up that will pick up some of this training. Discussions are ongoing with community and with museums as to what they can pick up together in order to fill that need, because it's a very clear need, as you've articulated. We have been contacted by many organisations, certainly in the business community, wanting to ensure that they have safe places of work. And so given that need, it is something that I'm very supportive of, and work is being done to try and set up that kind of structure.
Do you have a time frame on that? And you have been set an enormous task. Having a national approach to this is no easy feat. And I don't ask for a timeline to sort of put any pressure on you, but it is going to take lots and lots of different organisations working very closely together in private, in government, our broadcasters, our sporting institutions.
I couldn't have put it better. Absolutely. Well, I understand the urgency. I think it's very important. We are working as fast as we can to set up such an organisation with the right expertise and the right training materials. And I am hopeful that in the next few months we will see it happen.
Fantastic. Thank you very much. Thank you, Chair.
Thank you, Senator Blyth. Senator Pocock.
Thank you very much, Chair. Thank you for your time this afternoon. One of the things that I've taken interest in as a senator is around procurement. And yesterday I was asking Home Affairs questions about a 12-month, $198,000 contract that was awarded at your request to Society Advisory, whose founder is former Prime Minister Scott Morrison's former Principal Private Secretary, Yaron Finkelstein. And they advised me to come back and ask you about it further, as it was at your request. Looking at AusTender, the contract was awarded without a competitive tender under Commonwealth Procurement Rule 10.3D, which says goods and services can be supplied only by a particular business and there is no reasonable alternative or substitute. I was interested in what work is being undertaken that there is only one advisory service in the country that can provide it.
Thank you, Senator. Well, I think that I'm not sure that the premise is quite correct. It was the fact that it was a unique set of circumstances and a unique combination of expertise that was available, but it was also a timing issue. So it was very urgent that I needed some assistance because the Royal Commission had been established and I had been asked to already be involved in the initial statement and giving of evidence. And that is going to be a repeated thing. I'm going to be giving more statements and more evidence, as you would expect, given my work and the terms of reference of the Royal Commission. And so it was important that I needed a specific combination of expertise and of timing, understanding, as I think you might have been discussing yesterday, understanding the Jewish community, understanding the Royal Commission process, degree of working in a pretty compressed time frame and being available immediately. And soundings were made by my office in relation to who was available, and that's in relation to how they came to Society Advisory. Mm-hmm. Somebody who was available immediately, who unquestionably had the right qualifications and background. We went through, a fully compliant procurement process, as you would have heard yesterday from Home Affairs.
You said soundings were made by your office. What does that mean?
Well, who was available, who knew the community in that industry of strategic communications and drafting. And feedback was generally, as I understand it, I did not take these personally, it was done by a member of my team, but the Society Advisory was the almost, I think, I don't know, but certainly came out as the most strongly recommended.
Mm-hmm. And how long were these soundings undertaken for? What does that process look like?
I don't know, Senator, but just as soon as the need was established over a week or so, there was a discussion as to who would be available and who was appropriate. And Society Advisory were both available and had the relevant skills and the connection and understanding of the Jewish community, which I was very keen to have, sure, as well as an understanding of Royal Commission processes and an understanding of the ability to have strategic communications and to write in a clear fashion.
So who was appropriate but not available?
I don't know, Senator.
You don't know?
I don't know if there was anyone. I said soundings were made, and Society Advisory was the party that came forward, that was put forward as the most appropriate.
So, Ms. Siegel, how involved were you in this process? It sounds like not much at all, and it was just advised to you by your team that this was the person?
Yes, Senator. I can't be everywhere and do everything, so I do have members, I do have a team, and I have to delegate to members of my team to advise me. So this particular engagement was one where another member of my team took the primary running, and I was advised. I did interview and speak to Mr. Finkelstein, and I was satisfied that he was an appropriate person to recruit.
But you are the decision maker here.
I am, and I made the decision, Senator. Yes.
And you're the one who's spending $200,000 of taxpayer money on a contract for this, and you have, I assume, signed some sort of documentation that essentially means that you're not going through a usual process, and you're saying there is only one provider who can provide this advice.
At that particular point in time, yes.
Are you sure of that?
Well, Senator, as sure as one can be of these things, I might point out
what does that mean? Sorry.
That contract amount is for the full term of the contract. Well, I think it's a highly specialised and sensitive matter that I was looking for assistance on. I think that there were, to the best of my knowledge, there was a few people who were spoken to around the community as to who was appropriate, seeking input and advice, and the consistent advice was that Society Advisory was probably the best organisation. I was looking for something small, not a very large, complex organisation with multiple state and multiple directors and complex processes. I was looking at somebody I could work with directly, where the sort of key director would be the person delivering the service. I didn't want it to be many layers down and working with some very junior person, because I understood the important nature of what I needed to convey to the Royal Commission.
But Ms Siegel, that's not how Commonwealth procurement works. There is a process for very good reasons.
Certainly, Senator, and I conveyed all this to the department, and the department considered all the material and who was available. And as I understand, the Chief Operations Officer said to you yesterday, all procurement processes were met.
So, Senator, if I could assist, it was actually a delegate within the department that signed the contract, obviously with Ms Siegel's input, and our Chief Procurement Officer reviewed the documentation around the use of limited tender and was satisfied that all requirements had been met. We would be happy to take on notice how those conclusions were reached, but I just wanted to be clear they were departmental decisions.
Yes. And so how many is this a full-time role? How many hours are included in this contract? What services are being...
Senator, we can take that on notice, but there are, pursuant to the procurement rules, the contract has key performance indicators over different periods of time in response to what is needed in relation to the Royal Commission.
So this is not a full-time
No,
role.
no, it's just an advisory contract, yeah.
So $200,000 just for ad hoc advice?
I didn't say that, Senator. It's for, there are key performance indicators in the contract, and it's paid on a monthly basis for monthly...
And so what's...
And again, Senator, it would be my staff who signed off on the value for money proposition, so we'd be happy to take any
That'd be great, Ms Foster. Maybe on notice, like, the invoicing, is it an hourly
No, it's
rate?
monthly. It's monthly.
But included in that is an hour. Do you have to account for the hours that you've actually worked, or is it, even if we don't need any services in March, we still pay you?
I don't know. I have to take that on notice, Senator.
Okay.
Be in the contract.
Senator, we can take that on notice and provide that detail.
Thank you. Have any other contracts been awarded without competitive tender?
I have to take that on notice, Senator. I don't believe so, but I will happily check.
What was the recruitment process for the the staff member that Senator Shoebridge was asking about?
Well, that was not recruited. It was just a secondee, Senator.
Okay.
At no cost.
At no cost
the
to
office.
my office at all.
Sure. Okay.
There was another limited tender. Well, it was a full tender and then a limited tender, and that was Professor Craven, who I retained as an expert. The department went out at my request to tender. We went through the full tender process through various panels that the government has to conduct this independent investigation and assessment of universities, and there was no one from that tender process who wished to tender.
Okay. And what's the value of that contract?
What was the value of that contract? So then we went to a limited tender. I think that was for 2 years, 200,000, but I will check.
Gee whiz. Good business in contracting.
Is a very eminent jurist, previous Vice-Chancellor and constitutional lawyer, who was reviewing documentation from 49 different universities.
In the new contract? Well, that was the previous piece of work.
No, this is the limited tender that I'm referring to, that following a full tender and no one responding to that, there was then had to be a limited tender to find someone. And this is Professor Craven. You asked me the question if there was anyone else, and I've just been reminded that there was one more limited tender, but it followed a full tender. And again, it was conducted by the department and signed off by the department.
Okay. And so, apart from Professor Craven, anybody else?
Not that I can recall.
Okay. Well, thank you very much. I look forward to getting that on notice. Appreciate your time.
Thank you.
Thank you very much. That concludes the questions we have for you this afternoon. Thanks so much for your attendance here. You're released with our thanks.
Thank you.
We'll take a very short suspension while we welcome our next witnesses. We will now resume with officers from the Australian Federal Police. Commissioner Barrett, would you like to make an opening statement?
Yes, please. I have a short opening statement. Thank you. Good afternoon. Operation Health is a Victorian Joint Counter-Terrorism Team investigation into a man and two women who travelled to Syria between 2013 and 2014 to allegedly join ISIS. On the 26th of September last year, the two women and their children returned to Australia from the Al Hol internally displaced persons camp in Syria. The male is believed to be incarcerated in a Middle East prison. On their return, the Commonwealth Director of Public Prosecutions determined there was insufficient evidence to charge the two women. Off the back of that advice, the Victorian Joint Counter-Terrorism Team, which includes Victoria Police, the AFP and ASIO, continued Operation Health while the returnees resettled in Australia. That domestic 8-month investigation, plus the recent return of 4 women and their children from Syria 3 weeks ago, has collected new relevant evidence for Operation Health. That new evidence has enabled a number of search warrants to be executed today at homes in Broadmeadows and Fitzroy North in Victoria. One woman, aged 34, was today charged with entering or remaining in a declared area and being a member of a terrorist organisation. She has appeared before Melbourne Magistrates Court today and has been remanded in custody. Since 2019, 7 men and 3 women have been charged with foreign incursion and terrorism-related offences. A further 2 women have been charged with crimes against humanity and slavery offences relating to alleged incidents while in Syria. That includes the 3 alleged female offenders who were charged on arrival in Sydney and Melbourne on 7 May this year. A 54-year-old Victorian woman was charged with crimes against humanity, enslavement, possess a slave, use a slave, and engagement in slave trading purchase. These offences each carry a maximum penalty of 25 years imprisonment. This woman remains in custody. Her next court appearance is scheduled for 16 June this year. A 31-year-old woman was also arrested in Victoria on 7 May and was charged with crimes against humanity, enslavement, and use a slave. Both offences carry a maximum penalty of 25 years imprisonment. The woman remains in custody. Her next court appearance is scheduled for 4 June this year. And a 32-year-old woman who arrived in Sydney on 7 May was charged with entering or remaining in declared areas and being a member of a terrorist organisation. Both offences carry a maximum penalty of up to 10 years imprisonment. This woman remains in custody. Her next court appearance is scheduled for 15 July this year. Given these matters are now before the courts, we will be limited in providing further details today. However, I am sending 3 clear messages. The AFP and our partners are experienced in investigating complex crimes and are deeply dedicated to community safety. Alleged witnesses and alleged victims can still come forward to assist in our investigations. And those who have returned from internally displaced persons camps in Syria are subject to a range of investigative strategies and will be held account if they are found to have breached Australian laws. Any perceived delay in charges does not indicate investigations have ceased. Today's arrest and charge is a case in point. Furthermore, today I will reveal there are 8 separate Joint Counter-Terrorism Team investigations into the families who have returned from camps in Syria or remain overseas. They are Operation Hawarden Stillorgan, Operation Hawarden Arend's Nest, Operation Bossenstein, Operation Dudelange, Operation Balvenie, Operation Kilgobbin, Operation Gravenhof and Operation Rune. To preserve the integrity of these operations, we will be limited on any further detail that we can provide today. Thank you.
Thank you, Commissioner. We'll proceed to questions and begin with Senator Duniam.
Thank you, Chair. Thank you, Commissioner. Are you going to provide a copy of that statement to the committee?
I believe that is in train, if not already, yes.
Right. Okay. We'll see it when we see it. I want to go to, if I can, something that's been discussed in a number of parts of the committee's consideration over the last day and a half around information sharing between government agencies and between law enforcement agencies, state, territory, federal. Do you have a view on how things are going with regard to information sharing on joint counter-terror operations?
Thank you for your question, and obviously a very important question, and I will throw to my colleagues at the table as well. But I will say from the outset that we have extremely strong and positive relationships with all of our partners in the joint counter-terrorism teams, and as you know, they are located right around the country. We have protected this country for many, many years through the joint counter-terrorism teams, through a number of significant investigations and outcomes. And a lot of those have really never been known to the public in terms of their full significance, but the public can have trust in the joint counter-terrorism teams to be keeping them safe day in, day out. And I might throw on that note, first to Deputy Commissioner Surek, who sits across the joint counter-terrorism teams.
Thank you, Commissioner. Hilda Surek, Deputy Commissioner National Security Investigations with the AFP. As the Commissioner said, we have well-entrenched joint counter-terrorism teams. They've been in place for over 20 years all around Australia. There are processes and structures to coordinate the information sharing and flows. Through those joint teams, there's also a sharing of databases and the ability for other state and territory law enforcement agencies to be able to access our databases as well. And it doesn't just extend to counter-terrorism operations, it extends through our joint organised crime teams that look after organised crime, and also across child exploitation teams. So well-entrenched joint teams that have free sharing of information.
Thank you. Was there someone else who was going to contribute to the answer, or no? Were you going to pass to someone beyond? Yes. Okay.
Deputy
all right.
Commissioner Surek has covered it.
Has
Thank
done
you.
it. Okay. All right. I want to just go to something I asked the Department of Home Affairs yesterday about, and that was around the compilation of the brief of evidence relating to the charges that were laid against the 3 arrivals from Syria, a month ago, and obviously it was pointed out to me that the AFP have a significant role in pulling together that brief of evidence. My questions were around what process is gone through to ensure that other agencies who may have an interest in this information, like the Department of Foreign Affairs, the Department of Home Affairs, insofar as that information might be relevant to whether a passport should be granted or whether a temporary exclusion order might be something worth considering. What process has gone through to share that information you're gathering together in a brief of evidence as you're doing so?
Senator, if I could please, could I ask for some specificity, because there are different processes for different mechanisms. So you mentioned passports, you mentioned temporary exclusion orders. Is there one in particular that you would like us to?
Well, we can start with the temporary exclusion orders if you like, because a temporary exclusion order was applied to one individual. Now that's a matter, as I understand it, for the Home Affairs Department. They provide, off the back of some work ASIO will do. So let's start there. So you've got a brief of evidence being compiled off the back of all of the work you've done in relation to the individuals. It's provided to the Attorney General's Department to seek authority to prosecute, is that right?
So, Senator, there is quite a process. I will first throw to Deputy Commissioner Surek, and perhaps Assistant Commissioner Nutt can also help you with your question.
Thank you, Senator. In regards to developing a brief of evidence, particularly in the joint counter-terrorism teams, as we've said, the joint counter-terrorism teams have multiple agencies that sit within it. So, for instance, in New South Wales, there's the AFP, ASIO, New South Wales Crime Commission and New South Wales Police, and equally in Victoria Police, in Victoria Joint Counter-Terrorism Team, the Victoria Police, AFP and ASIO. Now, as that information is put together, all those agencies have access to all the information that is provided within the brief of evidence, and that's really important because, as well, ASIO has access to that information going forward. In terms of how brief compilation occurs, in terms of its requirement to go to the Attorney General's Department, for instance, it's dependent on the offence type. Not all offences have to go to the Attorney General's. So, for instance, if it was offences for entering a declared area or member of a terrorist group, that would not require Attorney General's consent to prosecute. However, that information, when compiled, would go to the Commonwealth Director of Public Prosecutions as well. But all agencies have those access to that information, and AFP readily shares updates on that information, particularly across our Commonwealth mechanisms and coordination groups. And I know there was evidence yesterday in regards to the senior officials group and the joint operations group that occur. So information flow, pertinent information flows occurs through those mechanisms.
And so just on that, the SOG, the Senior Officials Group, and the JOG, but more this senior group, that when do they have access, or do they have access to the brief of evidence readily at any point in time, or is it made available by the AFP at a point in time when on a need-to-know basis? How does this work?
I would suggest that the way, information, if asked, would be made available will determine thresholds in terms of evidentiary requirements or restrictions, but certainly if asked, we would make it available. Pertinent information that may relate to the individuals or actions that we plan to take, for instance, would be readily shared with all those agencies in the coordination mechanisms.
Yes, because the evidence yesterday was that information was shared just prior to, I think, the announcement, like days prior to the announcement being made around charges perhaps being laid. But you say that if asked, you would share. So if a department like Home Affairs said, can we please see the brief of evidence, the AFP would share it.
We would certainly assess if there was any restrictions, but we don't see a reason why we wouldn't share with our partners, particularly around the Joint Counter-Terrorism team.
Okay, and the same would... Oh, sorry.
Sorry, Senator, I can ask, add to this. Steve Nutt, the Assistant Commissioner representing counter-terrorism at the moment. I'm actually Assistant Commissioner for Global Operations. I've moved on. But in terms of so I'm the SOG representative for the Counter-Terrorism Command. In terms of the manner and form of information, most of that is in terms of briefings. So the senior official group is one who considers the strategic issues. The joint operations group, or officials group rather, is more at the tactical level. Information exchanges occur in a number of forms, both verbally and written. In terms of a physical brief of evidence, which is given to the DPP, Director of Public Prosecutions in the main, it may not include the provision of specific exhibits and things like that, so I don't know how far you want to go into that, but in terms of the key informations that relate to assessments, such as for TEOs, such as ASIO or others may require in relation to passport information, that material is provided through briefings in a number of forms, plus also through direct contact with officials as part of our joint arrangements.
Okay, so to be absolutely clear, it's not a case of requesting, because I had understood earlier that it was a case of an agency or a representative of an agency, either on the SOG or somewhere else in the machinery of it all, seeking the information. You're telling me that it is provided as a matter of course in briefings
in terms of the key aspects that relate to determinations. The brief of evidence is like a folder.
Yes.
So if a department asks to see the brief of evidence, there'd be no issues with seeing that. But that's a document, a folder, an electronic thing that is for the purposes of court. It's not necessarily for the purposes of whether a TEO should be granted or a passport, but certainly the relevant information contained within as a result of the investigations will be passed through departmentally and through those joint arrangements.
Okay, so, and I understand that, yes, it is a document compiled with the intention of taking a matter to court for criminal prosecution, but, as you say, and so to that end, if a department like the Department of Home Affairs or the Department of Foreign Affairs says, could we please see the brief of evidence because we're making an assessment on this individual as to whether they should be issued a passport or there are grounds to refuse, or whether we should apply for a TEO, you're saying that you would provide access to that, assessing if there are any restrictions that should be...
And there's potential restrictions around the form of evidence that's collected. So again, we'll make that assessment and ensure that where there's information relevant to what they're considering, again, depending on the purpose, that's made available.
Okay, and with regard to the charges laid for the first cohort of returnees, was information requested by Home Affairs, Foreign Affairs or ASIO, or access to the brief of evidence for the purpose of looking at whether TEOs should be applied or passports refused to be given or revoked?
I don't recall a request to access the brief of evidence, but certainly over an extended period we'd been discussing in the JOG and the SOG about the status of those matters. In the case of the 7 May group, they were we undertook action by first instance arrest warrants, and we had forecast to relevant agencies that we had satisfied the standard to issue an arrest warrant on their arrival, and when they arrived we executed arrest warrants. So that intention was made clear through communications across the relevant agencies in the SOG and the JOG.
Thank you. I
Thank
have to
you,
share
Senator
the call.
Duniam. Senator Shoebridge.
Well, thanks, Chair. It's nice to see you all here. It's quite a full desk. I have some questions about the AUKUS Command Force. Who's best to deal with that? Is that you?
Deputy Commissioner.
Deputy Commissioner Gale? Yep. Yes. In February, I asked some questions about the AUKUS Command Force. And in answers I got, I was advised that the AFP has been provided with $199.1 million over 2 years, commencing actually in this financial year, to continue to develop and implement the protective security overlay for submarine rotational force west at HMAS Stirling. Is that correct?
Yes, Senator. It's Lisa Gale, Deputy Commissioner. That is correct.
So let's be clear that when you say submarine rotational force west at HMAS Stirling,
yes.
That's a reference to the nuclear submarine base that's been built for AUKUS-related matters just off Fremantle. There's an existing submarine base that's been supersized to become a nuclear submarine base. Is that the one?
Yes.
Yep. Seems a lot of money to be giving to the AFP for just 2 years for security for a single base, which will only have visiting US and UK nuclear submarines at it. How do you get to $200 million for just 2 years of security?
Senator, the funding for the 2 years relates to the following. It will comprise of 199 sworn officers who will provide the protective security overlay at HMAS Stirling. There will be 46 enabling positions which will provide support functions including training, forensics, logistics, finance and legal support. A number of those enabling positions will be located in Canberra and another portion in Western Australia. We will, yes, that's it.
All right.
Senator, could...
Sorry, I can add to the Deputy's comments, Catherine Van Gogh, Chief Operating Officer. So the commencement of operations over in Western Australia is scheduled for 2027. So at this stage, the majority of the funding is to building up our workforce required for the commencement of operations there. So that it includes training, it includes the members going through our recruit college to be ready to start operations when the operations start at that facility.
So this AUKUS AFP Police Command, you're recruiting specifically to have people be part of the AUKUS policing in the AFP, is that right?
That's correct. It's a new function and a new role for the AFP, so we're recruiting a workforce for this function, yes.
And at this stage, the $200 million is to establish and commence the operation of it, and it's just for this one base, is that right?
That's correct.
There was some suggestion that there would be a broader AUKUS policing role for the AFP for this command, potentially policing perceived threats to AUKUS more broadly. Is it going to have any broader role, or is it literally just for this US nuclear submarine base that we're building them?
So the workforce is built around the concept of operations that was designed at the time with the submarine agency around the requirements for the protective security overlay that the AFP is delivering. So that includes a range of security functions to protect the facility being built there.
So it is only at this stage, specifically to protect that facility and only for that purpose.
And yeah, that's correct, Senator. And it is, I just would add that it is 24/7 coverage that will be required. So that references why some of the staffing figures are as they are.
Yeah, but it's on an island, like, you know, with a narrow causeway going to it. I'm still trying to work out how it's $200 million over 2 years to protect an already secure island facility, which you can only get to by a narrow causeway. How do we get to $200 million?
So, as I said, Senator, as per the concept of operations that was designed at the time based on similar facilities in the US and in the UK, that concept of operations was based on and developed with the Australian Submarine Agency. That informed the submission that went to government, and the funding that was provided to the AFP was for the specific functions that we were asked to deliver for defence in securing that facility. So it includes on land as well as on water, marine facilities. It includes boats, etc., required to police and secure that facility.
Is it going to operate at Osborne or Henderson as well, this police command?
This workforce we're building up is specifically for the Western Command, as you flagged. We are in discussions with the government, with Defence, around potential other facilities, but this funding is for the workforce in Perth.
Yeah. I'm having trouble marrying up this answer on notice with what's actually in this year's budget papers too, because I think it's program 3.3 in the Home Affairs budget has AFP-nuclear powered submarine program, and it has this year's appropriations at 54 million and next year's at 87 million. How do we marry the answers I got on notice, being 200 million over 2 years, and what's in the budget papers?
Thank you, Senator. Our funding has been received over a number of years, but we'll just get our CFO to take you through the numbers.
So just to assist, I had it here, one sec. It's page 118.
Great. Thank you, Senator. Paul Wood, Chief Financial Officer, Australian Federal Police. Senator, firstly, thank you for your question. I might just double back just with some references to the budget papers. So this first announcement of the funding for $199.1 million over 2 years was detailed in the mid-year economic and fiscal outlook for 25-26. As Ms Van Gerp has noted, this was to develop capabilities to provide protective security for submarine rotational force west at HMAS Stirling. So that was the first announcement that was in the budget papers. This was then detailed in our portfolio additional estimate statements for 25-26. On page 6, we note that funding of 73.5 million in 25-26 and 125 million in 26-27. With reference to your question, Senator, the difference would relate to what we call equity funding or capital funding. So the reference there to departmental appropriations is largely our staffing costs, and then there would be a balance that relates to equity funding, as well as we will have allocations more broadly across the corporate enabling functions. So with reference to the specific funding, it was contained in our portfolio additional estimate statements and the mid-year economic and fiscal outlook.
Yep. But I also note that this $200 million, you point out, as part of the optimal pathway, and this is the answer to questions on notice, As part of the optimal pathway, the AFP provides the protective security overlay to visiting United States and United Kingdom conventionally armed nuclear-powered submarine visits at HMAS Sterling. Therefore, US personnel may be present at HMAS Sterling as part of their role and functions in support of AUKUS in these visits. So is that, they're the assets you're responsible for protecting? Is it the nuclear submarine assets that you're protecting, or is it the broader HMAS Sterling, which includes potentially some Australian Collins-class submarines? What is it that you're protecting?
It's the nuclear assets, Senator.
But you see, we're now spending $200 million just in this year and next year in protecting the only US and UK nuclear submarines and US and UK personnel. That is the whole of this expenditure to protect two other nations' military. Is that right?
Senator, I'll reiterate what the Chief Operating Officer said. We were given a set of requirements and we designed a protective security overlay to meet those requirements. That was the request from the Australian Submarine Agency, and this funding is commensurate with the requirements that we were providing.
Commissioner Barrett, I know it's not your political call. I'm just trying to understand the task you've been given, and the task you've been given, and you've been given $200 million to do, is solely to protect two other nations' military assets and military personnel. And that's your task over the next 2 years with $200 million. Is that right?
Senator, I think that fails to recognise the location of those assets that you're talking about, and in terms of our national security and the proximity to Australia. So our role as a national security agency is to deliver that protective security agency overlay as requested by government to protect Australia's national security and those assets.
Thank you, Senator Shoebridge. Senator Polley.
Thank you, Chair. I want to go to the Counter-Terrorism Online Centre, and if you could advise the committee what role the AFP has in that recently announced project.
Thank you, Senator Polley.
Senator, sorry, could I just, I just would like to make an overarching statement in relation to that before I pass to the Deputy. I do want to be very clear that our role in countering violent extremism and terrorism is both prevention and early disruption, as well as an enforcement one. And I have said repeatedly, particularly in relation to young people, that shielding kids from manipulation and harm online is one of my key priorities as Commissioner. I have talked repeatedly, as have some of my colleagues, that we are seeing young people being exploited through the online space, not just in relation to extremism and terrorism, but also child exploitation, sadistic online exploitation. We are seeing young people be exploited through what we now term crime as a service. And of course, we are seeing that where it used to take months or years to radicalise a person, in some cases, it's happening in days. So we see the speed and the scale of radicalisation is becoming one of our most significant challenges, especially when it comes to young people. So before I pass to the Deputy Commissioner, in relation to the online centre, it will allow early identification and disruption, particularly to protect vulnerable young people who we know are being exploited online because of their vulnerability, and identify those that are preying on them. It will also provide an early warning system for our joint counter-terrorism teams about hate groups and individuals who are using online platforms to incite or commit violence. I'll pass to the Deputy.
Thank you, Commissioner, and thank you, Senator Polley. As you've outlined, the AFP and ASIO have been provided $74 million over 2 years to set up the dedicated National Centre to detect and disrupt the evolving threat of online violent extremism and terrorism. This threat is materialised through terrorists and violent extremists using social media, gaming platforms, online forums and dark webs to recruit and radicalise others, to plan violent acts and build capability to execute those attacks. We're seeing online areas as being grievance-filled, where people and children particularly are being desensitised to the graphic material that they're seeing. We're seeing private chat groups on social media act as echo chambers and channels for radicalisation and promotion of violence. Of particular concern, as the Commissioner said, is the growing number of young people being targeted and manipulated by violent extremists and terrorists. And of the 32 individuals charged by the AFP, ASIO and Joint Counter-Terrorism Team partners of violent extremism material offences to date, 19 of them were aged 17 years or younger and as young as 13. To dismantle this threat environment, the online centre will enable specialist counter-terrorism investigators and intelligence analysts to identify and assess potential threats within these high-risk online spaces. The centre will enhance coordination across Australian jurisdictions regarding the disruption of extremist content and activity, including through some COVID disruption and engagement. This capability will also enable the triaging of threats to progress these investigative actions under the National Joint Counter-Terrorism Teams and National Security Investigation capabilities. As more people are seeking to advocate hatred, fear and violence online, the centre will work to disrupt and intervene early those individuals and their criminal behaviour.
And Senator, could I just add that the landscape that we've just described to you, we are seeing that across the world. So a lot of our law enforcement colleagues, particularly our Five Eyes colleagues, but indeed right across the globe, are challenged by the same significant concerns, so much so that when I travel to the UK next month for the Five Eyes Law Enforcement Group annual heads meeting, there will be a focus at that meeting on vulnerable communities, specifically young people, and how we build an alliance with big tech companies to use AI and other emerging tech to combat these challenges. As we all know, the tech companies have a big responsibility here, so we will be working with the tech companies in terms of what they can bring to the table to assist us to protect young people.
From the experience, because we already have centres in dealing with child exploitation and cybercrime, so that experience, what lessons have you learned there that you can implement now in this new centre?
Thank you, Senator. I think there's two Deputy Commissioners that can talk quite passionately about both the JPC3 and the ACE, so I might start with.
Thank you, Commissioner, and thank you, Senator Polly. Critically, it's about the power of partnerships. It's making sure that we are incorporating traditional and non-traditional partnership, as the Commissioner has noted, in terms of engagement with tech companies. There's a big role to play here across the whole system of involvement. Our observation is by the time it becomes into law enforcement arenas, there are probably a number of steps beforehand that could have been early intervention points. So using those partnerships to make sure that we can have that early engagement and divert through the pathways is really critical. The other part that of lessons that have been learnt as well is particularly around the education and awareness that we can raise through this centre. The power of what we've been doing with the JPC3 and the ACE, as you highlighted, those education and training and awareness packages out to the community, particularly around efforts that they can have insight on and indicators that they can consider in terms of providing early intervention conversations with their children is really critical. So they're the sort of two key pillars of lessons that I think that we will bring certainly very early into the centre, but happy to hand over to the experiences through the ACE, through my deputy colleague.
Thank you, Senator. Certainly from the Australian Centre to Counter Child Exploitation's perspective, similar to my deputy colleague, her observations, the partnership approach, particularly with our state and territory counterparts, how crucial that is to ensure that we harmonise and augment any law enforcement response to some of these challenges so that we minimise any gaps in terms of a policing approach. I think similar to my colleague, the prevention component can't be understated, and how critically and important it is to engage families and parents particularly. Some of these conversations are difficult, and we know parents find it challenging to have these conversations with their children. So that really plays such a critical role in that awareness, education and prevention piece, but equally talking to students themselves through schools. We know through the ACE, the Think You Know program plays a really pivotal role in that education of not students but also teachers and also parents. So, and again, partnership approach between the states and the Commonwealth. In addition to industry, which my colleague and the Commissioner touched on, which we know, given the connected nature of all of these activities, in addition to partnering with industry, the NGO, civil society, they also play a really critical role in how our approach to tackling some of these challenges. So having those partnerships, we can't do it alone, and they can often reach elements of the community that we as police cannot. So ensuring that we have that partnership approach from all sectors is critical.
My question now relating to funding is not questioning whether you're getting too much money, like my colleague, but has there been a decline at all with the funding that the government's provided for these very important centres and the work that's done?
Thank you, Senator. I might pass to the Chief Operating Officer, who can talk through a number of the recent funded initiatives and our overall funding.
Thank you, Commissioner. Senator, we're very pleased to be able to say that we did receive additional funding in the latest budget that was released, $316.6 million additional funding for 26-27 and $465.1 million over the forward estimates. Our total resourcing for 26-27 is $2.59 billion, which is $204.8 million higher than this current year's resourcing. So we do continue to grow. Compared to 22-23, we've had a 40% increase in our budget and an 11.4% increase in our ASL. We're currently the largest we've ever been. Our headcount is 8,666 as at the end of May, with an FTE of 8,057. So positively, we do continue to grow. Internally, however, we obviously see an increasingly busy environment that we're faced with, so we continue to draw on our operational prioritisation within our agency. It's a very robust, mature process that we have through our Tasking and Coordination Centre to make sure that our resources are aligned to the highest threat to government priorities and to our internal AFP strategy as well.
And Senator, I might just draw attention to our National Security Investigations teams, for which we received funding earlier this year, and how much work those NSI teams have done since they commenced. They are focused on hate crimes and crimes or targeting of high office holders. And they have been incredibly busy and effective in terms of taking swift action and arresting and charging very quickly to send a very strong deterrence, particularly around hate crimes, but also, as I said, around threats and offensive communications targeting high office holders. I'm not sure if you wanted to just run through a couple of stats.
Thank you, Commissioner. Absolutely. The government's funding that have been provided, we've been able to amplify the national security investigation teams and framework. We have teams in Sydney, Melbourne and Canberra, and we will be expanding those teams certainly to Western Australia, in Queensland and beyond as we develop the framework. But since the introduction of national security investigations, we've charged 41 individuals with Commonwealth offences. Of those 41 individuals, 12 individuals were charged in direct relation to anti-Semitic conduct, and one of those individuals have been charged with an offence relating a threat against a high office holder as well in relation to anti-Semitic conduct, and 29 individuals were charged through these operations that direct relate to offences and threats against parliamentarians and high office holders.
Thank you. One more? One more question.
Final question, Senator Polley.
Yes. The collaboration between the Australian Border Force and yourselves, I think the evidence that they gave us earlier today about the increase in child exploitation material and people being charged and found at the border, how important is that collaboration to the AFP?
Senator, I can answer that question for you. That collaboration and partnership is crucial if Border Force didn't have that profile, that jettison profile, that is incredibly accurate. There would be quite a significant number of child sex offenders entering our country that we would not be aware of, and as we all know, likely that they would then potentially continue to contact offend, but also share any of the child abuse material potentially that they have obtained whilst offshore. So that partnership approach is absolutely vital. And if I could just add, this year alone we're hitting the high of 82,000 cyber tip line reports coming in to the ACE. That number sadly continues to grow at a rate we can't keep up with. So, a partnership approach is always going to be preferred in order for us to be able to respond to this ever-increasing crime.
Thank you, Chair.
Sorry, Senator, if I could also add, our relationship with Border Force extends way past just one crime type. I mean, they're very critical as partners, especially in organised crime arena, particularly around seizures at the border, and now as they lead the illicit tobacco task force that the AFP now is a part of. So those partnerships that we have with them, and particularly their role in the joint organised crime teams around the country, gives that seamless partnership that we have with Border Force.
Thank you, Senator Polley. Senator Duniam.
Thank you, Chair. So back to the issue we were discussing before, you made it clear to me that there are those ongoing conversations around, at the SOG, around the information that might be contained in the work that ultimately is the brief of evidence that leads to a request for authority to launch a prosecution. But to your knowledge, no other agency, Home Affairs, Foreign Affairs, had asked for access to that file. I was just reflecting on the opening statement the Commissioner made with regard to the charges that had been laid, with regard to one today in particular. One woman aged 34 was today charged with being a member of a terrorist organisation, for example, and I don't expect you to commentate too much specifically on the charges and evidence leading to those charges. Are the Australian Federal Police a competent authority for the purposes of the Passport Act 2005?
Senator, yes, the AFP is a competent authority in relation to the Passport Act.
Yeah, okay. So I was looking at this. So one woman aged 34 was today charged with entering or remaining in a declared area and being a member of a terrorist organisation. And then the Passport Act 2005, Section 14 says if a competent authority, which includes the AFP, suspects on reasonable grounds that if a passport were issued, the person would be likely to engage in conduct that, and it goes through a range of things, including prejudicing the security of Australia, might endanger the health or physical safety of other persons, might interfere with rights or freedoms, might constitute an indictable offence against this Act, might constitute an indictable offence against a law of the Commonwealth, being specified in a minister's determination, and it goes on. Was it ever considered that an application to have a passport refused, given you're a competent authority, should be made to the Foreign Minister in the course of compiling the evidence you were to apply charges?
So, Senator, in regards to assessments made in regards to passports, that is certainly ASIO's role in terms of that aspect, but certainly for us, our role is to investigate criminality, and we would utilise the appropriate legislation for the specific purpose of what the AFP's remit is that we undertake investigations for a criminal purpose.
And Senator, could I just restate what I said in the opening? It was, so the woman that you just referred to, that I referred to, the Operation House Arrest, I did mention in my opening that after an 8-month domestic investigation, plus the recent return of for women and their children, we collected new relevant evidence for Operation House. So there's been a lot of work done since they returned home.
Although this one, was this one of the 7 May returnees, the 34-year-old that was charged?
No, sorry, I was referring to the woman that was charged today.
Right, okay. Just on it's ASIO's responsibility to perhaps make such an application. You are a competent authority, so it would be within your remit to do so, for a start.
And Senator, as the Commissioner has said, I mean, yes, in terms of competent authority, but in this circumstance, particularly around the example that you've provided related to the woman that was charged today, she's arrived in September 2025. The investigation was continuing, and without putting too much detail out there because it's before the court, the relevancy of us being able to get to a threshold to charge has now occurred.
Okay, understood. Well then, if we go to the 54-year-old Victorian woman charged with crimes against humanity, enslavement, possess a slave, use a slave, engagement in slave trading, purchase, those, can we just actually step through the elements of those crimes? Do you have those there, just so I can be fully cognisant of the
specific elements of the offence, Senator? I'd have to draw upon I don't have the specific elements of the offence with me, only the charge.
That's fine. If we do, through the course of the evening, have those, that's great. But so this individual, the 54-year-old Victorian woman charged on arrival on the 7th of May, is that correct?
That's correct.
So the work was being done prior to this individual's arrival. And so this Act, the Passports Act, Section 14, specifically refers to conduct that might interfere with the rights or freedoms of persons, whether in Australia or a foreign country, set out in the International Covenant on Civil and Political Rights. Article 8 of that covenant says no one shall be held in slavery. Slavery and the slave trade in all their forms should be prohibited. Again, I ask that question, was contemplation given, as you're a competent authority, to either make a request of the Minister, given on my very bush lawyer reading of this, to have a passport revoked, because this is prior to their departure from and arrival in Australia, the work being done to pull together a brief of evidence that enables you then to get authority to proceed to prosecution and lay charges, or go to ASIO and say, hey, we've got something here, or that would have triggered ASIO's interest and get them to, and we'll ask them, of course, about this when they appear later today.
Senator, first can I just clarify for you, you asked earlier about ASIO as well. ASIO is part of the Joint Counter-Terrorism Team, so all of these investigations that we're talking about and the subsequent charges, ASIO had all the same information that we did in relation to that, and of course they're an intelligence agency, so they may have access to different information at a higher classification as well.
And just on that, sorry, if I may, just on that issue ask, so do they contribute to the compilation of the brief of evidence that is pulled together for submission to the AG?
So the policing agencies are the one who collect evidence. Obviously, ASIO being a member of the Joint Counter-Terrorism Team and using their statutory functions can collect material that is of evidential value that does form part of a brief of evidence. However, the ASIO retains their function as an intelligence agency, so just to ensure that they're not a prosecuting authority in that sense, they're a supporting agency to the prosecution. But going back to your question before around the issuance of passports, so from my understanding, Senator, is that we would contribute through ASIO on any potential assessment around whether a passport has been issued. We don't have a direct function in cancelling passports or making assessments about passports that I'm aware of. But again, as the Commissioner rightly pointed out, and the Deputy, ASIO are part of it. We have a collective understanding of what's available, and should there be a strategy that information would be used for that purpose, that material would be available.
So ASIO, also a competent authority, but as you say, have prime responsibility for making these recommendations, have full access to that brief of evidence the whole way. They don't need to ask, unlike Home Affairs or Foreign Affairs. Is that correct?
I know you keep referring to a brief of evidence. A brief of evidence is a product for the prosecutor, but yes, the correct, information that is on which a brief of evidence is created is material available to the joint counter-terrorism agencies, including ASIO.
Okay, and they have full access to that. Well, I will ask them about that because, as I say, you made the point with regard to the 34-year-old individual, and that makes sense to me that the work continued after arrival, so this is slightly less relevant. But for the 54-year-old who was arrested on return with charges that relate specifically, as far as I can read, to elements of the Passport Act, I would be very interested to understand why it was determined not to proceed that way, and why no request was made by other agencies to perhaps look closer at this information. Can I ask, with regard to, just on passports as well, Section 37, I think it is, makes it an offence to carry the passports of people other than yourself across international borders unless you have authority to do so. Has any complaint been made to the Australian Federal Police around a contravention of that Act relating to these returnees?
Senator, no, none that we've been made aware of.
And how would that be something brought to your attention by private individuals, by reports in the media, by the Department of Foreign Affairs and Trade and their Passport Office?
It could be provided through various means, as you say, through members of the public if it's an allegation, or identified at the border through Border Force, or other means. And we've received that information, then we would make the assessment on the material that's presented before us.
If someone says on public record in a media interview that they were carrying 35 passports from Australia to the Middle East, is that something that would pique the Federal Police's interest?
In regards to that, and in terms of the authority that someone might have had, I mean, we would have to sense check that, and that would certainly be an authority that would need to be discussed through DFAT.
Did AFP raise this with DFAT, or would you wait to hear from DFAT to do anything about it?
Well, we would wait to see if there was any impropriety in regards to the assertion that's made that someone is in possession of passports that they're not meant to be.
Right, so we'd wait for... Sorry, yes?
If DFAT raised with us that there was a concern around the authorisation that attached to those passports, we would look into it. Outside of those circumstances and specific reports of crime that raise a lack of authorisation to carry those passports in that way, there would be no consideration to look at that further unless there was concerns raised that there wasn't authorisation in that circumstance.
Okay, I will prosecute that with AFP, with DFAT. Do you want to...
You're welcome to roll into another 10-minute block.
Oh, sure, excellent, okay. Did you want to...
10 minutes, perfect.
Yes, so we'll...
Senator Cash.
Thank you. And thank you, Senator Duniam. Commissioner, I just have some very quick process questions in relation to the arrest of Ben Robert Smith. Can you confirm that Mr Robert Smith was arrested by the AFP and OSI officers at Sydney Airport on the 7th of April 2026?
Thank you, Senator, for your question. And of course, I do note the significant interest in this matter. Firstly, it's important that I acknowledge up front that there is a criminal prosecution in its early stages before the courts, and the individual concerned is, of course, entitled to a fair trial. Yes. I'm very conscious of this, so I'm going to choose my language very carefully. However, I know you and many members of the committee and indeed the community have a legitimate interest in this matter, so we will, of course, be as helpful as we can. I will provide a substantial outline of the matter, which
you very
should
much.
answer
Thank
the
you.
majority of the questions I think that you will have.
Thank you.
And it is for this reason that I ask you politely to allow me to provide this information. And then, of course, if you have any further questions, I'm happy to determine if we can assist further or whether we need to take them on notice. So in November 2020, the then government of the day established the Office of Special Investigator to undertake a range of tasks, including to work with the AFP to investigate the commission of criminal offences under Australian law arising from or related to any breaches of the laws of armed conflict by members of the Australian Defence Force in Afghanistan from 2005 to 2016, and to develop briefs of evidence in respect of any offences that are established for referral to the Commonwealth Director of Public Prosecutions. The joint OSI investigations teams have consisted of sworn police and professional members from the AFP and AFP special members seconded from the Australian Border Force, as well as New South Wales Police Force, Queensland Police Service, Western Australia Police Force, South Australia Police and Victoria Police. Some OSI members were sworn in as special members of the AFP and exercise AFP police powers. In December 2021, a joint investigation commenced into allegations that members of the Australian Defence Force engaged in specific instances of war crimes murder while deployed to Afghanistan. The operation is called Emerald Argon. This investigation resulted in a former member of the Special Air Service being arrested at Sydney Domestic Airport on 7 April 2026. Resources allocated to Operation Emerald Argon have varied over time. However, a senior investigating officer and a deputy senior investigating officer are responsible for day-to-day operational decisions relating to the operation. Operation Emerald Argon is subject to oversight by the Operation Emerald Sensitive Investigations Oversight Board. We call that the SIOB. The SIOB relating to this matter is chaired by Deputy Commissioner Ian McCartney. On 31 March 2026, the SIOB supported the proposed charging of the individual on 5 charges, war crimes murder.
Did you say the 31st of March?
31st of March,
Thank
the
you.
SIOB supported the proposed charging, subject to the consideration of the Commonwealth Director of Public Prosecutions and subject to the consent of the Attorney General. Yes. The OSI was notified of the Attorney General's consent on the 1st of April 2026. This authorised the operational planning for the arrest and charges. As outlined in publicly available material put before the court, the individual had no known fixed abode, and OSI had received information that the individual was planning to relocate overseas. An operational decision was made to arrest the individual at Sydney Domestic Airport on the 7th of April 2026. Because of requirements under ministerial guidelines or those that were directly or indirectly involved in the investigation, there were 9 agencies or departments that knew of the date of the arrest. A decision was made to arrest the individual at Sydney Domestic Airport for a number of operational reasons, including airports are sterile environments, meaning people are screened, plus the area is contained, meaning it is safer to take action for our members and members of the public. It is not uncommon for the AFP to arrest individuals at airports. The reason to arrest the individual in Sydney and not Brisbane was an operational decision that was determined after discussing with relevant partners. However, I will say the media speculation about why he was arrested in New South Wales over Queensland is inaccurate. We were aware the individual would be travelling with family. As such, members of OSI were deployed to the airport to assist with those family members. One media outlet was at the airport at the time of the individual's arrest. I am not just disappointed the media outlet was there, but I am determined to find out how they knew of the arrest. I have no evidence to suggest the AFP provided information to the media about the date or the details of the arrest, but out of an abundance of caution, the matter has been referred by the AFP and the OSI to the National Anti-Corruption Commission. But I want to be very clear, and this is really important. If the date of the individual's arrest or other sensitive information was disclosed to anyone in the media, this could be an unauthorised disclosure, and in my view, anyone who disclosed that information should face consequences. I also want to address reports that the individual offered to present himself to police ahead of a planned arrest. For a range of reasons, including the seriousness of the charges, which are 5 counts of war crime murder and carry a maximum sentence of life imprisonment, this was determined to be an unviable option. In relation to footage of the arrest, which was taken by AFP Media, it is within our normal processes to take this footage for serious allegations of criminal offending. Speaking generally, we make footage available to the media for a number of reasons. For example, it officially documents the arrest of an individual, and it is a single source point of truth in an era where we see deepfakes and mis and disinformation. We have seen in other countries where mis and disinformation can lead to significant safety issues. The AFP does not allow media to undertake ride-alongs, unlike other police agencies, and we do not invite or include the media in AFP operational activity. We do not allow or want media at our search warrants or when we are arresting individuals, particularly at dangerous locations or for those being charged with serious offences. The trade-off is that we will provide footage to the media with appropriate safeguards to protect members and crime scenes. The footage is attached to a hightail link on our media releases. Over the years, we've also been asked by politicians if they can do live television crosses while we're executing search warrants. We will not allow this either, and we've been very forceful that this is a red line for the AFP. If it is operationally sound and in the public interest, we will provide the footage to departments or agencies which also use it as part of their crime deterrence messaging, and we also use footage of arrests to educate about crime prevention and use it as a deterrence tool. There's been multiple occasions when publicly released footage has led to more information and evidence from the public. It is a tool we use to assist investigations. At its core, the AFP and OSI have made principled and legally sound decisions during this investigation, consistent with legislation and governance. We take an oath that we will faithfully and diligently carry out our duties without fear or favour, without affection or ill will. This is an extremely important point. The Australian public can know the AFP will determine cases on the evidence in front of us and not because of name, fame or background of any individual, and that is the right thing to do. Thank you.
Commissioner, thank you. That was a very comprehensive statement, and indeed you are correct. You did answer the questions that I had for you today. What I will do is I will have a look at that statement, which I assume you will table. You've read it out in any event, and I may put questions on notice, but can I thank you? As I said, you did answer the questions I have, so thank you very much.
Thank you, Senator.
Thank you, Senator Cash. Senator Duniam.
Okay, thank you very much. If I could go to well, in fact, let's start again on this theme of information sharing amongst agencies and also with your counterparts at state level. In the Australian newspaper today, there was some commentary around the Royal Commission and evidence that had been given, I believe, yesterday. And I refer to evidence of a Mr. Hudson, who I think is a Mr. Dave Hudson, maybe, David Hudson. And I quote from the newspaper, which I believe to be accurate. It says, Mr. Hudson agreed a review was needed and said federal authorities had used a protective security policy framework which regulates joint investigation information sharing to withhold critical details. I've observed different agencies having different interpretations of the PSPF in relation to what is allowed to be shared between agencies, he told the Royal Commission. Were you aware of that statement, for a start?
Yes, Senator, I was.
And does the AFP have a different interpretation to other agencies around the framework?
Senator, I'll pass to Deputy Commissioner McCartney to answer your question.
Thank you, Senator. Deputy Commissioner Ian McCartney. And I go back to what the Commissioner said before in terms of, from a partnership perspective, in terms of the great relationship and the engagement we have with agencies such as New South Wales and ASIO through the JCTT. But the PSPF does not prevent sharing, but it actually shapes how information is shared, particularly where classification systems, compatibility and security obligations differ across jurisdictions. What we're really talking about there, Senator, is when we receive information at the high side where there's a higher classification, and that information is required for law enforcement action. So how do we move that information from the high side to the low side? I spent 7 years working in the CT environment, that including working with Deputy Commissioner Hudson on a number of cases where that process worked extremely well. And I'll go back to the aviation plot in 2017, which could have been quite catastrophic for the Australian community. Within 24 hours of high-side information being received, that information was able to be translated to a lower classification.
24 hours, did you say?
24 hours was able to be provided to law enforcement agencies through the JCTT, providing us the ability to take action and prevent what would have been a pretty catastrophic event.
Okay, and Mr Hudson goes on to say, from our perspective, we take a very open interpretation of the PSPF, and if there is a risk or a threat, we will share information with other agencies, but other agencies can, on occasions, not be so forthcoming. He said this had made it difficult to deal with other agencies. I mean, do you have any reflections on that? Have New South Wales Police communicated anything of this nature, a concern around your approach to information sharing and how you might deal with it in the way the Deputy Commissioner has outlined it?
Senator, I just am thinking we're traversing topics that are very front and centre in the current Royal Commission block of hearings, and we have AFP witnesses that are due to appear this week, and indeed have appeared this week and into next week. So I'm quite mindful of that, and that we are probably traversing into territory that we need to leave to the Royal Commission.
Okay, on that basis then, I'll take you to the Select Committee on the relationship between the Dural Caravan incident and parliamentary debates on legislation, which was held on the 7th of April last year in the New South Wales Parliament. Are you familiar with that?
Yes, I am.
Yes. So similar points, it's been brought to my attention, were made back then with regard to interaction between New South Wales Police and the AFP insofar as it relates to information sharing. And a point was made to start with, and I'd just be interested in how, firstly on a time frame here, so the Management Committee, which I gather is the committee comprised of officials from, or representatives of both jurisdictions, is that correct?
Without it in front of me, I couldn't be sure, but I would suspect that's referring to the Joint Management Committee, which is the JMC, that is the Assistant Commissioner level committee that sits across the JCTT.
Okay. So it says here, the Management Committee, this is a question from the Honourable Susan Carter, knew on the 21st of February that it was not a terrorist plot, but it took until the 5th of March for that advice to be prepared by the AFP. And Mr Hudson confirmed that in evidence. And so he goes on to state in that evidence that there was a period of time, in that period of time, the New South Wales Police were aware of information that, in their view, drew a massive question mark over the veracity of the claims being made around what had actually happened in Dural. Would that be as a result of information not being shared in the way Assistant Deputy Commissioner Hudson had referred to in the evidence? What's the cause for this breakdown between New South Wales and AFP on this matter?
Senator, again, I'm concerned that we are traversing territory before the Royal Commission, and I'm very mindful that indeed we have a witness at the table from the Royal Commission. So I'm sorry, but I think these are questions that are subject to the current Royal Commission.
Does the Royal Commission cover the Dural caravan incident?
I can offer. I am a witness in the Royal Commission, Senator, and in my open evidence on Monday, I was asked about the Dural caravan incident.
Well, Commissioner Barrett, can I ask you about a statement that's referred to here by the Honourable Bob Nanva, and we'll see if you're able to answer this, noting what you've said. He says in this hearing, in a question to David Hudson, notwithstanding your suspicion that this whole incident was a criminal enterprise, I'm going to read a statement from the AFP Deputy Commissioner, Chrissy Barrett, at the press conference of the 10th of March. She stated, the JCTT discussed providing this information earlier to the public. However, during our investigations, we continue to receive tip-offs about other terror plots related to this matter. Out of an abundance of caution, it was agreed by all agencies that the operation would remain a JCTT investigation. While we were confident all of these tip-offs were fake, we could not risk ignoring the information provided, and we kept investigating at the highest level. That was your position as well as New South Wales Police's position, and David Hudson says, that's the AFP's position, sir. My position is slightly different. They, of course, went into camera to discuss that. That matter is closed, and I know it is. You've referred to it in your opening statement at the Royal Commission, but is there any reflection on, when it comes to information sharing between federal law enforcement authorities and state, that you can provide to us that would deal with some of these concerns?
Senator, again, you've heard from a number of us at the table today talk about the strength of our relationships, not just through the JCTTs, but through other highly effective joint task forces that we share with our state and territory colleagues. But beyond that, as per Assistant Commissioner Nutt's comments earlier in relation to the Royal Commission and his evidence, and the fact that we still have quite a way to go with the Royal Commission, I'm not prepared to provide anything further on that one.
Okay. Has the AFP ever requested New South Wales Police or any other state police force member who are part of any JCTT to sign a non-disclosure agreement?
Well, we did in that case, Commissioner.
Yeah, Senator, again, I wonder if I can take that one on notice as to whether and how to answer it. Again, I'm mindful of the Royal Commission and that this will be subject to the Royal Commission. I know there's been public reporting in relation to the media reporting around a non-disclosure agreement, but I'm not prepared.
Asking in general terms whether that has ever happened, which would be a yes or no answer, not related to an event. No details related to an event, an investigation into or cooperation with a state or territory law enforcement agency. It's just a straight down the line, has it ever happened?
Yes.
Thank you very much. Do you want to
rotate the
Yes,
call?
of course you can. Yeah.
Thank you, Senator Duniam. Senator McDonald.
Thank you very much, Chair. Commissioner, the AFP plays a part on the Electoral Integrity Assurance Task Force. Is that correct?
That's correct.
What is the AFP's contribution to this task force in terms of activity and type of advice provided? What sort of issues, without getting into specific details?
Thank you, Senator. I'll pass to the Deputy Commissioner.
Thank you, Senator. Our role in the Australian Electoral Task Force is to work with the agencies, particularly around the Australian Electoral Commission and other cooperating agencies, and we have an investigative function if reports of crime are received, but also contribute to the forum and higher level strategic meetings to ensure that we are able to preserve the democracy of elections.
How many matters have been referred to the AFP for investigation to date from the task force?
Specifically, I'd have to take that one on notice, or I'll come to it throughout the hearing.
Thank you. Does this task force specifically look at general elections, by-elections, or nothing outside of elections?
It would look at those that relate to the Commonwealth elections.
What kind of matters might be of concern?
Sorry, I could just add value there. The remit does apply to federal arrangements. However, the AEC does offer the electoral integrity task force for other elections as well, where those jurisdictions do apply. However, in terms of the role of the AFP in that task force, we are limited to federal Commonwealth offences and in those circumstances specifically around potential foreign interference offending.
Thank you, that's very helpful. What kind of matters might be of concern to the task force? I note that there has previously been referrals for spam emails in by-elections. Full stop. Question mark.
Any matter that might go towards the fraudulent nature or intimidation even at electoral booths during election cycles, they will all be matters that would be ventilated through the task force and then be brought into the AFP to assess for investigation.
Are activities by trade associations or other organisations monitored or considered or taken into account?
Trade associations, could I ask you to explain that one? Sorry, Senator.
Exactly that. Peak bodies, groupings of organisations, unions, gatherings.
Certainly, I mean, the AFP will certainly investigate if matters relate to a union, particularly around corruption or organised crime, but I'm not linking that to the work that we do through the Electoral Commission.
There may be circumstances, Senator, where the AEC, the Australian Electoral Commission, raises issues around conduct of organisations, I'll say more broadly, to capture all of what you're referring to, that may relate to electoral offences that occur during specified periods of an election when and there are rules, of course, that apply during election period around public statements and the like, which at times do result in reports of crime from the Australian Electoral Commission to the AFP for consideration.
Thank you. What about foreign businesses or foreign government-owned business investment?
If they would traverse Commonwealth offending, then yes, the AFP would certainly be the investigative organisation.
Does it monitor, and by this I mean the Electoral Integrity Assurance Task Force, does it monitor activity outside of the peak voting periods where political campaigning can still exist on policies or budgets?
The task force comes together more regularly when there are peak periods, but there's still engagement that occurs outside of those peak times. So those circumstances where things are ventilating or there's an issue, there are ongoing opportunities throughout the year for that to continue and that to be passed into the AFP.
Right. Does the AFP see a need to expand, upgrade or increase the role of the Electoral Integrity Assurance Task Force and its contribution?
Well, we certainly know that the task force works effectively from particularly our purposes and my engagement through senior levels. We are able to engage with the right levels and provide the right skills and capabilities for the matters that are coming before us.
Is the AFP aware of foreign interference in overseas jurisdictions that has had an impact on economic policy, specifically in the energy realm?
We have not received any specific reports of crime that relate directly to that.
Is the AFP aware of the impact of overseas activist campaigns being weaponised by foreign powers to impact the economic and investment climate of other countries?
Well, the AFP work with our partners, particularly around the Foreign Interference Task Force, in terms of understanding threats and trends, but I won't say any more than that.
Thank you, Chair.
Thank you. Senator Duniam.
Thank you very much. Now, just on the matter of the returnees from Syria, the so-called ISIS brides, can I just ask about, and I know this is a joint operation with the two state law enforcement agencies, Victoria and New South Wales, what planning and what modelling, what cost, what assessment of resources has been done about what's required to support, manage, deal with the presence of these individuals in the community?
Senator, thank you. I'm not going to talk specifically to costs for security reasons. It wouldn't be appropriate to disclose, but certainly each matter would be taken case by case. We would allocate the appropriate resourcing and capabilities for each individual matter and collaborate, as you highlighted, with our states and territory partners to provide the right inputs into that. And as we've already put on evidence, a lot of these matters have been investigated for many, many years. So giving you a definitive cost would not be able to be useful.
Well, I'd find it useful to understand. So I'm just, have costs been identified? Has a figure been budgeted?
Well, the AFP is budgeted to undertake these activities through our baseline budget. So
sure, in a broad sense,
in the broader sense,
yes.
This is the role of the AFP.
Yes.
We'd investigate crimes, and we'll, for those individuals that return, we'll respond. That is part of our remit.
So I understand you're provided for by the taxpayer of Australia to do those jobs in the broad sense, but obviously there is an effort required, that's obvious to all of us, to deal with to some degree, and I know part of that will be unknown because there are matters before the court which could have any number of outcomes, but was there a specific allocation budgeted for to deal with this?
As I said, it's through the joint counter-terrorism teams. So those are the teams that will look after this. So there's nothing extra has been aligned into the joint counter-terrorism team specifically for these matters.
Senator, I might just ask our Chief Operating Officer just to explain how our budget is allocated and then how we allocate resources from there.
Thank you, Commissioner and Deputy. So, Senator, our CT budget that we have, if that's what you're referring to, is historically made up from a range of base funding that is within the AFP, as well as targeted national new policy proposals, MPPs, that we receive. So, for example, in the latest budget, you would have seen, and we talked about earlier today, we received $68.8 million to uplift our national security investigation teams. We received $74 million over 2 years with ASIO for the CTOC Centre. We received $35 million in the 26-27 budget to continue our HARTO funding. But within the AFP, so we have specific funding to deliver specific activities, but our base funding allows us to maintain an agile and deployable workforce where we surge to where the highest priorities are. We have our AFP Task and Coordination Committee that meets weekly to set those priorities and move resources around as needed to meet the demands that we have operationally.
Okay, and so the point that was made before around there's been no additional funding provided to the JCTT operations that you undertake, and I guess in this case we're talking about New South Wales and Victoria. So it's whatever was allocated at the beginning of the financial year, that is all that's been allocated, not $1 more to deal with these issues. Is that your evidence?
Well, that's my evidence, but equally the way that the AFP allocates its resources, if we just talk for the AFP's perspective,
sure, yes,
is that based on prioritisation, based on the resourcing, the capabilities, the enabling that's required, we move those flexibly across the organisation depending on the priority that's come in. And we've heard evidence before, and particularly the Commissioner saying that CT is one of the highest priorities for the AFP. So there's, we would mobilise the resources as needed.
So to that,
as I flagged before, whilst we don't have a line item in the budget that's for returning women and children, we have received additional funding for CT activities for the AFP.
Okay, and has any of that additional funding been allocated for returning women and children?
Well, the additional budget that comes into the CT, as the Chief Operating Officer has said, would be aligned to the activities undertaken by the Joint Counter-Terrorism Team.
And do we know, have we, because we don't just sort of go through the year hoping for the best. There is planning, and I'm sure that the Chief Financial Officer makes sure all of you stick within your budgets and plan your expenditure. So I'm trying to understand with regard to, because we've been planning for this for some time, more than a decade now, surely some thought has gone into how much it might cost to do any number of things required. I don't want a specific dollar figure. My question was simply, has further resource been allocated specifically to that? We've sort of traversed the high level at the counter-terror effort, but for the purposes of the people that have now returned, is there extra AFP resource either planned to be or actually now being deployed in relation to that?
Well, as I said before, we would absorb the requirements that are coming into the Joint Counter-Terrorism Team with the current resource platform. We would move people in as required. And each of these matters, as the Commissioner outlined before, each has its own operation, and that would be allocated to a specific team. And if that specific team requires additional requirements, they will be more than able to manoeuvre that requirement through our prioritisation architecture within the AFP.
And Senator, I mean, I'm sure you would understand that counter-terrorism is, as much as we try to plan and predict, can be quite unpredictable in terms of incidents and events, which we try and factor in as best as we can in terms of budget submissions and then how we allocate that budget. But when the Deputy Commissioner talks about being able to surge in, that really is a strength of how we operate within the AFP, that we can surge to where the highest priorities are. And indeed, as has been said many times, countering terrorism is one of, if not the highest priority.
So, and I appreciate that. We are talking about a unique part of a counter-terror effort, which is something we've been planning for 11 years now, and that is the return of these individuals to Australia. They're here, some of them at least are here now, and I'm just seeking to understand what we've provided for to deal with that. I'm finding great difficulty in understanding in any detail what that is that we've planned for by way of provision. But can I understand then what has been agreed with the states? Is there a co-contribution? I know that there has been talk publicly from both premiers of both states that they required resources to assist with this. Is that a matter that's come across your desk, Commissioner or Deputy Commissioner?
Senator, to try and help you, can I ask, are you talking about, which aspect of the returns are you talking about? Are you talking about the ongoing CVE, state-delivered programs? Are you talking about our investigations and prosecutions? Are you talking about them reintegrating into the community?
What parts are you involved in? So your investigations are not, that will happen, that is what you do. In terms of them being here, and there are protective elements, there's, goodness knows, and some of this is unknown because they are before a court, and I accept that. But, so I'm just trying to understand if there is any, because state premiers are talking about it, so there must be some level of knowledge. The Secretary of Home Affairs has talked about this previously as well. Indeed, there was a request we came across yesterday that people weren't aware of from the state of New South Wales for extra resources. I'm not sure if that came to the AFP or to Home Affairs as well, but...
So to provide you some clarity, our role is to investigate and then prosecute where we can, or continue investigating, which I have publicly said we will continue to investigate the women that have returned and have not yet been charged. In terms of them resettling into the community, those programs are predominantly delivered by state and territory governments, and there is an element of Home Affairs that assist with that. But our role, predominantly relates to investigations and/or prosecutions.
Okay, and not the other elements we've talked about. Okay,
correct.
That is very helpful. Thank you. Do you want to?
Yeah, I do want to share the call. Thank you, Senator Duniam. Senator Roberts.
Thank you, Chair. Thank you for appearing today from the Australian Federal Police. Why was the decision made to arrest Victoria Cross recipient Mr Ben Roberts-Smith on the tarmac at the airport in full public?
Senator Roberts.
Good on you.
Senator Roberts. Senator Cash began a similar line of questioning, and the Commissioner delivered a very comprehensive response, which I think will address many of the questions. Maybe Senator Cash could, having been here, could have a look at the question Senator Roberts proposes to ask to see if there's anything additional that hasn't been covered.
Senator Roberts, the other...
I'll just read each question.
Sure. And maybe if they've already been addressed, perhaps you can refer to the statement.
Sure.
Yeah.
Did you ask about it being done in front of his children?
Yes, essentially, it was the reasons for the way the arrest occurred were fully set out in the statement.
Thank you. Had he not offered to present himself to the Australian Federal Police several times earlier to assist them if they wished to arrest him?
That was covered.
Thank you. Just say that was covered. I'm happy with that. Why was the decision made to arrest him in Sydney rather than Brisbane?
That was covered.
You could have arrested... Okay, that's fine. You could have arrested him at the airport. No, that's fine. Did you have a conversation with anyone within the Commonwealth Director of Public Prosecutions about where you intended to effect the arrest? That's before you arrested him?
Senator, I refer to that in my statement as well in relation to why and the reasons.
So you had a conversation?
Sorry, can you ask me?
You had a conversation with the Commonwealth Director of Public Prosecutions?
In relation to what specifically?
Where you intended to effect the arrest?
So those matters are operational matters that were operational decisions.
Did you have a conversation with the Commonwealth Director of Public Prosecutions before arresting him?
Senator, in my statement, I refer to us engaging with stakeholders in relation to that.
Did you have a conversation with the Commonwealth Director of Public Prosecutions about the location in which to arrest him?
Senator Roberts,
yes or no?
The Commissioner has responded to your question.
She hasn't answered my question.
The Commissioner has responded to your question. If you've got another question you want to ask, please ask it.
I think it might be better for the Commissioner to answer.
The Commissioner has responded to your question.
Senator Roberts, maybe a good way forward, if you take a couple of minutes to read that statement, I think you'll find that many of your questions have been addressed. Senator Cash, for example...
This one clearly has not been, Minister.
Yeah, but just in the interest of time, for example, Senator Cash ended up finding that all of the questions she was going to ask were addressed in the statement. It might be a good use of time. Obviously, if there are questions that you have that haven't been addressed already, I'm sure the Commissioner would be happy to answer them.
Okay. Senator Cash advised...
Senator Roberts, can I propose that I go to Senator Pocock for his block, and if there are questions that you still have after reading the statement, that I come back to you?
Sure, that's fine.
Yeah.
Thank you.
Senator Pocock.
Thank you, Chair. Thank you very much for your time this evening. Commissioner, thank you very much again for your words at the last estimates, talking about your plans to prioritise the health and safety of your team. Obviously, a lot has happened in that time. I imagine it's been an incredibly busy and stressful time for everyone in the AFP. And I just wanted to get your reflection on the current sort of morale, but also the health and wellbeing initiatives that have been undertaken to look after AFP members.
Thank you, Senator. That gives me an opportunity to talk about a couple of things that I have driven since I've become the Commissioner, and then I might pass to our Chief Operating Officer. The first thing I want to talk about this afternoon is the way we have gone about restructuring the organisation to ensure that we are fit for purpose and we are operating as efficiently as we can. It was very important to me that the workforce had a full ability to input into a co-design process about how they wanted to see their organisation structured and how that might be able to bring efficiencies and assist them in terms of, their workload and the way that they actually work day to day. So we undertook quite an extensive co-design process over a couple of months. I was extremely pleased at the level of input that we got from the workforce. I undertook a lot of musters, but subsequent to that, we also did a lot of working groups and forums at every level across the organisation. I think we had thousands of lines of input that were provided, and I undertook to read every single one of them, and I did. So we then implemented a new structure early this year, which is something that I'm very proud of because we can say it was designed by the workforce and is a way that, as I said, the workforce has the ability to have a very strong say in what they need and how they need to be structured to operate in terms of what you refer to as a very, very busy period, which we fully anticipate will continue. So that is something that I'm extremely proud of. But I might pass to the Chief Operating Officer to talk a little bit more.
Thank you, Commissioner. Thank you, Senator. I think the Commissioner picks up on a really big focus of what we're trying to do since the last staff survey that we did. Our people want to be heard. They want to be part of decisions. They want to be involved in decision-making and understanding what we're doing and why we're doing it. So that co-design process the Commissioner described was really successful, really well taken up by our organisation. Some of the other initiatives that pick up on that same theme of getting people involved that we've been doing is around our consultative committee. So coming out of our most recent enterprise agreement, we set up a consultative committee. That was one of the APSC common conditions that we adopted in our EA, and the purpose of that really is to bring member representatives, management representatives, the union representatives together in a room to talk about decisions before and informed decisions before we take them, and that's also been well received by the workforce, I'd say. Some of the other initiatives that we've rolled out recently is our serious illness register. So that's off the back of our new health and wellbeing strategy that I've talked about in this committee with you before. But our serious illness register we rolled out as part of our enterprise agreement as well, and that enables employees under the EA to donate sick leave for other members to be able to access that. As at the 31st of March, we'd had almost 10,000 hours donated by 584 employees, over 691 donations there, and employees are able to access that and make application for supporting their own leave where they're having a difficulty. We've had 31 applications made by 21 employees to access that leave. One of the other initiatives we've rolled out, which was in response to feedback we heard as part of our staff survey, was our Wellness in Work Time initiative. Again, that allows staff an opportunity to carve out time in their day where we're allowed. Obviously, it's a high-pressure, very busy environment we've got, but giving them that authority and safety to seek to carve out some time for their own wellness, to do whatever that means to them, if it's going for a walk around the lake or having a yoga session, whatever makes them feel well and have that reset time. Based on the monthly recording time data, since our restructure in March, we've had that Wellness in Work Time initiative utilised by nearly 2,000 members. That's 23% of our workforce. So it's something that they're taking up and hopefully giving that balance to people, because it is a very, very busy workload that we all have. We've also very much in our messaging focused on, we know the environment's getting busier, focused on that need for team leaders and managers to assist with prioritising what we do every day. We know job demands is an issue for people. We've heard that in staff surveys before, so really focused on how we enable our team leaders and our managers to help their members be able to prioritise what's in front of them day to day.
Thank you very much.
Sorry, I forgot to tell you the second thing that I was going to tell you, and it was around that the coup has jogged my memory. I've been very clear since coming in as the Commissioner in terms of what our mission is and what our 5 priorities are, and that I'm empowering the workforce to make decisions around how they prioritise their work and what work they do. Some parts of the business more so than others have more discretion about what work and how we take that work on. I've been very strong in encouraging the workforce to look at partnerships in terms of how we leverage both domestic and international partnerships to achieve, operational disruption outcomes without the AFP, taking on a whole investigation. What are the other options so that we can manage our workload as best as we can. A big part of that messaging has been about empowerment, and I really am, challenging the workforce and our middle management leaders to be making these decisions and giving them, the authority to do that.
Thanks, Commissioner. That sounds really good. Could the staff survey be provided on notice? The results to that?
Yeah, it is published. So the last staff survey we did was February last year, so it is available.
When's the next one?
Our next full census will be done the first quarter of next year, so we do that every second year.
I'll look out for that.
Yep.
I had a few questions on budget. I see in the budget there's been an overall increase of 101 ASL. That's correct?
I'll ask the crew to...
Sure.
Yes.
Or the CFO.
Thank you, Senator. I'll kick off. We'll have our CFO join as well. We did receive an additional $316.6 million in the 2026-27 budget and $465.1 million over 4 years. Since the 2022-23 budget, I mentioned earlier in this hearing, we have grown by 40% in terms of our budget, and there's been an 11.4% increase in our ASL. 21% increase in ASL in the last 5 years. So we do continue to grow year on year. The AFP is currently the largest it's ever been, with a headcount of 8,666.
And so there was an overall increase of 101 ASL in the last budget, or not?
Correct, Senator.
Okay. That's cool. Thank you.
Sure.
I just wanted to make sure I was reading it properly.
No, but if I could just put the numbers on the record, Senator. So for the 26-27 financial year, our average staffing level is forecast to be 8,195. That's compared to 8,094 for the 25-26 financial year. So yes, you are exactly correct.
And looking at the numbers, it seems like national policing has gone backwards, and from what I understand, this is the work linked to counterterrorism, human exploitation, serious organised crime, cybercrime, fraud, corruption, espionage, foreign interference, Commonwealth criminal crime, Commonwealth criminal law. How many positions are leaving national policing?
There's a small reduction in the average staffing level under Outcome 1. We have increases for Outcome 2 and Outcome 3. In some respects, this may just be allocation of some back office functions. It may relate in some cases where we no longer need a particular service, as Ms Van Gup's outlined, and as we've noted previously. We are doing some redirections and surges into different areas. We're seeing increases, obviously, in the Australian Capital Territory Police, as well as our support for the nuclear-powered submarines program.
And so, thank you, Mr Wood, but are any capabilities being lost from national policing, or is it simply just shifting?
Yeah, so just to clarify, Senator, in the budget we've received quite substantial funding, but it is for specific initiatives. So as the CFO just outlined, within ACT policing, which isn't these budget papers, we are getting a big injection. We're getting injections for AUKUS over in the west, and we're getting injections for Western Sydney Airport. So they're our main growth areas in the AFP. We're not losing funding for specific functions per se. However, we do contribute to whole of government savings targets, so we are allocated savings targets year on year. So within the agency, we prioritise resources according to highest harm and highest need, and in line with government priorities to ensure that we're within the budget that is allocated.
So would it be fair to say that there's additional resourcing, but a lot of that's going to things like AUKUS and Western Sydney Airport, but we're actually seeing a reduction in things like national policing because of the efficiency?
Not quite correct. We actually did also get quite significant funding for CT, for example. So
just on national policing, why is that going backwards then?
I
think it's largely the allocation of some of the overheads and some of the sort of back office enabling roles that may no longer be required. I think certainly
and why are they sort of redundant? They're no longer required. Why is that?
Correct. So it may be that we no longer require a certain service, or something may be automated, and we can utilise those people to support other areas. Okay. I think certainly within the budget papers we saw an increase in funding for transnational serious and organised crime, and we saw that increase for the national security investigations.
Maybe just on notice then, could you just let me know where in national policing these savings are coming from?
Sure. I think just again for the record, we are seeing increases in our sworn police numbers. We're seeing increases in our protective service officer numbers, and as I've said, we have had significant increases for those critical budget priorities.
Thank you, Senator Pocock.
Just got one more.
Oh, sorry.
I'll hang around.
Oh. Senator Roberts, did you have any further questions? I'm just coming back to you as I said that I would. Are you satisfied with the Commissioner's statement?
Hang on, Chair.
I can keep going if you want.
Do you want to, if you've got another couple of questions that you
great.
want to, Senator Pocock.
Mr. Lee, I was hoping just to follow up on some questions from, I think it was last estimates, about the incident here in Canberra with the young man who was taken off the bus at gunpoint. As I understand, it was a mistaken identity, but then he was searched, and there was some real sort of questions from people in the community about it. At the time, you said you couldn't discuss it because there was an internal investigation. Has that investigation been completed?
Senator, I might direct that question to our Chief Operating Officer, who sits over the top of our professional standards.
Thank you, Senator. And yes, you're correct. Last session we did confirm that on the 19th of November the AFP's Professional Standards Command commenced an investigation under Part 5 of the AFP Act into that matter. I also advised at the time that on the 21st of November the Ombudsman commenced a no-motion investigation into that same matter. Both of these matters are still ongoing, so there won't be much I can say on that matter.
After 6 months?
In terms of the Ombudsman investigation and the internal investigation, they're at almost final stages, but not quite finalised.
Why does, I mean, this is a fairly confined incident, like it's not a long-running thing. How can that take 6 months? I'm even thinking of the officers involved. Like, that's a long time to have something like this hang over your head.
It's probably quite a short time compared to most of our investigations.
6 months.
We have a very robust investigations capability, Senator, and we do collect evidence thoroughly, and we go through the interviews thoroughly to make sure that any decisions we're making establish findings of fact are based on that evidence.
But how many interviews could you possibly have from an incident like this? A dozen?
So when we do an investigation into an incident like this, you've not only got all the people that were at the incident at the time, but you've got people who were peripherally involved in terms of call-outs, directing where those staff were going to, as well as evidence that we collect in relation to the training they've undertaken, so through our college and other aspects. So it's quite thorough to make sure that when we sit down, we have the full facts in front of us to be able to make an assessment on did our officers do the right thing.
And so has this young man and his family been kept in the loop here, or what's the...
Yes, Senator. We do have a range of support services available to ensure that young person is supported and their family are being kept up to date on the matter. Yes.
And Senator, I might just add, so we've got a professional standards investigation and a known motion investigation running concurrently, which is the first time that has happened. We have had to manage the sequencing of that primarily for the welfare of the officers involved. As you can imagine, it's stressful enough to have a professional standards investigation, let alone a known motion investigation running at the same time. So I can give you assurance that in terms of the welfare of the members involved, that has been at the forefront, and the support for the members involved.
And so what is that support for members who are under a professional standards investigation? I've certainly heard many concerns about lack of communication, sort of the length of time it takes, just this sort of never-ending process. What does support look like?
So, Senator, we have quite a robust support service through our SHIELD capability that we've talked about through this committee before, in terms of accessing psychologists, accessing other support services. That whole wraparound is put around our members when they're subject to investigation, or whether they're the victim as well. And yes, I understand that matters have been raised before. We undertake to continuously learn in terms of improving processes, but there's a very robust support welfare mechanism that's wrapped around members.
And what about
Senator,
support for the family?
The Chief Police Officer might be able to offer a little bit more detail.
Could I just, I think I'm going to get wound up here. Just if you could incorporate what support is being given to the family. I know there was a lot of distress, not just in the family, but in the First Nations community here in Canberra.
Thanks, Senator. I can do. Scott Lee, Deputy Commissioner, Chief Police Officer for the ACT. Firstly, Senator, in relation to the support for our members, obviously when we recently hosted you at the SHIELD Hub and with our welfare officer team, so certainly with that hub that has that specialist support and those dedicated resources, those members continue to provide supports to our members. Our members also have peer support from within their workplaces, as well as support from the executive as well, from the executive team within ACT Policing. So there are a range of supports that are provided to those members, but as you say, also it is a particularly stressful period, and we're extremely cognizant of that in terms of the professional standards investigation and the ongoing Ombudsman own motion investigation. But I can assure you that we are continuing to ensure that we are in contact with those members and there is support to those members. I have a meeting with all of those members myself next week to talk to them about their ongoing health and wellbeing. In terms of the support to the family, there has been a range of supports through our vulnerable persons portfolio and our First Nation liaison officer team to that family, and obviously that has occurred in consultation with other Aboriginal and Torres Strait Islander stakeholders within the ACT as well. So those offers have been made to the family, and we will continue to do that to provide every support that we can to the family, including as we've committed previously to funding that support, so to make sure that we are looking after that young person. The most recent advice that I had was that notwithstanding those offers of support, some of those supports have not been taken up at this stage, but if you wish, just as of today's date, I'm happy to take that on notice and come back to you in writing just to provide you whether that has changed. But certainly we are taking that very seriously to ensure that we're looking after that young person, his family, and also conscious of the broader impact on the First Nations community.
Thank you very much, CPO.
Thank you, Senator Pocock. I understand Senator Roberts has got a couple of follow-up questions from the statement. Senator Roberts.
Thank you, Chair, and thank you for your statement. It's very clear and comprehensive, so thank you. I'm very pleased to see that you're going to investigate the source of the leak to the media, because it's not fair that one of our most decorated warriors is being subjected to a trial by media. We can't hold you responsible for that, so we'd like to see the results of that investigation. So thank you. Did you have a conversation or exchange emails with anyone well, before I get onto that, midway through the second page, you say the reason to arrest the individual in Sydney and not Brisbane was an operational decision. What do you mean by operational decision?
It was based on operational factors. So I said it was an operational decision that was determined after discussing with relevant partners.
So an operational decision in terms of getting the assets in the right place to do the arrest.
I'll pass to Deputy Commissioner McCartney.
Thank you, Senator. If you go to the Commissioner's statement, at the front of the statement, she makes it fairly clear that we need to be careful with our language. This matter is before court, and we're at risk if we talk more about these issues. Yes. We talk more about these issues, we run the risk, and these information is ventilated through this committee. We run the risk of potential and impact on a fair trial. There were a range of operational matters like the Commissioner's discussed, but taking into account that balance and trying to be helpful to the committee, Senator, we're going to err on the side of caution and say those operational matters may be relevant to the court case, so we'll decline on answering that one.
Okay. Senator, we've really tried to provide as much information as we can in the statement. Yeah. To be as helpful as we can, and at the outset, as I said, we understand that of course it's of significant interest to the public, but of course we need to balance that with ensuring that there's a fair trial.
And you've got safety to consider as well.
Sorry, Senator.
You've got safety to consider as well.
Correct.
So I understand. Okay, now I understand what operational decision means. Did you have a conversation or exchange emails with anyone within the Commonwealth Director of Public Prosecutions about where you intended to effect the arrest?
Senator, are you asking me specifically or we, the AFP?
AFP.
Again, I'll pass to Deputy Commissioner McCartney.
So, Senator, division of responsibilities, the role of the Director of Public Prosecutions is to prosecute charges and offences. Once those charges have been affected by operational agencies such as the AFP and OSI did in this case, they were aware of the location being in New South Wales and Sydney. In terms of being aware of the exact location at the airport, I will take that one on notice, Senator, and come back to you.
Thank you. Minister, final question. The Commissioner has clarified some misrepresentations in the media, which is appreciated. Perhaps you could clarify another comment in the media that so far your predecessor government, the Morrison government, and your government have spent supposedly $300 million or more on prosecuting these investigations. So far you've got 2 men charged, I understand, and no one convicted.
Sorry, I missed that last bit, Senator.
No one convicted yet. I don't think anyone's gone to court yet, have they?
There are 2 matters before court currently.
Before the court, yes, but I don't think they've actually started trying them. So this is a question to the Minister. Is this action to justify more funding?
Is what action to justify more?
The arrest of Ben Roberts-Smith. Because
that's a very big statement to make, Senator Roberts.
I'm asking you to clarify this because the Commissioner has done a very good job in clarifying media misrepresentations.
I'm not sure about you, Senator Roberts, but I and our government have full confidence in our police forces to make good decisions and to when they're deciding who to charge and why. And I'd be very concerned if you're suggesting otherwise.
I'm not suggesting the AFP.
Well, we don't interfere with decisions of the AFP as to who they charge and what for. That is an independent decision, as it should be.
Thank you. You've answered my question. Thank you. And I'll just say again, Commissioner, thank you for your summary.
Thank you, Senator.
Thank you, Senator
Thanks,
Roberts.
Chair. And thanks for your indulgence.
Happy to serve, Senator Roberts. Senator Duniam.
Thank you very much. I only have a couple more questions. In the February estimates of this year, we covered off on that reporting, which you were able to correct the record on with regard to the 3-page report from May 2024. And I'm sure you remember that document we're talking about.
I do.
Yes. So just in relation to that and the evidence that was given then around that executive briefing that was prepared around May 2024 regarding critical staffing levels in the AFP's Counter-Terrorism and Special Investigations Command, I wonder whether you can confirm whether a document entitled CTSI, Command Critical Staffing Levels Impact Statement, existed, and indeed who prepared it.
Thank you, Senator. I'll pass to perhaps Assistant Commissioner Nutt.
Thanks, Senator. I can say that the document existed.
And who prepared that document?
It was prepared by the commanders of the Counter-Terrorism Special Investigations Command who work for me.
Okay. How many commanders are we talking about there, sorry?
4 commanders.
4 of them. Who received that document?
I don't know definitively all recipients. I know it went through my office as Assistant Commissioner and I'm potentially speculating here on where it went next.
Sure, so it got to you, but you didn't formally then distribute it to anyone else, it just stopped with you?
My office distributed it to the Deputy Commissioner's office so I personally didn't distribute it.
Senator, I'd like to take that one on notice, please, to give you the
correct information. Senator, it's speculation there.
Yeah.
Of course, no, I don't want you speculating. We all get in trouble when that happens. Okay, so you'll take on notice who received it. So we know at the very least your office received it, and I think you said you personally didn't look at it, but on notice I'd appreciate who received it and indeed what date it was first provided to AFP Senior Executive. I assume that does include that everyone at the table is Senior Executive, yes, including
I'm Senior Executive,
yes.
yes.
Okay. All right. Were there other verbal or written briefings or advice provided to members of the Senior Executive around potential problems in respect of AFP counter-terror and special investigations under resourcing? Was it something that was discussed in other fora beyond the document we've just talked about?
Sorry, Senator, I'm not too sure. I don't quite understand the question.
So, okay, perhaps in the years 2023, 2024 and indeed 25, were there other verbal or written pieces of advice provided to you around problems relating to resourcing in the area you have responsibility for with regard to counter-terrorism and special investigations?
There's a couple of ways I'll look to answer this one, Senator. First of all, resourcing is a matter that is under consideration of the Royal Commission. The Commissioner's already pointed out that we'll be very careful. As I've pointed out, I'm a witness as well, so I don't want to traverse those issues in this forum.
Sure.
What I can say is that that document was in relation to a draft proposed budget as part of the 25-26 budget, and as I mentioned in the February estimates, that one of the conditions relating to that document was around an error of an initial budget allocation, which prompted the production of that document as part of normal budget processes. So it wasn't a document that was created for its own sake. It was actually part of a budget process, and that initial draft figure was an error, and that was corrected after there was the budget allocated to my command was understated, and that was subsequently corrected during the budget processes.
Okay.
And Senator, I think that's useful context to help you better understand the origin of this document. Previous budget processes, we used to ask each command to write an impact statement going into the next budget, internal budget process to assist us making decisions around budget allocation for the coming financial year. So of course you can imagine that every command would put an impact statement in saying we want more money because we're doing more work, and we have changed the process now to make it more enterprise-wide and coming together looking at where are the highest priorities across the organisation. So it's not an individual siloed budget process anymore, it's a much more streamlined enterprise-wide process.
Okay. So Were you a co-signatory to that draft document?
I was not, Senator. I was on other duties at the time.
Right.
Someone was performing my role and processed that document.
Okay. Who was that was performing in the...
Acting Assistant Commissioner Tom Hester from the Counter-Terrorism Command.
Okay. All right. And Ms Van Gerp, had you seen it? Had it been sent to you?
No, Senator, I think we clarified at the last meeting in February that it didn't progress beyond the chain of command where CT sits under, because it was identified that the information within it wasn't factually correct. So that document didn't come to our Enterprise Operations Board, where we do our budget allocations.
Okay, so yes, you said that it did not make its way up to the AFP governance levels, which is you, inter alia. Okay. All right, that's fine. And so just though back to a question you've referred to the Royal Commission, I'm not asking for content of advice or even on just whether there had been other verbal or written advice around potential problems in respect of AFP counter-terrorism and special investigations under resourcing. So are you saying
as the Commissioner mentioned, there were processes in prior years around producing a budget hurt statement as part of normal budget processes, and it would, so without having precise knowledge on what you're saying on particular documents, those processes and documents would have involved discussions around resourcing and operational pressures, commitments, obligations that are being put forward to consider as part of enterprise budgeting processes.
Okay, all right, that's fine. And there was an element of that that's been taken on notice, so that's fine. With regard to the press club address, Commissioner, you gave on the 29th of October last year, was any of the priorities you talked about in your address and resources associated with them funded as a result of reprioritisation, or was it new funding that came to the AFP to support those things you talked about in your address?
Senator, I spoke about a number of things in my address. Is there something in particular?
In broad terms, whether it was about recalibrating what you had as Commissioner in terms of resourcing for the AFP, or it was indeed new resourcing coming to, of any of the elements you talked about?
Sure. Maybe the best way to help you with that question is to go back to what I said earlier in terms of I've issued a new mission statement and 5 new priorities for the organisation, and as part of the internal budget process that we are currently going through, I might get the Chief Operating Officer to just talk about how we are using those 5 priorities to I guess, guide us through that budget allocation process.
Perhaps, maybe it would save time if perhaps on notice I could ask that one,
sure.
And it'll give you a chance to either through the 5 priorities or the address itself, and then see if there was reprioritisation on your funding. That would be
happy to.
Easy enough. Back to that document, this CTSI Command Critical Staffing Levels Impact Statement. Can I ask whether that document warned of national CTSI staffing vacancies of more than 20%, significant superintendent and sergeant level leadership gaps, operational sustainability risks, psychosocial hazards for staff and structural problems created by the regional command model? Do you recall, Mr Nutt?
Before I answer that, Senator, I've just received a message that I will have to correct the record. It was actually Acting Assistant Commissioner Matt Gale, not Tom Hester, that was in the role at the time.
I'm sure he
That'd be
will
very
forgive you
pleased
for
to
misattributing finding that bus and pushing him under it.
Make sure I'm accurate,
he's back out from under the bus. Okay. All right. On that, sorry to make light of that, but thank you for correcting the record. So yes, did you hear my question?
Kindly request it to be read out again.
Yes, sure. So I wondered whether it is correct that the content of the document we're talking about here, the impact statement, warned of national CTSI staffing vacancies of more than 20%, significant superintendent and sergeant level leadership gaps, operational sustainability risks, psychosocial hazards for staff and structural problems created by the regional command model.
Senator, thank you for that. What I will say that those particular topics go closely towards what I would expect the Royal Commission to consider. And given that I'm a witness, I'll respectively say while the Royal Commission's on, I'm unable to provide that detail this time.
So I'm just on this. We were told at the last estimates that this document effectively had no value. It was based on errors around wrong assumptions around budgeting, and it didn't make it to the AFP governance levels. So it evaporated effectively, I think was the term I used last time. How is that relevant to the content of a document which, according to the evidence last time, is somehow now relevant to
and again,
RC?
very difficult on what instructions I've received around what we can and can't talk about. But I can say that resourcing is an issue. This document relates to resourcing, and so I really want to be helpful here because there is an explanation here that we can provide. However, given it's before the Royal Commission, likely, I'm not in a position to go into any detail on that.
Could I invite you to take it on notice?
I'm happy to do that, and we'll get legal advice on what we can reply and all the
Yes.
rest of it. If you're happy with
because
that.
I understand, and I'm not going to ask you to breach any obligations you have there.
Senator, I will just draw you back to some of the early evidence from the Chief Operating Officer, however, in relation to our CT funding and some of that was picked up in the interim report from the Royal Commission also.
Yeah, which addresses some of... I understand that, and that was a point in time, and there have been things done since to address that, and I suppose it's just about trying to understand whether what has been done makes the grade, and it's difficult when the document was not accurate. Okay.
Well, just to clarify that, Senator,
Yes.
the document relates to a budget process and a draft budget number that was proven incorrect.
Yes.
So for the purpose of which it was created, shifted because of the budget figure was reinstated and the budget process continued.
Yeah. Okay. I'm just going to try and get the Chair's attention. Did you want to rotate the call for a minute?
Thank you.
Yeah.
Thank you. Senator Shoebridge.
Thanks, Chair. I'm going to ask a couple of questions that have come out through evidence in the Royal Commission about the connections between the New South Wales Police and the AFP. You probably saw some of that evidence that came out. Part of that was the New South Wales Police telling the Royal Commission that the AFP was using protective security policy framework as a justification for withholding intelligence in joint cases. That was the New South Wales Police version. I'm giving you the opportunity to respond to that evidence that I think we all heard.
Senator, this line of questioning has already occurred this evening from Senator Duniam. I'm happy for Deputy Commissioner McCartney to repeat the reference he made to the PSPF, but my broader response was that these matters are before the Royal Commission, so we're traversing territory that goes to the current hearings before the Royal Commission.
The fact that they're before the Royal Commission is a moot point, because if this is happening now, I don't want to wait until December for the report of the Royal Commission to fix it. There's no judgment that you're prejudicing. There's no civil proceedings that you're prejudicing. And indeed, the Royal Commission made...
There's a Royal Commission the Royal Commission prejudiced.
Well, the Royal Commission is not... It's not sitting there in some abstract court case determining guilt or innocence. It's there trying to help public administration if there's a problem. So I can't understand how you telling us, I assume something consistent with what you'd tell the Royal Commission, in any way harms the Royal Commission's project.
Well, I'm sorry, Senator Shoebridge, but witnesses don't give evidence to, make you happy. They give the appropriate evidence, taking into account, in this instance, the fact that there's an active Royal Commission underway.
Well, the fact of the Royal Commission doesn't change the obligations to provide evidence in response to parliamentary oversight. And And what the New South Wales Police said was quite damning of the AFP. And if it's not true, then please tell us.
Senator, Deputy Commissioner McCartney provided an answer to this question earlier where he spoke about the PSPF, and he also gave some examples of where we have very successfully worked and continue to work with New South Wales Police. There are other witnesses at this table that have also provided examples this evening, and I'm very mindful, I'm not sure if you were in the room earlier when I said this, but we have a witness at the table of the Royal Commission who is currently still sworn in as a witness, and I'm very mindful that we're traversing territory that is before the Royal Commission.
Well, I mean, there is no sub judice or any such principle in relation to Royal Commissions.
Well,
that is simply not.
Senator Shivich, as we discussed earlier today, if you're not satisfied with the answer the Commissioner has given you, the Commissioner has the opportunity to take your question on notice, to then consider whether she wishes to claim a public interest immunity. So if you want to do it that way,
let's do it
that's
that
fine
way.
too.
Let's do it that way.
I'll take that on notice, Senator. Thank you.
What about the situation now for AFP caveats that the AFP is putting on intelligence given to New South Wales Police when it comes to the ability of the New South Wales Police to deny gun licences? Is that a thing? Is that real?
Senator, again, I think I'll just get Mr McCartney to repeat his evidence because the questions you're asking go to responses he's already given in relation to the PSPF.
Well, I think, some of those issues, as the Commissioner has noted, were raised to the Royal Commission, so we do need to be careful in terms of how I couch my answer. But I talked about, and you spoke about the PSPF, and from my experience, it's not set up to prevent the sharing of information. The focus is on the classification of that information and how it's shared across jurisdictions. And in my previous evidence, I give examples where it has worked well in the past. But again, I think you're going to issues that are raised in the context of the Royal Commission, and I think we go back to a previous response, Senator.
Well, whether or not it's raised in the Royal Commission, it's a matter that's relevant to national public safety. If our state police forces are being given information that they would like to use to deny gun licences to people, but because of restrictions the AFP is putting on it, they can't. And I don't want to wait to December to fix that, or whatever it takes after December to fix that. Is that a problem?
These questions and issues have been raised in the context of the Royal Commission, Senator, and I'll go back to my previous response.
This is not the only instance where there's been evidence of significant dysfunction between the Australian Federal Police and the New South Wales Police. The New South Wales Police have been, for a significant period of time, refusing to process proceeds of crime applications from the AFP because they are objecting to the way in which the AFP has been cooperating with them, police force to police force. Is that still an ongoing thing, the New South Wales Police refusing to cooperate with proceeds of crime matters?
Well, I'll take that particular issue on notice, Senator, but...
Well, hang on, sorry. Are the New South Wales Police still refusing to cooperate for proceeds of crimes applications brought for the AFP?
Well, Senator, if I had the answer, I'd give it to you. I'll take it on notice.
How could you not know?
I haven't got that briefing material with me, Senator, but I think I go back in terms of,
Senator Shoebridge, can we allow the witness to respond to your question? You've interrupted multiple times now. Please let the Deputy Commissioner respond.
In terms of how you've couched your question in terms of dysfunction, there are many, many examples of close cooperation with New South Wales Police across all of our crime types that we work very closely with on a daily basis. Many successful operations we could compare to you. But going back to your question, I'll take it on notice.
But, I mean, do you want to explain to the committee why the New South Wales Police have taken that approach? What reason they've given to you previously, you being the AFP?
On what issue, Senator?
For refusing to process proceeds of crimes matters.
I haven't got that information here. I'll take it on notice.
Are there any other instances where the relationship is so dysfunctional that state police forces are refusing to do things for you?
I'll take it on notice, Senator.
And I wouldn't describe the relationships as dysfunctional, Senator. We've given multiple examples this evening of very productive working relationships and very significant operational outcomes we've done in the joint space.
Well, Commissioner, I would have thought as Commissioner it would be a matter of real concern to you if the relationship between the AFP and the largest police force in this country, the New South Wales Police, was such that New South Wales Police were not processing proceeds of crimes applications on behalf of the AFP. And I would have thought you would have made that a priority to make sure it was fixed. And I'm sitting here and you can't even tell me if it's still a thing.
I've just received some information from the head of our proceeds unit. He hasn't heard of that instance either, Senator. So I think, but as a matter of completeness, we'd take it on notice.
Are you aware of concerns that New South Wales Police have on joint drug operations, that they are concerned that the New South Wales Police and the AFP cooperate to the point where drugs are brought to the border? The New South Wales Police, for operational reasons, would like to see the drugs pass the border, go into the hands of the principal dealers so as they could actually start dismantling the networks in Australia. And that is their stated aim, to dismantle the networks in Australia. And their repeated frustration that instead the AFP interdicts the drugs at the border, seizes the drugs, has a photo opportunity at the border, and they miss the opportunity to follow the drugs through and dismantle the networks. Are you aware of that tension that has been repeatedly evidenced between the AFP and the New South Wales Police?
It's an open relationship. It's one that we can discuss these issues. But what I'm aware of is the many successful joint drug operations the AFP and New South Wales has conducted, Senator.
Commissioner, are you aware of that tension between the two police forces?
Senator, what I would say is we do many joint operations with many partners, both domestically and internationally. On occasions, as you would expect, sometimes there are differences that need to be worked through, but ultimately, at the end of the day, the safety of the community is everybody's priority. And again, as I've said, we've given multiple examples this evening of where we've achieved significant outcomes in line with protecting the community.
And if I can add, I can even give a recent example, Senator. Just on the 22nd of May, the multi-agency strike team made up of investigators from AFP, New South Wales Police, working directly with law enforcement partners, ABF, New South Wales Crime Commission, ACIC, AUSTRAC and the ATO, charged a man in relation to multiple plots to import up to 1 tonne of illicit drugs over an 8-month period. That is sustained collaborative effort with New South Wales Police and other partners, effecting an impact to the criminal environment.
I'll go to another matter, which is NAC referrals. Who's probably best for dealing with NAC referrals?
Chief Operating Officer.
Okay. Under ACLI, the AFP, which is the predecessor for NAC, the AFP made 148 referrals over approximately 48 months, and it was a rate of about 3, almost 4 referrals per month. Since the NAC commenced on the 1st of July, in that whole time, the AFP has made only 54 referrals at a rate of about 1.6 per month. Now, that is a, halving of the number of referrals. Now, is this explained by substantial changes inside the AFP so that the conduct has ceased to happen? Is it explained by a different threshold? Or is it explained by some other thing that I'm not aware of?
Senator, as per our answer to question on notice after the February hearing, referrals to ACLI and NAC are not a like-for-like comparison. Their referral rate reflects the number of matters that met the relevant definition, warranting referral to that agency in operation at the time. So referrals to ACLI were undertaken pursuant to Section 19(1) of the Law Enforcement Integrity Commissioner Act. the Leak Act, and all matters assessed to be corruption were required to be notified to ACLI. Referrals to the NAC are pursuant to Section 33(1)(b) of the National Anti-Corruption Commission Act, which mandates Commonwealth Agency to refer an issue to the NAC only when it is deemed serious or systemic. So there is a complete different definition since the establishment of the NAC. The AFP has mandatory referral requirements under the NAC Act, under that Section 33 I've just outlined, where alleged misconduct amounts to serious or systemic corruption, and we refer those matters.
So there, by reason of the NAC being established, the threshold for referral has raised.
The definition changed.
Well, it's a higher threshold. Is that how it's been interpreted? I mean, it does seem on the face of it, if it's got a serious or systemic addition to it, that's put a higher threshold on.
That's correct. But regardless, as you would know, and as we've talked about before, all matters of misconduct and corruption are investigated internally within the AFP. So this is just matters that we're talking about that are referred to the external oversight agency.
Just two final matters. Can you provide on notice the number of those internal referrals from, a good baseline would be from 1 January 2022, that are being assessed, potential corruption referrals that are coming through the AFP? What's the threshold to go to your internal assessment process?
So through our wicked triage, we get all allegations of misconduct, whether they're Category 1 through to Category 4, which is what you're talking about.
Can you provide the numbers of Category 1 through 4 referrals, internal referrals from 1 January 2022 to now, so as we can see if there actually has been a reduction in referrals?
Yes. It is published in our annual report, but yes, I can take that on notice, Senator.
Who is now determining whether or not a matter meets the serious or systemic threshold for a referral to NAC? Who is tasked with doing that?
Our Professional Standards Command makes that assessment and makes the referrals. However, I would say that anyone can make a referral to NAC, but the matters that we receive internally are handled through our Professional Standards Command.
And is that made at what level in the Professional Standards Command?
Our command is headed by a commander.
Yeah, but who makes the final determination? Is it delegated down to junior officers?
I'll take that on notice, Senator, on who signs it off.
Right. And is there some guidance or material produced to help officers assess serious or systemic?
Well, the Act is the ultimate guiding material, but yes, we do have internal guidance. Yes,
can you
we'll
provide copies of that to the committee? Thank you.
Thank you, Senator Shoebridge. We are due to go to dinner. Senator Mackenzie's indicated she's got a short block of questions, 10 or 15 minutes, and then we'll be in a position to release you. And I'm putting to you that we continue until that 10 or 15 minute block is up and we can release you. Yeah, thank you.
Thank you,
Senator
Chair.
Mackenzie.
Thank you, Commissioner. You're apparently the right person to ask my questions to, according to the Secretary of Home Affairs. So I'm not sure whether this was passed on to you by the department, but my question relates to a series of questions around child exploitation. United Kingdom's 2025 national audit on group-based child sexual exploitation found that authorities had failed for decades to systematically collect, record or analyse data on group-based child sexual exploitation as a distinct category of offending, separate from individual offending. As a direct result, the problem went undetected, under-investigated and under-prosecuted for decades. And my question is, does the Australian government currently collect national data that would allow it to distinguish, as a matter of routine crime reporting, between child sexual offences committed by individual offenders and those committed by a coordinated group of offenders committing in concert?
Thank you, Senator. I understand the question. I'll ask Deputy Commissioner Gale to provide
Thank
you
you.
a response.
Thank you, Senator. I would start by highlighting the work of the Australian Centre to Counter Child Exploitation, that is AFP-led. That specifically relates to the online child sexual exploitation. So that particular centre receives all reports for online child sexual exploitation for Australia coming in and triages that. What happens post that, which relates to your question, is we have across the country joint anti-child exploitation teams, and that is a combination of AFP and state and territory police. So where the offending relates to the online environment, AFP are the lead very much. Where it relates to contact offending, which is what you're referring to, Senator, particularly where there may be a child imminently at harm, that is where our state and territory counterparts very much take the lead. Now, in terms of coordination of data and the like, there are a number of forums, Senator, where both the Commonwealth and the state and territories work together to work through the different data. So one particularly is the Australian and New Zealand Child Protection Working Group, which is a combination of state and AFP.
Yeah, thanks. I do appreciate, and on notice I'm happy with the details. I've got a series of questions and a limited time because I know I don't want anyone being hangry during my questioning, including myself, but a criminal offence. But I guess my question goes around the difference between individual offences and offences that are committed by a group in concert. Do we collect data that allows us to make that determination at a national level? Because that is what the UK found was, one of the reasons that the horrific incidences remained unreported, undetected, under-investigated, under-prosecuted for decades. And I'm wanting to ascertain what our status is here in Australia.
So, Senator, no, data isn't collected in terms of whether it's an individual offender versus a network. And the reason I say that is because the way information is received comes in very many different forms. The ACE, if I can give you one example really quickly, because I'm mindful of your time.
Yeah, no, it's your time I'm more worried about.
Operation Arkstone. It was a major operation where it originated from one cyber tip line, report of a cam being possessed. It then evolved through the course of the investigation into a broader network of offenders. So I guess what I'm trying to say to you is it will require an investigation to determine whether or not it's an individual or whether it's a network.
And I appreciate that we don't have data that allows us to do that, though, at the moment, and I'm seeing other officers shaking their head, and you did tell me no, so I'll just move on. Suggest we develop one, but we'll get to that. In 2000 and 2001, New South Wales Police investigated and prosecuted a series of gang rapes in Sydney involving coordinated groups of young men. The perpetrators were Muslim, mostly Lebanese and Pakistanis. 2 cases, the Scaff brothers case and the Khan brothers case being the most prominent. Following those prosecutions and sentencing, was any national monitoring framework established to track whether similar patterns of organised group sexual offending continued or re-emerged?
Senator, if I could just say, for the Commonwealth, our focus is very much on children. Some of those cases, I understand, were adult offending, so that wouldn't be something that, having said that we are intelligence-led, but that is not something that we would have been at the first point in collecting data on.
But we haven't set anything up 25 years later, so I'm assuming it wasn't done at the time either.
I would say, Senator, that across policing in general, we have a myriad of different forums that police come together, both federal police with their state and territory counterparts, whether that's at the commissioner level, the deputy commissioner, specific groups that focus on things to talk about trends and issues happening across the jurisdictions.
Thank you. So if not, on what basis did agencies conclude that ongoing monitoring wasn't necessary? Or that similar patterns of behaviour weren't being found in other jurisdictions?
Senator, we would have to take that one on notice and look at...
Mr Lee?
Yeah, no, thank you, Senator. I think I was just discussing with my colleague. I think it would be best for us to take it on notice. There is, obviously, if I talk about this in an ACT policing context, we have sexual assault and child abuse teams that respond to sexual assault allegations and reports of crime within the ACT. Now, that may well be singular offenders, multiple victims, and as at times the number of victims at the time of an allegation will grow or potentially grow, where we may have multiple offenders involved.
Or gang rapes.
That's right. Involved in specific incidents, and we obviously investigate those matters in terms of those specific reports.
But do you then record it as a gang rape or 8 separate rapes?
No, and that's what I was going to suggest, Senator. Certainly from our perspective, the way we then capture our crime data, it's in relation to each of those specific incidents and single offenders, and obviously then in terms of our ongoing monitoring, then that will occur through our child sex offender, our sexual offender registers. So
thank you.
I think if we took it on notice, though, for you, Senator, because there are national working groups that exist under the ANSPAR framework where these types of issues may well have been discussed, but I think it would be useful. We could come back to you with that detail.
The only substantial English language article asserting that Australia has successfully eliminated organised group-based sexual exploitation following the early 2000s Sydney cases appears to be a July 2025 opinion piece published in an American political magazine written by a US-based commentator whose Australian experience consists of 5 years as a think tank researcher at the Centre of Independent Studies, ending in 2017. And that article is by Helen Andrews, How Australia Stopped Grooming Gangs. It cites no Australian government report, no AFP assessment, no AIC research, and no Child Protection Authority findings. Are there any Australian government documents, law enforcement assessments, or independent research that supports the proposition in this article that this form of offending was effectively eliminated or not?
Senator, we would, not having seen that particular article, if we could take that on notice.
Chair, I'm happy to table the article. Because it is behind a paywall. It's $9, so I've paid it for everybody. And thanks to the Senate, you can all now read it. But on notice, because I know what I've asked you is effectively a research task, effectively claiming that because we prosecuted a number of those perpetrators, that we effectively eliminated this type of behaviour from the Australian community, and yet I can't find Australian documents or government research that would suggest or confirm that. Thank you. The same argument, while arguing that Australia has resolved the problem, references a gang rape of a Sydney teenager in June 25, just weeks before the publication, and quotes Crown Prosecutor Margaret Cunneen as observing that the lessons of a generation ago may have faded. Is the AFP able to advise this committee whether that June 2025 matter involved multiple perpetrators acting in concert, and doesn't not follow that if such an incident occurred, the proposition that the problem was permanently resolved in the early 2000s, actually now that it is resurfaced, requires renewed scrutiny?
Senator, we would have to take that one on notice.
Yep. To your knowledge, has the AFP, through Operation Task Force Argos or any other child exploitation investigation capability, ever investigated a matter in Australia in which multiple adult offenders were found to have coordinated, whether online or in person, to groom, recruit or sexually exploit the same child or group of children?
Senator, yes. Task Force Argos from Queensland Police are embedded within the ACE, and so we work very closely with them on this type of offending. What I would say to you, and if we can take it on notice, we'll provide you more detail, that particularly in the darknet, you will see where through anonymising technology there are often adult males targeting the same victims. That also then can translate into the real world. So, yes.
Thank you. Are these matters then recorded in a way that allows a national level analysis of whether such coordinated offending constitutes a pattern?
Within the ACE, we have an intelligence fusion cell, Senator, and the purpose of that particular team is, as you've indicated, to be able to gather intelligence and coordinate the dissemination of that intelligence nationally and internationally.
Thank you. I'd just like on notice, given the time, whether there is a standard mechanism receiving information from Five Eyes partners around these type of matters, and what it is, and the mechanism, obviously not the detail of any information, but just how the process works. Commissioned by Prime Minister Keir Starmer, the United Kingdom published a major national audit in June 2025, the Casey report, and I note you are nodding, making 12 substantive recommendations on group-based child sexual exploitation, including mandatory ethnicity recording, treating exploitation as a serious organised crime, and launching a national inquiry. The European Union, through Europol, has documented the trafficking of children across borders by organised criminal networks since at least 2011. Has the Australian Government formally reviewed, and the AFP, either the Casey report or the relevant Europol findings, and considered if any of those recommendations are similarly appropriate for Australia in terms of policy or practice?
Senator, again, in the interest of time, because it's a lot of detail in the questions that you've asked.
But you are aware of the Casey report?
Yes, I am.
Have you or your officials read it?
I believe some of them would, yes. Senator, just also you asked another question about our Five Eyes partners and the sharing. So we will have, we'll be able to provide you updates on that as well. There are many mechanisms for sharing intelligence.
Okay, thank you. Well, I'll look forward to getting your answers on notice. Appreciate it. Thanks, Chair.
Thank you for being very concise, Senator McKenzie. That concludes the questions that we have for you this evening. Thank you very much for your time. The committee is going to take a short 10-minute suspension. We are going to be having a look at the program, and our next witnesses should be prepared to come to the table after that. But the committee is going to make a decision about that now.
Okay, so we may resume in 10
We may resume in 10 minutes, but I'll come back and update you if that's not the case.
Thanks.
return with the Australian Security Intelligence Organisation. But before I invite you to make an opening statement, I will just update that the committee has agreed to release the Australian Criminal Intelligence Commission, including the Australian Institute of Criminology, and consider it forewarning that you will get a number of questions on notice from senators. Thank you very much. Mr Gilmore, would you like to make an opening statement?
Opening statement. Thank you, Chair.
Please proceed.
First, I'd like to extend the Director-General's sincere apologies for his absence tonight. As you know from my letter earlier today, the Director-General has unfortunately fallen ill and is unable to participate in this hearing. Second, I seek the Committee's understanding that noting the ongoing Royal Commission and the criminal investigation into the horrific and heartbreaking terrorist attack at Bondi, there are some issues and topics which we will not be in a position to respond to this evening. The Royal Commission is the appropriate place and mechanism to explore certain topics, and we cannot answer questions which risk prejudicing the ongoing criminal investigation or that may preempt the Royal Commission's consideration of certain matters. Of course, to best support the committee, we will seek to answer all questions as completely as possible, and where necessary and appropriate, we will take questions on notice. Thank you, and I welcome the committee's questions.
Thank you, Mr Gilmore. We will proceed to questions and go to Senator McDonald.
Thank you very much, Chair. Good evening. Hello, Mr Gilmore. Wanted to ask you, what is the ASIO's contribution to the Electoral Integrity Assurance Task Force in terms of activity and types of advice provided and on what sort of issues, without asking you about specific details?
Thank you, Senator.
Thank you. Just if you could give me one moment. We are a member of that committee. Just excuse me for a second. I'll need to take the details of all of that on notice, but we are a member of that committee and provide information as required, and I'm happy to provide more detail on notice.
Thank you. I was looking for the kind of activity that you would be providing advice on and the type of advice that you would be providing.
And I now have some notes that I'll refer to. Thank you. My apologies. We work with the Australian Electoral Commission and the Integrity and Assurance Task Force, particularly through the established processes in the federal election. We would draw your attention to the board's advice to the Acting Commissioner in July, which is available on the web page. But we work around the issues of foreign interference in elections and provide advice around that.
Thank you. Are activities by unions, trade associations or other group organisations monitored and considered in ASIO's contribution to the task force?
We would monitor anything that we believe has elements of foreign interference or anything else that is of security relevance and provide that.
So, well, I was going to ask you about foreign businesses or foreign government-owned business investments.
If we believed that we had information that was security relevant, then we would assess that.
Does security include not just physical security but economic security issues as well?
It would be something that we would refer to understand whether it was relevant under our Act and the heads of security that we look at, but if that had impact on the security of the country and we felt that it was aligned, then yes, we would consider that.
Thank you. Does ASIO see a need to expand, upgrade or increase the role of the Electoral Integrity Assurance Task Force and its contribution?
That would be a matter for government, Senator.
Is ASIO aware of foreign interference in overseas jurisdictions that has had an impact on economic policy, specifically in the energy realm?
I would need to take that on notice.
Okay, so my next question was going to be, do you see this type of interference as a concern for ASIO in terms of how it could potentially occur in Australia, and does this form part of your considerations on the task force?
If we saw that foreign interference and the involvement of a foreign government was present, then that would be of interest to us, and we would
provide advice to the task force on that.
I guess I'm interested of the impact of overseas activist campaigns being weaponised by foreign powers to impact economic and investment climate and ultimately electoral outcomes in other jurisdictions, and whether or not that would be a pattern that you're looking for here in Australia.
If we see patterns of behaviour, that would inform the information and the assessments that we make here, and we would be considering that so that we can provide good advice to the task force when we need to.
All right, but on notice, you're going to let me know if you're aware of other jurisdictions' examples?
Yes, Senator. Happy to.
Chair, that's the end of my questions for ASIO. Thank you very much.
Thank you for being so swift, Senator McDonald. Senator Duniam.
Thanks, Chair. If I could thank you for attending, and we send the Director General our best wishes for a speedy recovery. I'm not sure if you heard my questions to the AFP earlier relating to the compilation of the brief of evidence relating to the so-called ISIS brides. And my question was, or questions related to, and I know your role with regard to this is different to other agencies as well, but what role did ASIO have in what the AFP eventually brought together for that brief of evidence?
Thank you, Senator. I think one of your responses from the AFP to that question was clearly around evidence, which is a function of our police services, not ASIO. But we do work very closely with our partners in the joint counter-terrorism teams and over many, many years to understand the threat posed by those Australians who have chosen to travel overseas and to join ISIL. We provided advice on this and other cohorts, both overseas and in Australia, to government, departments, agencies, consistent with our statutory functions and requirements for many years. But I stress we're not the decision maker in that regard. Our role is to provide intelligence and assessments.
And when you say the decision maker, a decision to what?
Well, it would. There are, as I think you'd be aware under legislation, individuals may be referred to ASIO for assessment under various acts, whether that's the Passport Act, the Citizenship Act.
Yes. Okay, well, just on that then, I think the bulk of my questioning was around the Passport Act. We did talk about the Counter-Terror Temporary Exclusion Order Act as well, and it talks about a competent authority. The officers at the table for the AFP said that ASIO would take the lead in making a recommendation or a request to the Minister as the competent authority. Are you saying that's not the case?
No, Senator. ASIO's security assessments, if I begin with the security assessment, a rigorous process. It's an analysis of all the intelligence. Every assessment is undertaken through a thorough and robust process. If we determine a person poses a security risk, we'll recommend against a passport according to the relevant legislative thresholds, and they're clear in legislation. It's not ASIO's role to cancel passports. However, passport applications can be referred to ASIO, as you've said, as the competent authority.
Yes.
And that's under Section 22 of the Passports Act. We would undertake an assessment on the threat that the applicant poses. There are a number of tests that we must meet in that assessment, but for a passport refusal, ASIO suspects on reasonable grounds that if the individual were to hold an Australian travel document, he or she would be likely to engage in conduct that might prejudice the security of Australia or a foreign country, and his or her Australian travel document should be refused in order to prevent him or her from engaging in that conduct. I tonight would not provide detail on ASIO's advice or assessments in relation to any individual.
No, and noting that they are before the courts, so there'd be elements you can't.
And I would also say the Department of Foreign Affairs and Trade is essentially responsible for
administering that act, yes. But I'm just interested, you referenced Section 14(1)(a)(1) might prejudice the security of Australia or a foreign country. Does your work not extend to 2, endanger health or physical safety, 3, might interfere with the rights or freedoms of other persons set out in the International Covenant on Civil and Political Rights, or those?
Our functions extend to the security as in the ASIO Act.
Sure. Okay, well, we will talk to the Department of Foreign Affairs next week and see where that gets us. There's an article that's been published just this evening in the Australian Financial Review entitled "Labor Gag Would Block Bondi Inquiry from Anti-Terror Funding Decision." And are you aware of this article?
I'm not aware of that article.
Okay, I'll quote from it and then I might seek to table it so you have a copy. It's going to be hard for you to talk about it otherwise, and in quoting from it means I'll be able to read it myself so I can know what I'm going to ask you. The article suggests that the Royal Commissioner will be blocked from considering whether Cabinet-directed intelligence agencies to put fewer resources into counter-terror in the years leading up to Bondi, in effect because a public interest immunity claim has been made in relation to elements of that information. Are you aware of any public interest immunity claim having been sought by ASIO with regard to any evidence provided to the Royal Commission?
No, I'm not aware that ASIO has asked for that.
Are you aware, Minister, are you aware of any public interest immunity claim being sought by government relating to evidence around decisions of Cabinet that might relate to resourcing of these agencies?
I'm not aware of that, no.
I'm going to table this document if I can, or seek to, so that, there you are, thank you. Just so, and we might come back to that before we conclude and allow you to review that. It's just been published this evening. Because as I understand it, the laws that we passed earlier in the year were to enable agencies like yours that have certain requirements around the information you hold and risks to various parts of what you do as a result of that, was to enable you to share that with the Royal Commission without being in breach of your duties. But this article suggests that this public interest immunity claim...
I was just going to say the committee tables the article.
Okay. It suggests that that decision to seek a PII claim will undercut the effect of those laws that were passed. So once you've had a chance to review, we might come back to that. I might, while we're doing that, Senator Shoebridge.
Yeah,
thanks.
Senator Shoebridge. Senator Shoebridge.
Thanks, Chair. Thanks for your attendance today, Deputy Director. Ms Gilmore, were you present when the Israeli President Herzog visited the ASIO offices?
I wasn't, Senator.
Okay. Who was present? Which offices did, or which office did President Herzog visit?
I'm happy to take that question. The President did visit the Ben Chifley building in Canberra. Intelligence agencies, including ASIO, do maintain strong and enduring relationships with a range of our foreign partners. The President met with the Director-General of Security and was also briefed by our counter-terrorism teams on their work following the Bondi attack.
Were you there?
I was not.
So, met with the Director-General?
Yes.
And then also, who else?
Some members of our counter-terrorism teams.
Was there anyone else present?
I wasn't there, so I couldn't tell you exactly who was present at any particular time.
Well, I'm asking at any time throughout the currency of the President's visit to the Ben Chifley building.
I'm not aware of the individuals that were present, and neither would I be able to disclose that for matters.
Were there any individuals who were not members of ASIO present, apart from President Herzog and members of President Herzog's entourage?
I'm not aware.
Will you take it on notice?
Yes, I'm happy to take it.
Can you take it on notice if, not to identify the individuals, but to identify the positions of the people who were present?
I'm happy to take that on notice to see what we can provide you with, Senator.
And if there was anybody who wasn't a member of ASIO, to identify them by name and position.
I'm happy to take on notice to see what we can provide.
How long did the meeting go for?
I'm not aware of the exact period of time.
Were there any family members present?
Family members of ASIO?
Family members of ASIO or family members of the President?
I'm not sure. I'm happy to take that on notice.
All right. Do you know if President Herzog brought members of the Israeli security agencies, Mossad, with him?
I understand he had some people with him, but I am not sure who they were employed by. I would need to take that on notice.
I mean, Deputy Director General, I'm sure that ASIO would want to know whether or not members of a foreign intelligence agencies have been invited into your building in Canberra. That would be an essential security step that ASIO would take, I assume, Director General or Deputy?
Senator, I think as the Director General has previously said in this forum, ASIO has relations with many partners, including foreign intelligence agencies. The nature and substance of those engagements are overseen by the Inspector General of Intelligence and Security, powers akin to a Royal Commission, but they're not something that we would discuss in any detail in a forum such as this.
Well, my question is fairly simple. Did President Herzog come to an ASIO building with members of Mossad?
Senator, as I've said, we would not discuss details of our engagements with foreign intelligence partners in this forum.
It was publicly disclosed that President Herzog came to, I think at the invitation of the ASIO Director General, came to ASIO's Canberra offices, the Ben Chifley office. That's a matter of the public record, isn't it, Deputy Director?
It is.
The question I'm asking, in relation to that publicly disclosed visit by President Herzog to ASIO's Canberra offices, did members of Mossad come with President Herzog?
I think Mr Gilmore understands your question and he's answered it a couple of times, and there is information that he's not at liberty to disclose.
Do you agree that ASIO would want to ensure they knew whether or not members of a foreign intelligence agency was visiting the Ben Chifley building in Canberra? You'd want to know that in advance?
Senator, as a matter of security, we would want to know anyone who's visiting the Ben Chifley building. The details, however, of those arrangements would not be something that we would reveal in a public forum.
Israel has been found to have had a backdoor into Australia's battle management software for the ADF. And at considerable public expense, the ADF had to remove Israeli software from the Australian Defence Force's battle management systems. Do you consider in those circumstances Israel to be a security threat to Australia, given that history?
Senator, we have partnerships with many intelligence services around the world. Those arrangements are overseen by the Inspector General of Intelligence and Security, and those arrangements are also, in terms of the partners with whom we engage, are approved by government.
Mossad used Australian passports to organise a kidnapping and an assassination in one of the Gulf states, in gross breach of any of the rules that normally exist between friendly nations. In light of that, do you consider Israel's security agencies to be a risk to the Australian national interest?
Senator, your question goes to security matters, which I would not be prepared to discuss in a forum such as this.
Were there any US officials present at the meeting between President Herzog and the Director General of ASIO in the Ben Chifley building in Canberra?
Senator, I've said that we'd take that on notice and provide you with any information that we can.
What possible purpose could there be for the head of a foreign state, and I've told you some of the history, they put a backdoor into our battle management system, they used Australian passports in a kidnapping and an assassination exercise in a third country in the Gulf states. What possible reason could there be for bringing the head of state of that country in to visit the Director General of our principal national security agency inside their headquarters in our nation's capital? What possible rationale is there for that visit to occur, Deputy Director General?
Senator, I think the question of our arrangements and partnerships with our security partners, both domestically and globally, when they go to the heart of the benefit of the intelligence that we gather to protect Australia and Australians from threat to their security, is something that is classified. It's not something that I'd be prepared to venture to this evening.
This wasn't a security agency. Well, perhaps Mossad was there as well. We may or may not find out. I'm not talking about connections with a security agency. I'm talking about what on earth ASIO was doing, inviting a foreign head of state into ASIO's principal office in the heart of our capital. What was the purpose of it?
Senator, the President was a guest of the Australian government.
Yes, but what on earth was he doing in the headquarters of our national spy agency?
Senator, ASIO maintains relationships with many partners domestically and globally. The nature and the benefit of those relationships is not something I'd be prepared to dwell on or in fact go to in a forum.
This isn't
public.
This isn't Mossad. We're talking about the President, not a member of the security of Israel's security agencies or spy agencies. We're talking about the President of a foreign state, not our country, a foreign state. The public deserves an explanation for why our nation's principal spy agency was inviting a foreign head of state into the headquarters of our spy agencies and giving him a secret briefing.
Senator,
what was the purpose?
Senator Shoebridge, I know you've repeatedly asked that question and Mr Gilmore has repeatedly explained the limit of what he can answer. I mean, you can keep asking the same question, but you'll get the same answer.
Mr Gilmore, you answer by saying you won't disclose arrangements with other security agencies, which is a non-answer to my question. I'm asking you why a foreign head of state?
Who was a guest of the Australian government, Senator?
Is that ASIO policy to invite guests of the Australian government into ASIO headquarters?
ASIO policy in terms of who is invited or not invited doesn't specifically go to individuals.
The senior Chinese government officials are often here as guests of the Australian government. Do they get an invite into ASIO?
Senator, that's not something I'd be prepared to publicly disclose. Who is invited into ASIO, the screening processes for those visits and how those visits are managed.
Which other head of state of any country on the entire planet, apart from President Herzog of Israel, has had an invitation to go to Australia's principal spy agency's office in the capital? Which other head of state?
Senator, I'm unaware of, over the passage of time, which other heads of state may have been invited to visit ASIO headquarters.
Well, so far as you can recall, there has never happened before, has it? So far as you can recall.
In my recollection, Senator, that's correct.
So what was it about President Herzog and the relationship potentially between ASIO and President Herzog that created this extraordinary precedent?
Senator, the President was visiting Australia as a guest of the government. we have strong relationships with intelligence and security agencies globally and partners, which we rely on to keep Australians safe. The detail of the reasoning behind specific invitations is not something I would be prepared to venture to in a public forum.
Was the minister informed about the invitation?
Senator, I'm unaware. I would need to take that on notice.
Are you aware?
No, I'm not aware either.
And if the minister was informed, was the permission asked of the minister, or was it simply for information?
I will take that on notice, Senator.
All right. I can see the chair wants to rotate the call. So.
Yes, thank you, Senator Shoebridge. Senator Roberts.
Thank you, Chair. Thank you for appearing tonight. Another group of ISIS concubines and their children arrived this week.
Sorry, I'm going to take a point of order. That kind of language is just pointlessly, gratuitously offensive, and I'd ask Senator Roberts to review his language and rephrase his question.
And withdraw, please, Senator
Sorry?
Roberts, and please rephrase.
I withdraw concubines. So ISIS terrorist wives, brides, partners. What security screening has been done on them to ensure the safety of Australian citizens, as a group and also individually?
Thank you, Senator. As I said earlier this evening, ASIO has worked over many years to understand the threat posed by those Australians who chose to travel offshore and join ISIL. We've provided advice on this and other cohorts previously, both overseas and in Australia, to government departments and agencies consistent with our statutory functions and requirements for many years.
So, excuse me, you're watching them on the way out while they're over there and on the way back?
ASIO will always be watching to identify threats, and where information comes to our attention that requires action, we will act.
So what sort of, have they been screened individually and as a group? I guess what you're saying is yes.
What I've said, Senator, is that we, on any cohort that travels overseas and people travelling to join ISIL, I think I could characterise this evening as a cohort, has been of interest to ASIO for many years, along with our partners, I must say, including in the JCTTs.
Thank you. Are older children to be screened for security risk? I understand the eldest at the moment is 18 years of age.
Senator, that would be a question, I think, now for the security authorities, the AFP and others.
And I think Senator Roberts will surely understand that there are limits to what ASIO is able to put into the public domain as well.
Yeah, I understand the New South Wales Police, for example, or AFP. Okay. Will ASIO have a role in ensuring national security after these and other returnees arrive and stay in Australia?
Absolutely, Senator. ASIO's function is to protect Australia and Australians from threats to their security, and that means that we will always be looking, and where we need to, we will act.
Thank you. What is all this related, the work related to the return brides, wives, partners, costing and future related costs?
Senator, ASIO receives a baseline allocation from government, as with any department or agency. We have a robust prioritisation and resource allocation process. The details of how those resources are allocated is not something that I could declare in this public forum.
I'm not asking you to declare the detailed operational plans, but I'm asking what would the cost be for these recent women that have come back?
And Senator, I think Mr Gilmore has indicated that the question you're asking goes to the very thing that he's just said that he's not willing to disclose at this forum.
Don't you think the taxpayers have a right to know?
I think the taxpayers would be expecting us to prioritise our resources against the highest threats and to be doing our job, which is what we're doing, Senator.
Do you have enough money to cover it?
Senator, we have allocations from government. We have a prioritisation process. We assess risk and we do our job.
Do you have enough to do your job?
We have the resources allocated by budget. I think the Director-General has been on the public record successive years, but I'm happy if you want specific details that we might be able to offer this evening, we could go there, but we do, Senator.
Thank you. When ASIO provide heightened terrorist risk alert notices to the New South Wales Police Service, is there any expectation or follow-up by ASIO to check if there has been a suitable response from the New South Wales Police?
Senator, I think you may be aware we're members of the joint counter-terrorism teams around the country. That consists of ASIO, AFP and the state and territory police authorities in each state. We share information through those forums, not just those forums, there are many other mechanisms, but we work very closely with our partners in the states and territories.
So you keep tabs on them formally or informally or both?
Sorry, Senator, could you just clarify, you keep tabs on them?
Keep tabs on the New South Wales Police, for example, if you give them advice, you watch to make sure that they implement that advice?
We partner very closely. We have I think it would be reasonable to say, a shared understanding through that habitual relationship that we've built over many, many years with our police partners.
Thank you. Is ASIO concerned to find that the New South Wales Police Service had actually wound back the police presence for Jewish festivals or events shortly before the Bondi atrocity, the murder, even though they had been warned of a heightened risk assessment of terrorist activity?
Senator, I apologise, but that would go to matters being considered by the Royal Commission, and it wouldn't be appropriate for me to comment on those this evening. Needless to say, resourcing decisions for police or for other agencies and departments are decisions made by them, and they're questions that should be directed to them.
Okay. In the process of your relationship, it's a close relationship, I'm concluding. Would you comment if something was less than you expected?
We will always work closely with our partners. Nothing's achieved alone. No truer words in the security and intelligence domain. So we rely on close relationships with our partners to understand and respond to threats to Australia.
I assume it's in both your interests anyway to do that.
It is, Senator.
Yeah. Was ASIO aware of the New South Wales Police Force winding back when you sent out the heightened risk notice?
Senator, that's not a question that I'm able to answer this evening.
Could you take it on notice?
Senator, I think the question really starts to go to some of the questions that the Royal Commission will be exploring, and it would be inappropriate to say anything that might compromise that process.
Okay. Last question was on the Royal Commission, so I don't need to go there now. Thank you very much. Thank you, Chair. And thank you for your accommodation again.
Thank you, Senator Roberts. Senator Dunningham.
Thanks, Chair. So I wonder if you've had a chance to review that document, and just to refresh it, the assertion in this newspaper article written by Paul Karp in the Australian Financial Review is that a government bid to block disclosure of a cabinet decision would apply to Bell, being the Royal Commissioner's deliberations, and not just to whether it could be disclosed. So the document may not be able to be considered. The Commissioner is looking at that. It says that it relates to Mike Burgess, the Director-General's written statements to the Commission containing significant redactions due to the Commonwealth claiming Cabinet confidentiality over his answer about whether Cabinet or the National Security Committee decided or issued a direction in relation to reducing counter-terrorism efforts. So again, I'll ask whether ASIO or a representative of asked for the public interest immunity claim.
That wasn't something that ASIO has asked for. It would be a question you would need to direct to Prime Minister and Cabinet.
What I can tell you, Senator Dunningham, I've just got a bit of advice since you last raised this. All I can say is that the PIO claim was made by the Commonwealth on advice from Prime Minister and Cabinet Department to protect Cabinet process, but of course the Royal Commissioner makes the final decision on all PIO claims.
Indeed.
And as you would know, cabinet confidentiality is not exactly a new concept.
Indeed, but that intersection of royal commissions and these matters, especially when it comes to something at the heart of the Royal Commissioner's deliberations. So just to be clear, that was made by officials from Prime Minister and Cabinet, not the Prime
advice
Minister?
I've received is that the claim was made by the Commonwealth on advice from the Department of Prime Minister and Cabinet.
Okay, so the Commonwealth being...
The Commonwealth.
Officials or the elected...
if there's anything I can add to that, I'll let you know.
Yes, perhaps someone's listening now and will do so. Okay, then just to go as much as we can on matters relating to funding, noting what you've said about the Royal Commission and what it's considering. Back in February, at the last estimates, Mr Burgess made it very clear that ASIO rejects the claim that counter-terror funding was just cut. But I'm just trying to reconcile that evidence from the February estimates with the interim report of the Royal Commission, which talks about counter-terror related funding declining as a proportion of overall funding in the national intelligence community. Are you able to help me understand that in as simple terms possible, as far as ASIO can?
Without stepping into matters before the Royal
Yes.
Commission, I would just say some of those points of data are around the entire intelligence community, and they also speak to proportion, so percentage of
overall.
When the Director General has referred to budget, it will be in relation to ASIO's budget and the prioritisation of that budget, but also the full amount of the budget as opposed to a percentage. So I think they are looking at two different elements of thinking about budget.
Okay, all right. Thank you. I don't think I'm going to be able to ask any of those questions. Just in relation to the operational planning for the return of the so-called ISIS brides, which began in 2015 under what was called at a point in time Operation Kurrajong. What role did ASIO play in that operation? And yes, if you could just outline the role.
Senator, at the risk of repeating myself, we have been looking at anything that might represent a security threat. We do that routinely, both onshore and offshore, individuals and cohorts. We've been doing that for many years and will continue to do that to protect Australians.
Has ASIO ever provided advice on whether the government should return to government-managed repatriations versus self-managed returns when it comes to individuals like the so-called ISIS brides?
Senator, more broadly, ASIO will provide advice and security assessments to government and others routinely. The nature and the detail of that advice is something that I couldn't speak to in a public forum.
Sure. I think Senator Roberts has talked about any of these. I might just go, if I can, to the matter of electric vehicles and a warning Director General Burgess has previously provided around the security risks posed by internet-connected vehicles, including that they can operate as listening or tracking devices. Does ASIO regard Chinese-made EVs used by ministers or members of parliament or senior government officials or as a national security risk, particularly where those individuals may hold sensitive information or deal with sensitive information?
In relation to any vehicle, whether it's connected or not, we would suggest that members of parliament or public servants do not have conversations that contain sensitive or classified information.
Sorry, did you say whether the car's connected or not?
Whether the car is connected or not. Obviously, a connected car may have other vectors to gather that information, but those conversations should only ever happen in places that are set up for classified conversations.
Indeed.
And we would say that people should be conscious of the things that they are discussing in vehicles, knowing that people may be able to get that information.
I think it's a question for another time, but I'd love to know how non-connected cars threaten that. It's very interesting. Yeah, maybe.
It's nothing to do with the drivetrain. Every car is connected now. I don't know why this fixation on electric vehicles. It doesn't matter what's under the bonnet. It does not matter what's under the bonnet. I know there's an ideological issue about it, but that has...
What do you drive? Do you drive? We're almost there, and this is a serious matter.
Chewing up your own time.
Indeed, yeah, well.
He's got
So...
an internet-connected donkey.
I've got a Land Cruiser, actually, which I will never have sensitive conversations in.
Good.
So, yes. So has advice been provided to government officials, the Department of Home Affairs, Department of Finance or the Special Minister of State about, in particular, whether Chinese-made cars, regardless of their drivetrain, should be avoided for procurement and use by members of the cohorts we've already talked about?
ASIO has provided advice about connected vehicles that has been made available at the correct classifications. It doesn't go to particular brands or anything of that, but just about being aware of the risks and making some assessment of that.
Yeah, okay. Look, one other thing I will ask about that you may not be able to talk to, I expect, but there was an article by Sharry Markson published on the 25th of May this year, which talked about intelligence provided to Australia by foreign partners, including the United States and Israel, suggesting that the alleged shooters in the Bondi event tried to reach Afghanistan on foot via Uzbekistan. I mean, is that information that you were aware of?
Senator, that would go to the heart of inquiries by the Royal Commission. Inappropriate to comment while the Royal Commission is afoot.
Thank you. No further questions.
Excellent. Thank you, Senator Dunningham. Senator Shoebridge.
Thank you. I've got a series of questions about ASIO number 2 bill. I'm assuming you were briefed on it and consulted, given the name on the box.
Questioning warrants.
Questioning warrants, yes. Coercive questioning powers, that bill. I think it's officially called the ASIO Amendment Integrity Measures Bill number 2.
Yes.
We know what bill we're talking about?
Yes.
Yes.
Yep. Did ASIO request the removal of the sunset clause?
Senator Shoebridge, is this a bill that's currently before the Senate?
It is.
Can't talk about bills and estimates because it's still alive in the Senate. Standing against standing on this.
I'm just checking.
I think we can.
I'm not sure where it is.
It's definitely it's been reported on. It's not subject.
Oh, it's been reported on.
It's been reported on.
Okay. Yeah.
Yep.
Okay.
Yep.
It's anyway.
Deputy Director.
Hang on.
Did ASIO request the removal of the sunset clause?
We were consulted on it. It wasn't a request made by ASIO.
Did you support the removal of the sunset clause?
Yes.
Why?
We were consulted on whether that would, when I say support, I should correct the record. We were consulted on whether that would be an issue for us. It would not be an issue for us, but equally if those matters are a matter for the Parliament and we will work within the legislation as it is, and I understand that is being debated, and we will work with that whether there is a sunset clause or not.
Did ASIO request the expansion of the definition of material that could be the subject of the coercive questioning powers? The current definition of matters that can be the subject of it are espionage, politically motivated violence, acts of foreign interference, and the bill proposes to include promotion of communal violence and attacks on Australia's defence system.
Yes, Senator, we advocated for the expansion to the heads of security, of which ASIO is responsible.
So that was at ASIO's request?
We advocated for the expansion, Senator.
Did you begin the agitation, or was a bill presented to you and you supported it?
Sorry, Senator, advocated, not agitated. My
Did
apologies.
Did you begin the process? Was it at your request that this process commenced, or were you shown the bill and then supported it?
Senator, I'm unsure of the ordering of how that expansion of powers to ASIO's heads of security was introduced in discussions. So I'm cautious in responding to that question in terms of how that was introduced.
How are attacks on Australia's defence system not already picked up by the existing heads, either any of espionage or obviously politically motivated violence or acts of foreign interference? What are you intending to pick up there that's not already covered?
Senator, our heads of security are pretty clear in the ASIO Act. It is a discrete head of security in the Act. It is not included in those categories or those heads of security that you referred to.
Perhaps you could take on notice and actually, just given the time, provide an answer about what it's intended to cover that's not already picked up by the espionage, politically motivated violence or acts of foreign interference.
Well, it's the remaining heads of security, sabotage, security defence systems.
But an attack on Australia's defence system would ordinarily meet the test of politically motivated violence.
No, Senator, it's a discrete head of security in the ASIO Act. It's discrete and has a purpose in that regard.
Are there examples from your work where you have found the absence of coercive questioning powers means that you've been unable to prevent attacks on Australia's defence system? Has this come about because of experience that you found this gap?
Senator, the security environment that we are confronting at the moment is diverse, dynamic and degrading. We are finding a confluence, as the Director General has spoken to before, of the threats that we are confronting in a counter-terrorism space, ideologically motivated violent extremism is sometimes intersecting with religiously motivated violent extremism. These challenges are coming at Australia in a way that is, I would say, unprecedented.
Well, each of those elements, the ones you've just identified, would be covered by politically motivated violence?
In the counter-terrorism domain. I think in the Director General's threat assessment last year, he spoke about everything, everywhere, all at once. That was in relation to ASIO's responsibilities in the ASIO Act. Our heads and those threats, whether they be in the foreign interference, the sabotage, defence systems, are all responsibilities for ASIO to confront.
But my question was, have you found the absence of this expanded coercive questioning powers has meant you've been unable to prevent attacks on Australia's defence system to date?
Senator, ASIO provided submission to the Parliamentary Joint Committee on Intelligence and Security, which I think put on the record our support for these powers and explained our position.
Well, but could you answer my question, please?
I'll take that on notice if I could, Senator.
All right. What are you intending to cover with coercive questioning powers that cover the promotion of communal violence? What is your understanding of where you want to go with the word promotion? Does it require intention? What is your understanding of how far you want these powers to go?
Sorry, Senator. If you just give me a moment, please. What I would say, Senator, in this regard, Section 17A of the ASIO Act is specifically focused not to limit the right of a person to engage in lawful advocacy or protest or dissent, and that exercise of that right by itself wouldn't be regarded as prejudicial to security and the functions of the organisation.
What do you mean? What conduct do you say the word promotion extends to? Unintentional conduct that may be meant in a neutral way but is taken by others and used by others to generate communal violence. Would that cover your test of promotion?
Peaceful demonstration and dissent is not something that falls within that description, Senator.
Well, public commentary. Well, let's public commentary that's deeply critical of the United States, deeply critical of the United States, deeply critical of President Trump, intended as a political commentary, but then somebody with a completely different set of motivations picks up that language and uses that criticism and then uses that in part as a justification for an attack on the US Embassy, say. Would that criticism of the United States meet your understanding of promotion in those circumstances?
Senator, I won't engage in hypotheticals.
Will you tell me where the boundaries are?
What I would say is Section 17A of the ASIO Act is very clear. It does not limit lawful advocacy or protest or dissent.
So what are you hoping to get? I'm not asking what you're intending not to capture. What additional conduct are you hoping to capture with the use of the word promotion there? In terms of, so it's not engaging in communal violence, it's not acts of communal violence, it's promotion of communal violence. What are you hoping to capture by being given power to do coercive questioning over promotion?
Promoting or advocating for violence in ASIO's remit. When someone motivates towards or moves towards violence,
I understand if it had been advocating, it's a very different word. I understand what advocating is. I don't know what you intend to cover though, what you intend to be able to capture by the use of the word promotion.
Senator, I think the key word is violence, promoting violence, advocating for violence.
What does promotion mean though? It doesn't on its face of it require intent. It doesn't require an active link. What do you understand promotion to require?
Senator, it's an interesting question. What moves towards violence? Our interest will be where the threshold has been met, where the temperature has moved to a point where violence is the means that's been sought.
Well, it doesn't require intent. You say sought. Promotion doesn't require intent. As drafted, it doesn't require the conduct to have been intended to. It's neutral as to whether or not there's any intent. It could be used by somebody for a totally different purpose. I'm asking you, this is one of the key questions that is before, legislators at the moment. The scope of this word promotion. What do you think it means?
I'll draw upon the definition in Section 4 of the ASIO Act, if I may, and that is activities that are directed to promoting violence between different groups of persons in the Australian community so as to endanger the peace, order and good government of Australia. Promotion isn't accidental, I would say. It is directed.
Sorry, what is that defining in the, what's the definition of in Section 4?
Promotion of communal violence.
Is that the proposed definition?
No, it's in the ASIO Act.
Again, I ask you, do you think it requires intentionality? Is that your understanding?
I think there is a difference between criticism that led to violence, but intentionality is certainly something that is important.
Is it a requirement? as you understand it, will that be a requirement?
Senator, I don't understand sorry, I do not have in front of me the materials supporting the bill to respond to that question tonight.
Could you take it on notice?
Take that on notice.
But sitting there with, I mean, you want this for a purpose. Would intent be consistent with the purpose for which ASIO wants these powers, to cover that kind of conduct done with intent, malicious intent? Or are you hoping to cover people who have no malicious intent and where their conduct, where whatever they've done is taken by a third party? Are you hoping to be able to cover that body of activity with your coercive powers?
Senator, the promotion of communal violence is not a new head of security. It has existed in the ASIO Act for many years. Intentionality is an important component of that, and we are not interested by law in lawful advocacy, protest or dissent.
Perhaps I might just go to a final point. I don't know if you're aware of comments that have been made by the Islamophobia envoy. I think actually we had a statement submitted.
His opening statement
was tabled. Yep, the opening statement that's been tabled by the Islamophobia envoy today. And I don't expect you to be following closely tabled documents in the Legal and Constitutional Affairs Committee website. But I will let you know that in that, the Islamophobia envoy talked about the rise of Islamophobic violence linked to online extremist ecosystems and transnational white supremacist ideologies. Do you agree that there is a risk of Islamophobic violence associated with extremist ecosystems, and most specifically here, I suppose, transnational white supremacist ideologies?
Senator, sadly, anti-Semitism and Islamophobia have both featured in parts of Australian society before the conflict in Gaza and the more recent conflict with Iran. Yeah. We are interested in any form of violence that threatens Australia or Australians.
I saw what the Director General, the evidence given in the Royal Commission on anti-Semitism, and I'm sure if I asked you to do that, I'd get an objection from the government about it's covered by the Royal Commission. So we won't go down that path, but I'm asking about Islamophobic violence and the connection with transnational white supremacist ideologies. Do you see a link between transnational white supremacist ideologies and the rise of Islamophobia in Australia?
Senator, there is a confluence of threats in Australia today. As I mentioned so specifically to that question, our environment is dynamic, diverse and degrading. Politically motivated violence is one of our concerns. The national threat level remains at probable, but we are concerned about the temperature and trajectory of our security environment. Grievance is growing, social cohesion is straining, trust in institutions is declining, and intolerance is spreading. Radicalisation is increasingly occurring online, and extremists are increasingly engaging with each other in encrypted chat room groups, as you suggested. ASIO is extremely concerned by the number of young people, particularly young men, who are being radicalised online and mobilising to violence relatively quickly with little to no warning. Espionage and foreign interference are another of our principal security concerns. Based on what ASIO is identifying and investigating, more Australians are being targeted for espionage and foreign interference than ever before. So this is a complex, challenging and changing environment in which Australia is
But you see, Deputy Director General, I was asking you about transnational white supremacist ideologies. Can you please, address my question?
Transnational white supremacist groups are of interest to ASIO, as are anyone else who threatens.
I'm sure there are others. I'm not suggesting there aren't others. I'm asking you about this. What do you see? Is that an increasing threat? Is it static? The evidence from the Islamophobia envoy is that it's increasing, it's rising. Is that consistent with ASIO's assessment?
We are concerned about nationalist and racist violent extremism. We've been warning about that for some time. Some of these groups have international connections, but many do not.
All right. So do you have a strategy to disrupt this transnational ideologies? Where is it? How is it coming into the country? Where is it sourced from? I mean, on my observations, a significant amount of it is sourced from the United States. Is that where you see a significant source of this transnational white supremacist ideologies coming from?
So without specifically talking about that group, amongst all the other threats that ASIO is watching, we will look overseas, we will look in Australia, and where those threats are threatening Australia and there is a need, we will act.
Well,
a good example might be our recent investment in, or the recent investment government's made in our online capabilities. Those types of capabilities will help us to do our job.
what about domestic white supremacist ideologies? I've asked you about transnational. Do you believe they're on the rise as well?
Senator, we're watching closely all groups. Many of them are combining, and where there's a need to act, we will.
Well, I'm asking you specifically about white supremacist ideologies, and you can see multiple evidences of it, you know, with Nazis out the front of the New South Wales Parliament, with hateful comments being made online, talk about, you know, a white Australia and Australia for white man. These statements seem to be in higher circulation. These hateful, appalling statements seem to be in higher circulation. Is ASIO observing that, and are you concerned about it, and are you doing anything about it?
Senator, I think probably an example that I could give you tonight, you may recall the Director General's address at the Lowy Institute, where he specifically called out two groups, HUT and White Australia. You would be aware that aside from that, the Director General has been warning about these threats for some time, and government has recently listed White Australia as a prohibited hate group.
I'm asking you if you see that threat as growing. I mean, it's a pretty simple question. I've been putting it to you in 5 different ways.
We are concerned about the threat, and we are investigating the threat.
Right. Have you undertaken a threat assessment of the risks to Palestinian Australian community in particular? Because, you know, reports to me are that they feel particularly threatened. There are hateful comments being made about them. Some of that is linked to this deeply racist online chatter. Have you looked at the risk to the Palestinian Australian community?
Senator, I won't go to the specifics of who we have or have not undertaken a security or a threat assessment for. However, we are interested in protecting Australia and Australians from threats to their security. That includes all Australians, regardless of.
But not all Australians are at the same level of threat. There are parts of our community that are really feeling under threat at the moment. We know that the Jewish community has expressed that very clearly, but so too has the Palestinian community, the Muslim community, First Nations community. You know, there was a bomb thrown into a First Nations rally in Perth.
We're very aware.
Are you treating the threats to these different communities with a fair share of resources?
Senator, let me assure you that we are impartial in our activities. Where we see a threat to Australia or Australians, all Australians, we will act.
Well, have you undertaken a threat assessment as against the First Nations community here? Because some of the most hateful things you could imagine are being said online.
Senator, as I said earlier, I won't comment specifically on who we may or may not have undertaken threat or security assessments on. What I will assure you of is that we will act impartially to ensure the safety of Australia and Australians.
We see we got a level of quite granular detail from the Director General about the nature of the risk, the threats and the responses to anti-Semitism. And that was put on the record in the Royal Commission. But when I ask you for anything like that in relation to the Palestinian community, the Muslim community, First Nations community, all of which we know are facing heightened risks of threats. Nothing like the same level of detail is provided. How is this?
Senator, I think you referred to information provided to the Royal Commission.
Yes.
That information may have been provided to the Royal Commission in this forum, providing detail of our activities, our priorities, and our operations is not something that I will go to.
Has ASIO received any requests from foreign governments or intelligence partners to monitor individuals in Australia on the basis of their political views on the Israel-Palestine conflict?
Senator, I can't go to I will not go to the detail of our engagements with partners in a public forum.
All right. I know at the time too.
Thank you very much. That concludes the questions that we have for you this evening. We pass on our well wishes to Mr. Burgess. Thank you very much. You were released with our thanks. That concludes today's proceedings. I thank ministers and witnesses for their attendance, as well as Hansard Broadcasting and the Secretariat over the last 4 days. Can I ask a committee member to please move the acceptance document table through there? Thank you, Senator Cox. We have 3 of those. I also remind senators that written questions or notice should be lodged with the Secretariat by 5 p.m. Friday, 5 June 2026. The hearing is adjourned.